Hi, this is Erica Sanders, Chair of the Colorado Real Estate Commission. Today's date is August the 4th, 2026. It is 9:02 a.m. This is a public meeting of the Colorado Real Estate Commission. We will now call this meeting to order. Let's begin by having the Division Director, Waters, perform a roll call.
Erica Sanders,
Here.
Erica Doyle,
Here.
Bernadette Bugarin,
Here.
Tom Patton.
Here.
Autumn Rubal is absent, but you have a quorum.
Thank you. And David, would you like to take a moment to poll the room on CE credits?
Thank you, Commissioner Sanders. Good morning, everyone. I'm launching a poll for any of the current real estate broker licensees that are seeking continuing education credit for today's meeting. Should the meeting last more than 2 hours, we will be able to issue a continuing education course certificate to you for credit for attendance in today's meeting. Attendance will be monitored, so we will look at that, and then within a matter of a couple days after today's meeting, we will get those certificates delivered out to you all directly to the emails that you have registered here at. Should anyone have any issues with the poll or be joining us by way of their telephone, you are more than welcome to deliver an email directly to myself at David, that's D-A-V-I-D, Donnelly, D-O-N as in Nancy, N as in Nancy, E, L as in Larry, L as in Larry, Y, at state.co.us. And we will be able to get that certificate delivered to you that way as well. So with that, I will pass that back. And after a minute or so here, commissioners, I will take the poll down, but you can certainly proceed with the next steps in your meeting. Thank you very much for your time.
Okay. Am I good to continue?
Yes.
All right. Well, can I have a motion to approve the board meeting minutes from the June 2nd, 2026 meeting?
Motion to approve.
Second.
All right. Any
My
discussion?
name, when my name was spelled wrong at the bottom, so if we could just change that, everything else looked good.
All right. So we have a motion to approve the minutes with the change of correcting the spelling of Erica Doyle's name. All right. So let's take a vote. All in favor, say aye.
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 Any opposed? All right, all are in favor, so motion passes to approve the minutes. Next on the agenda, we have the public presentation of issues not on today's meeting agenda.
So commissioners, if any individuals from the public that are in attendance today would like to address the board with any matters that are not on the agenda today, please select the raise hand icon, which you can find in the Zoom platform meeting, and your comments will be limited to 3 minutes here. And David Powell, it looks like you have a comment here, so I have unmuted you, and you should be able to address the board now.
Thank you, commissioners. Can you hear me okay?
Yes, sir.
Okay. I'd like the commission to reconsider the 6 hours for given to or all you can use for your continuing education when you teach classes. I find it hard that I would need to take another ACU class from another member that teaches the exact same slides, that would have the exact same information. We're not supposed to vary too much off of the slides given. We already have to take the train the trainer, which we get no credit for, which I don't have a problem with that. But I'm already got a couple hours of train the trainer. Then I teach the ACU class, and then I got to take it from somebody else when it's the exact same slides. I know I'm a little different. I'm teaching the ACU class 21 times this year in Northern Colorado. times that by 4 hours. I have 84 hours plus the couple hours of train the trainer, and I have to take that from somebody else. I'd like the commission to consider the 6 hours to be moved to 12 hours so that people who take the train the trainer and teach the ACU don't have to take it from somebody else. I am actually one that would like to see the 24 hours get moved to about 48 for the state, not because I want to teach more classes, but I want more education. But I don't think this was thought through very well, or maybe enough time was given to it. And then the other thing too, my license expires this year. So obviously I would not have known about this rule. I would not have taken this in the last 2 years. So I would probably have in the 50 some hours of credit if I was audited this year, but I would fail because I didn't know about this rule until the third year of my license cycle. So that's my request, is that you would consider the 6 hours for speaker or for instructors to be changed to 12 hours, so that I just think that's better. I think that's just a better way to do it. Or I think we need to look at giving credit for train the trainer, because we don't get credit for that. So just my thoughts. I appreciate your time and considering what I have to say. So everybody have a great day. Thank you.
Thank you,
Thank you
David.
so much.
Thank you, David.
Does anyone else have any comments for matters that are not on today's agenda? Commissioners, I'm not seeing any other hands at this time, so we'll pass it back to you.
Okay, thank you, David. Well, next on the agenda is going to be the rulemaking hearing for the proposed new amended and or repealed rules. All right. Well, good morning. I'm Erica Sanders, Chair of the Colorado Real Estate Commission. Could you please take roll call, Director Waters?
Erica Sanders,
Here.
Erica Doyle,
Here.
Bernadette Bugarin,
Here.
Tom Patton,
Here.
Autumn Rubal is absent. You have a quorum.
Thank you. Today is Tuesday, August 4th, 2026. It is now 9:09 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found at Section 24-4103 of the Colorado Revised Statutes to hear oral testimony related to the proposed amendments concerning the rules regarding real estate brokers, referenced in the Code of Colorado Regulations as 4 CCR 725-1. The Real Estate Commission's authority to promulgate rules is set forth in 12-210203 CRS Application for License Rules, 12-210204 CRS Errors and Omission Insurance Required Rules, 12-10-210 CRS Publication of Exam Passing Rate Rules, 12-10-212 CRS Licensing Fees Rules, 12-210 12-10-213 CRS Continuing Education Rules, 12-10-217 CRS Investigation Record Audit Rules, 12-10-218 CRS Affiliated Business Arrangement Rules, 12-10-219 CRS Power to Promulgate Rules, 12-10-220 CRS General Rulemaking Authority referencing Title 24, Article 4 Rules, 12-10-220.5 CRS Radon Disclosure Rules, and 12-10-506 CRS Subdivision Rules. The permanent rulemaking hearing is being conducted pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the Commission will hear testimony in regard to the proposed revision and repeal of rules in Chapter 1, Definitions, Chapter 2, Licensure Requirements, Chapter 3, Licensure Renewal, License Status and Insurance, Chapter 4, Continuing Education Requirement, Chapter 5, Separate Accounts and Accounting, Chapter 6, Practice Standards, Chapter 7, Use of Standard Forms, Chapter 8, Declaratory Orders, and Chapter 9, Commission Review of Initial Decisions and Exceptions. Here with me today are my fellow commissioners, Director Marsha Waters, Deputy Director Sarah Holleran, Senior Advisor Melissa Phipps, Education Communication and Policy Manager David Donnelly, and Irina Groen and Gina Simonson from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable timeframe. Therefore, in addition to considering all of the public comments today, the Commission has an opportunity to review all written materials to make the final decision on the proposed amendments. The public record will close at the end of this hearing. Let's now have Director Waters explain the proposed changes to the Chapter 1 rules.
And actually, commissioners, before we launch into Chapter 1, we wanted to just give a basic overview to everybody on the meeting today about how rulemaking works. So to start off, the rulemaking procedures are set forth in the Administrative Procedures Act. The statute of reference is 24-4103 of the Colorado Revised Statutes. The rules that we're discussing today were filed with the Secretary of State on June 30th, 2026, and that is when the written comment period for the rules started. They were also published in the Colorado Register on July 10th of 2026. As to meet our stakeholder threshold, we held a meeting on July 14th of 2026. There were 133 registrants and we had 64 actual attendees, but we also sent out multiple notifications leading up to that stakeholder hearing and then afterwards about your rulemaking hearing. And those notifications were sent out on July 2nd, the 21st, and the 31st. And we sent them out to more than just the licensee pool based on the numbers. This is our interested party list. So the largest amount to have received these notifications was 67,604 people. Next, David. We also, as part of our feedback and in our engagement, we created a Google form so that people could submit comments through that. The rulemaking notice itself actually said that written comments would come to the division director. I have provided you with the comments that I received individually, along with the ones that were acquired through the Google form. The public comment today will end at today's hearing. I also wanted to just go over what the purpose of administrative rules is for you. So the purpose of administrative rules is to implement, interpret, or prescribe law or policy. Rules establish expectations and standards. Rules do not provide practice guidance. The rules of the Commission apply to the individuals and entities that you regulate or otherwise have jurisdiction over. Rules should not restate the law, nor can they conflict with it. Rules also shouldn't misstate the law. Numerous rules fall into these three categories. Internal processes, like how we process license applications, are generally not intended to be administrative rules. And finally, 24-4103-4B3 of the Colorado Revised Statutes requires that regulations be clearly and simply stated so that the meaning will be understood by any party required to comply with the regulation when practicable. So with that, I will start off with Chapter 1. So Chapter 1 definitions. Based on comments that we received, we would propose to add a sentence immediately beneath the chapter title that says all defined terms are codified in 1210-101, 1210-201 at CREC, 1210-301 at CREC, 1210-401 at CREC of the Colorado Revised Statutes. That pulls the definitions from the statutes into your regulations without restating them. We are proposing to repeal rules 1.3, 1.9, 116, 118, 119, 121, 125, 148, 150, 154, and 158 because those are all definitions found in the statutes. We're proposing to repeal 1.4 because license cycles no longer expire on anniversary dates. We are proposing to delete the sentence in Rule 110 that says, quote, all brokers will eventually be on a calendar year cycle for the license renewal, unquote. Everyone is on a calendar year cycle at this time. With 1.13, the proposed change is to delete the definition of the commission, which is defined in law. We are suggesting that it be replaced with a definition of a complete application, which is defined as a complete and satisfactory application that includes the fee and has the accompanying documentation as required by the laws cited. The modifications to 114 clarify the language of the rule. Based on written comments, we recommend changing apparent to potential. We are proposing to repeal 117, that was the definition of deemed complete, and replace it with the definition of a complete application that would be found in the new 113. The proposed changes to 129 are to actually define what an inactive license is. The current language describes it rather than defining it. We are recommending repealing 131, invalid payment. The existing definition is not a definition. It is more appropriate as a regulation. The proposed addition to 133 is to clarify that the holder of a license is a licensee. The changes to 136 clarify that the definition applies to license duties. 137 changes accumulative to cumulative. 141 changes, quote, an ongoing, unquote, to a. 142 deletes the statement and further described in the management agreement. This is descriptive language. 143 changes pursuant to as set forth in, and deletes a statement when performed on behalf of a consumer. That's part of the definition of a real estate broker in the law. 145 provides a definition of a real estate school rather than references to a section of Title 23. 151 adds a definition of a standard form rather than just referencing the statute that lists the types of standard forms. 152 just adds the word supervision to describe the employing broker's duties. 155 provides a clearer definition of things of value. 156 deletes an example at the end of the definition. 157 deletes the language that establishes the requirements for filing a trade name with the commission. This language is not a definition of the term. We are proposing to repeal 159, which defines a transition period. This is no longer in effect. 161, we're proposing to change must equal a requirement to equality between a definition. And then 162, the proposed changes clean up the language to make it easier to read and understand. And that's all for chapter 1.
Thank you for those explanations, Director Waters. At this time, we will start with the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals, and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you finish your testimony. If you desire to provide testimony, please raise your virtual hand so division staff will know who to call on. David, do you want to double check to see?
As Commissioner Sanders indicated, anyone that would like to address the commission on Chapter 1's changes, please select that raise hand icon from the Zoom platform menu and we can identify you. So if we can give that just a moment, commissioners. However, I'm not seeing any hands.
Okay, thank you. Well, we'll now consider the proposed changes to the Chapter 1 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 1?
Motion to approve the changes in Chapter 1.
Do I have a second?
Second.
So it's moved and seconded. It's moved and seconded that the proposed changes to Chapter 1 be adopted. Any discussion?
I do have discussion.
Okay.
I do have some discussion.
Perfect.
There was a suggestion at one of the stakeholder meetings to have a definition delineating property maintenance versus property management so that property maintenance does not fall under the commission guidance. I think that was the note that I had under there. And Marcia, Can you talk to us just a little bit about that? You'd said something about it was already in the statute. I was pulling that up. Can you tell us if there might be benefit to adding something there or clarifying that under 1.42?
I think one of the challenges that we encounter, particularly with consumers and also practitioners in different areas outside of brokerage, property management can mean maintaining an HOA association. Um, Consumers often call property management maintenance activities. Like, we are only looking at the licensed brokerage duties, which are bringing landlord and tenant together, negotiating the leases. If a property manager chooses to take on maintenance duties and they don't perform them and it's in their agreement, then you would have authority over that because it would be a false misrepresentation. But in general, like, if a broker agrees to mow somebody's yard as part of their license duties and then somebody complains to us because they don't like the way the yard was mowed, that's not in the commission's jurisdiction. So it's kind of, it's something that we deal with on a regular basis. I don't know whether you need a definition of what property maintenance is.
Yeah, I know that they were just asking for clarity so that it helped maybe consumers have some guidance that it was or was not, and practitioners and the division, when something came in, just to be simple and be like, nope, that's not our issue, or it is. I don't know. What is your thought as to moving forward in adding something there or leaving it?
So I don't think most consumers are going to look at the regulations the way the practitioners are. I think that we can work on adding some information, particularly to our website, maybe when they go to file a complaint about we don't deal with property maintenance issues.
Okay,
Yeah.
I would be happy with that. Anybody else have any comments on that?
I actually had a comment on that too. I actually thought it was a good proposition because I think it creates a little clarity as well because there are unlicensed people that do property management, and the way the rule is very vague, it just says property management services. One could think that they require a license in order to conduct property management services such as maintenance. So I think clarity is important there. Now, how we word that and add that, I don't know. But I think that was a very good point, and I think that I personally would like to see some clarity there. It's just so non-licensees that are doing maintenance services aren't being confused with licensees that are doing actual property management services. And they don't think that there's not this idea that you have to have a license to do those services. So I don't know if does anyone have any ideas of how that could be reworded?
Tom, what do you see in your practice?
I mean, property management and property maintenance are two totally different things, I think. And we're only concerned with property, like what Marcia was saying, the leasing, the relationship with the owners. Services, people, like everybody who does maintenance, like a plumber is technically a service, right? I don't know. It seems like we're talking about broadening this where it doesn't really need any more broadening. I don't know if that makes any sense.
Question, would it make sense, and I don't know, my expertise is definitely not in property management. Would it make sense to say under property management, a relationship between a brokerage firm and an owner of a property in which the brokerage firm is designated to provide licensed property management services or something like that? To just clarify the activities of a licensee.
Yeah, I mean, that would be fine.
Marcia, what do you think about that?
Well, so the only problem is that with the management agreements, if they agree to take on additional duties and they don't perform those, that is what pulls them into your jurisdiction, not how well they perform the maintenance duties. So if they agree in the maintenance or in the management agreement that they're going to perform property maintenance the failure to perform that puts them in your jurisdiction. I think you just need to be really careful with how you word it because there is that component to it.
Okay.
Has that been an issue? I mean, the performance of maintenance, I agree, I mean, that's not a licensing issue. If you're not happy with that, then you fire your property manager and find a new one. If you're violating a licensing area, then that's where we get involved. So I don't know. I'm not sure what point I'm trying to make actually, but I think what the issue is people bringing issues in front of the board that are not really license related issues. They're performance, right? Is that essentially what we're talking about?
I think it's the goal is to avoid that happening,
Yeah.
but we field
We don't
those
want to.
for you, and you don't usually see those. We are dealing with those when we are reviewing the complaints that come in.
Okay.
Yeah.
So, theoretically, complaint comes in about a property manager, but the property manager is unlicensed and they're only doing maintenance. They're not doing the licensee items. That would not be addressed by us.
No.
That's what I want to make sure.
And
Okay.
we wouldn't, so if it was clear when we got that complaint in that it was just somebody who's not licensed and they're doing work on the property doesn't require a license, we're not going to investigate that. We're
Okay.
going to let the people know that we don't have jurisdiction.
Okay. Thank you for that clarification. And then the other thing that I just want to bring up, there's a stakeholder that mentioned 1.62. This is going to probably be another one. We lean on you, Tom, just based on your expertise. But 1.62, they wanted to re-add the deleted section that says, I think I probably should read this whole thing. Unlicensed, this is regarding unlicensed on-site manager. It says an unlicensed person who completes pre-printed lease agreements as a scrivener, shows prospective tenants available units, quotes rental prices established by the owner or broker, arranges for maintenance, and or collects monies, including security deposits and rents. That's the definition. Sorry, I'm trying to read. It's very small writing. Unlicensed on-site manager employed by a brokerage firm is either a regularly salaried employee or an independent contractor and is compensated with a salary, but they wanted to add the salary may include rent value or other non-commission income. And I just don't know enough about
Rent
that.
value. I'm not sure what that means.
Yeah.
So the important thing is, based on the license law, is that they're not being paid a commission. A commission means you are a licensed broker, and that's the only person under our framework that can receive a commission. So
Should
for
we
all intents and
say,
purposes, we didn't come up with every type of compensation that somebody could receive. Frankly, the real estate commission doesn't care if they get paid in candy. If they want to do rent rebates to the on-site manager, they can do that. Salary was just kind of the easiest word, I think, for us
okay.
to
So
use for purposes of a definition.
Okay, so just for clarity purposes, maybe we can just add at the end of that last sentence or non-commission income
Yeah. Or other non-commission income.
or other. Yeah. Okay.
Yeah, that sounds fine.
That sounds good.
Okay, so just to kind of cycle back here, the only change, we're not going to make any changes to 1.41, and we are going to make a change to 1.62, and we're going to add, excuse me, we're going to add at the end of that sentence or other non-commission income.
Correct.
Yep, sounds
Okay.
good.
Yeah.
Okay. So, we, I guess, need to clarify our motion, and maybe motion the changes as amended. So can I get a motion to adopt with the amendments?
I motion to adopt with the amendments, or do you want those clarified? The amendments as stated.
Yeah, I think that's good.
Yeah, I'll second that.
Okay. All right. It is moved and second that the proposed changes to Chapter 1 be adopted as amended. Any more discussion?
Nope.
All those in favor, say aye.
Aye.
Any opposed? All right, motion passes. Okay, bear with me here. So now, if Director Waters, can you please provide a brief explanation or summary of the proposed changes to Chapter 2?
So with Chapter 2, we are proposing to change the title of this chapter to License Qualifications, Applications, Audits, and Examinations. The proposed changes to 2.1 delete the statutory language and requirements from the rule. This is an example of the rule in part duplicating the law. We did leave the portion of the rule that clarifies the 72 hours of qualifying education in Section A. In Section B, we clarify the Commission's authority to audit QE classes. Those are qualifying education classes. We removed references to what will be obsolete or incorrect rule references. We also removed the language about the removal of course providers, instructors, and a course from the approved list. The proposed changes to 2.2 include a change to the reference about the national and Colorado parts of the exam to include the terms general portion and state portion, which are terms typically used internally by division staff. We are proposing to delete the language about duly qualified applicants. This has not been an issue previously, and we also question what authority the Commission has to limit who may take the licensing exam, especially when they may not be licensed. With 2.3, we are proposing to delete the language about the law regarding fingerprinting. We are suggesting that you keep the language about what happens when fingerprints fail twice. With 2.5, we're proposing to delete the different license requirements that are enumerated in the Practice Act itself. We are proposing to modify this rule to address the requirements for the employing broker level of licensure. The proposed language clarifies that the employing broker needs to demonstrate the experience and knowledge sufficient to employ and adequately supervise as appropriate to the area of supervision. With 2.6, we are proposing to eliminate the language in the current rule that duplicates the education requirements in the statutes. With 2.8, we are suggesting that this be repealed. We have dealt with the grandfathering in of the employing brokers when the law changed in 2018. The employing broker requirements that are not established in statute have been moved to Rule 2.5. 2.210, we are proposing to delete Section C regarding the temporary employing broker level license. That language is in statute and the language in the rule is inconsistent with the law. 2.11, we are recommending that you substitute the reference in A from Rule 2.3 to the citation in the law. And there is a typographical error in D4 that needs to be fixed that was not part of the filing. We need to remove that from the sentence. 2.12 is the invalid payment rule that was moved from Chapter 1, but the language was modified to be more plain language and easier to understand. 2.13 is moving Rule 3.4 about applicants with prior or pending criminal records to Chapter 2. We have added language in A1G so that indicates status of the case, including deferred, sealed, or expunged cases for clarity. 2.14 would be the existing Rule 3.5 about applicants with past or pending professional disciplinary actions. There is a typo in the statute citation in the proposed rule. It should reference 1210-203-3 CRS. 2.15 would move the language from Rule 3.8 about preliminary advisory opinions. 2.16 would move language from 3.6 over to Chapter 2. We propose to omit the language that the Commission must issue licenses within 10 days of reviewing the fingerprint results. The Code of Regulations is for real estate brokers, not regulating the Commission itself. The Commission is not required by law to issue a license within a set number of days. But for your reference, the division currently processes applications on behalf of the Commission in an average of 1.5 days. 2.17 would be the new 3.7 about license denials. 2.18 would replace 3.11 about license renewals. The language was refined to omit the language representative of the renewal process itself and statutory requirements. Instead, the rule language focuses on clarifying that entity licenses do not have to be renewed, that email notifications will be sent to licensees about expiring licenses, the renewal requirements, including payment of the renewal fee and certification of continuing education completion, and the fingerprinting requirements for those brokers not previously fingerprinted. And 219 explains when a license may be issued or placed on inactive status at the request of the broker. The rule also explains when the commission may place a license on inactive status. And that is it for Chapter 2.
Thank you for those explanations, Director Waters. At this time, we're going to start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identity. Please state your full name and identify the name of the organizations that you're representing, if applicable. Finally, limit your testimony to only the proposed rule amendments and repeals. Do not duplicate testimony. Should the commission or any of its representatives have questions regarding your testimony, we will ask you when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so the division staff will know who to call on.
Thank you, Commissioner Sanders. Once again, if anyone does have any comments on the Chapter 2 modifications, please do select that raise hand icon at this time. I am not seeing any at this time, though, Commissioner Sanders.
Okay. We'll now consider the proposed changes to Chapter 2. Do I have a motion concerning the adoption of the proposed changes to Chapter 2?
Motion to approve the changes in Chapter 2.
Do I have a second?
Second.
Okay. It is moved and seconded. Can we have discussion? Does anyone have comments in regard to Chapter 2? I know I have a couple. Okay, if no other comments, I'll just kind of dive into my own. If I can get it in front of me. I just had a couple quick questions. In regard to 2.1a, Marcia, I was wondering, because that section kind of provided like a little bit of guidance and detail, the section that was deleted. It really just gave the applicant information about the education requirements. And I'm just wondering, where can consumers find that information?
So they can find it in 1210-203-4.
Okay, so it's easy for that to be found still, even.
It's in the statutes, yeah.
Okay.
So I think also part of this, with the rules having so much duplication of statute in them, and that's really not what rules are for, people need to be looking at the laws themselves along with the regulations.
Okay. Okay. And then my next question, this is just more of a, it's not really substantial, but let's see, looking at 2.3, criminal background check requirements, the part that we are deleting, that I thought just kind of gave a summary. We kind of dive into fingerprints, but then there's no explanation. I really personally liked having it start with applicant must submit a set of fingerprints to the Colorado Bureau of Investigation for the purpose of conducting a state and national criminal history record check prior to submitting an application to the division, and then kind of going into the rest. Did anyone else have feelings on that? I know it's really kind of an insignificant thing, but it just gave a brief explanation because there's no mention of fingerprints, and then we just kind of dive into it. So I don't know. I just kind of liked having a brief little summary of what the requirement is.
Yeah, I agree with you on that. What is the reason that we were removing that? Just for simplicity, or because I do like the lead up into that?
It restates the statute.
So we're just eliminating anything for the most part that is restating statute and pointing them
Correct.
to read that themselves?
Correct.
Okay. And I think those were, bear with me, I'm just making sure. That's everything. Oh no, I did have another question. When we go to 218, I had a question on renewal. This just confused me. So it mentions, this is back to fingerprinting. It mentions any broker who has not submitted fingerprints to the Colorado Bureau of Investigation to be used to complete a one-time only criminal history record check must do so prior to renewal of an active license. And I just needed to understand that process because with my understanding, I thought that that happens at licensure. So why would it also happen at renewal?
So it does now happen at licensure, but over 2 decades ago, like prior to 2005, apparently the division would have a set amount of money for fingerprinting, and the division would run out of that money and not everybody would get fingerprinted. This is my understanding of it. So not everybody got fingerprinted. So they started fingerprinting at the time of the renewal in 2005, 2006, and 2007, which still did not catch everybody that had not gone through fingerprinting. So the reason that we have this rule on the books is if we have had somebody that has been on inactive status for over 20 years, they technically could reactivate now and have not had any fingerprints done. And this is designed to catch that so that we are making sure that they go through fingerprinting.
Okay. Thanks for explaining that because I was thoroughly confused there. And then on the inactive status, which is 2.19, I really wanted to see how the commissioners felt about adding language that they also may be put in inactive status if educational requirements aren't met. So that would be, probably a D under, no, a E maybe under 2.19. It is addressed later in a different section, but this is really kind of touching on all of the different things that could put you into inactive status. So I just thought it would be good to add that here.
That's actually a good idea with that one. Um, I would I would go with that. Even though it's repeated somewhere else. Um,
And there's a few instances where that's happening in the rules anyway, so I don't know that it would hurt to reiterate that. And because it's maybe not something that I can't speak to how that was handled in the past, but this is really how it's handled now. And I don't know that the industry is full aware of this, and I know that we want to really push this. So I think it would be great to put that here
So do
in
you want to
addition.
duplicate the language from 48B as an E for that?
Let's see. Yeah, I think so,
Yes,
because
that
I saw it
works.
somewhere else. I have to get to that page. Um, you said it was 4.8.
48B.
Let's see.
And I'll clarify that it's the continuing education audit process.
Let's see. 4.8B. The commission will place. Yep. Yeah, that's it. Or well, B and C. I don't know. Those can be combined somehow.
let's see.
Do it to a continuing education audit.
Yeah.
So we kind of go into the different chapters like when we get to the insurance chapter, it talks about what you have to do to go back to active. So I think it's sufficient if you just kind of identify what causes the inactive status, and then in the different chapters that address insurance and continuing education, it can be more descriptive as far as what they have to do to go back to active status.
Okay. That worked for me. Let me get back to that page. Okay. So, my recommendation would be to add the language in 4B, 4.8B to 2.19E. We would add a E. Yeah. Okay. Does that sound okay with my fellow commissioners?
Yes, absolutely.
Mhm.
Okay.
Yeah, that sounds fine.
Yeah.
So that would be the only change, it sounds like, to that section. And so, yeah, I guess we just we have a motion on the table. We just need to amend that motion. So, do we have a motion to amend that?
I motion to adopt with amendments as stated.
Second,
I'll second.
any discussion? All those in favor?
Aye.
Any opposed? All right, motion passes. And I was in favor too, so I forgot to say that. Okay. Well, thank you for getting through chapter 2. Director Waters, can you please explain the proposed changes to the chapter 3 rules?
So with chapter 3, we are proposing to add requirements to the title of the chapter, so it's insurance requirements. We're proposing to reorganize the chapter to focus solely on insurance-related regulations. To that extent, we recommend the repeal of 3.1, 3.2, 3.3, 3.4, 3.5, 3.6, 3.7, 3.8, 310, 311, 312, 313, 314, and 315. Those are regulations that focus on licensing requirements. In Rule 3.9, we're recommending the addition of, quote, when a claim is paid, unquote, in section C3E to clarify when a deductible is paid. We're also recommending that defense costs are not subject to the deductible amount be added in C3F for clarification. 316 is a proposed new rule to memorialize that the Commission may audit brokers for errors and omissions insurance coverage, and that non-compliant brokers will be placed on inactive status. The rule also establishes that what a broker must do to reactivate a license after being inactivated for not having a current policy of E&O insurance. This is a practice we have long done. We are just putting it into a regulation to put everybody on notice that that is what the Commission does. And that is all for Chapter 3.
Okay. Thank you for that explanation, Director Waters. At this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you're representing, if applicable. Finally, please limit your testimony to only the proposed rule amendment and repeals, and do not duplicate testimony. Should the commission or any other of its representatives have any questions regarding your testimony, we will ask you when you have finished your testimony. If you desire to provide testimony on chapter 3, please raise your virtual hand so division staff will know who to call on.
If any members of the public would like to address the commissioners on chapter 3, please select that raise hand icon at this time. Commissioners, seeing no hands, I'll pass it back to you.
All right, thank you. Well, do I have a motion regarding the adoption of the proposed changes to chapter 3?
Motion to adopt proposed changes in chapter 3.
Do I have a second?
Second.
All right, it's moved in second that the proposed changes to chapter 3 be adopted. Any discussion? Okay, if there's no discussion, I'll just call the question. All those in favor?
I,
Aye. Any opposed? All right. Well, motion passes to adopt changes in rules in chapter 3. All right, thank you. Now let's have Director Waters explain the proposed changes to chapter 4.
Chapter 4 is the continuing education requirement. With 4.1, we're recommending deleting references to anniversary, calendar, and transitional periods. The proposed new language is to clarify that continuing education requirements apply to active license renewals, license activations that were previously renewed on inactive status, and are to reinstate an expired license on active status. 1210-2131A CRS states that a broker applying for renewal of a license must certify to having successfully completed real estate courses in the following schedule. 1, for licenses applying for renewal on a 3-year license, passage with the previous 3 years of the Colorado portion of the exam or completion of a minimum of 24 hours of credit, 12 of which must be the credits developed by the Commission pursuant to 1210-213-2 CRS. This is the annual Commission update course. The language in the statute appears to be very explicit. Complete the 24 hours of CE, 12 of which are the ACU classes, or pass the exam. The language in 4.2 is consistent with this particular section of statute as it allows, or it's inconsistent with this particular section of statute as it allows for 2 additional alternatives that are not included in that section. Continuing education is intended to be timely and assure the reasonable competency and currency of real estate knowledge of licensees, particularly the ACU courses. We're recommending that Rule 4.2 be aligned so that the requirements are consistent with the statute requirements. We are also clarifying that the requirement to complete the ACU by July 1st begins in 2027. We are suggesting deleting the language directly from the statute about the continuing education requirements for original licenses and transition periods. 4.3 proposes changing the reference to the division in Part A and replace it with the Commission. The Commission is responsible for developing the ACU, not the division. In 4.4, we are proposing to change division to Commission in A.5. In B.1, we removed the specific statute language and replaced it with the statute citation. The additional language in 4.5D is to clarify that who must complete the education. We added the word elective in 4.5H. We are proposing to delete the language in K that duplicates statute. It is then replaced by the verbiage from L. 4.6B clarifies that the course approval applications require payment of a fee. This change stems from the passage of House Bill 26-1287, which was the sunset bill. 4.7A deletes an unnecessary to from the first sentence. 4.7D, we recommend adding information about the Commission's ability to request instructional materials and attendance records from each course offering. The new language also explains why course audits are conducted. 4.8 is a new rule to memorialize the Commission's authority to conduct audits of brokers for continuing education compliance. It also establishes when a license will be placed on inactive status and how a license can be reactivated. The authority to inactivate a license for CE noncompliance is a result of changes made by House Bill 26-1287. 4.9 clarifies the continuing education requirements for a broker whose license has been on inactive or expired status for specified periods of time. And those are the only changes proposed for Chapter 4.
All right, thank you, Director Waters. At this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of your organization that you're representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals and do not duplicate testimony. Should the Commission or any of its representatives have questions regarding your testimony, we will ask when you have finished. If you desire to provide testimony on Chapter 4, please raise your virtual hand so division staff know who to call on.
With Chapter 4 today, if any members of the public would like to address the Commission, please select the raise hand icon, and it looks like we do have a hand. I have asked Laura to unmute, please.
Hi, thank you. My name is Laura Witt. I'm with Longmont Consultants, and I'm also an instructor. First, I just want to say thank you. I appreciate the time and effort that has gone into this rulemaking process. My comments are offered in that same spirit with the hope of helping ensure that the transition to the new continuing education framework is as effective and fair as possible. I'm not arguing against continuing education. I think it protects consumers, it strengthens our profession, and it's an essential part of maintaining a real estate license. And I am also not arguing that brokers should wait until the last minute to complete their education. They should not. My concern, though, is about changing a long-standing compliance framework during a period of already significant regulatory transition. For at least a decade, and my understanding is closer to two, the Commission has used its rulemaking authority to implement the continuing education requirements established by the General Assembly. Throughout multiple sunset reviews and legislative reauthorizations, the broker reactivation course and the contracts and closings pathway have remained part of that framework. House Bill 26-1287 directed important changes to continuing education, but I do not understand that it specifically directed the Commission to eliminate those long-standing educational pathways for active brokers. At the same time, the Commission is already implementing one of the most significant continuing education changes in years. Beginning in 2027, the annual Commission update must be completed during the first half of the year. That change alone is going to make sure that in education providers, brokerage firms, and all the thousands of Colorado brokers have to adjust compliance practices that have existed for many years. So I would just like to consider a broker whose license expires at the end of 2026 and who missed the 2025 annual commission update. Under the existing framework, that broker could reasonably believe that they could regain compliance before renewal. Instead, they are going to discover later in the cycle that the annual commission is no longer available and that long-standing reactivation pathway that they expected to rely upon is also no longer available for an active licensee. At that point, there's just no practical opportunity for a licensee to recover before they become inactive or expire. And these consequences are significant. The proposed rules also contemplate limitations on compensation for inactive or expired licensees. So in practical terms, the failure to complete a single 4-hour annual commission update could ultimately result in a broker losing active status and facing consequences far beyond the missed education itself. What I find difficult to reconcile is that the broker reactivation course remains the commission-approved educational pathway for restoring an inactive license status, but it is no longer available for an active broker to remain compliant before reaching inactive status. And I just
Laura?
ask the commission to consider that issue.
Thank you. Do we have any questions? And thank you for your testimony, Laura. Do we have any questions for the speaker, commissioners? I guess my question is, are you stating that there should be continuing education post-July?
Well, it's more, my concern is if a broker is already in a place where they know they are not going to be able to, make up a past annual commission update. Currently, they're able to proactively take the 24-hour broker reactivation course and remain compliant. But it seems that under this new framework, that option is being removed. And so I don't know how brokers are going to navigate that. Are they intending to just wait until they become inactive and then take the broker reactivation course? Because it seems that it's still a remedy. It's just not available proactively at this point, and I don't understand the rationale there.
Laura,
Okay.
thank you for bringing this
Thank you for
up.
clarification.
Yeah, I had this in my notes as well because you're not the first person to bring this up. It also came up in stakeholder. And my question, I'm wondering if Marcia can elaborate a little bit on this, why it would not be available for an active status. How do we protect this option in here?
So we added those two options probably a little over a decade ago. It has not been around for 2 decades. In looking at the language in the statute, it really seems to be specific to do your 24 hours or you pass the exam. So they have an exam option available to them. We looked at also the statistics from our continuing education audits for the past 5 years, and we have audited tens of thousands of people. So when we look at those audit numbers, the broker reactivation course is used maybe 2% of the time that we see with the continuing education audits. The 72 hours of contracts and closings is 0.2%. That's how often that's used. That's a $300 class. The broker reactivation course is a $200 class. These are not well-utilized avenues, and they don't speak to the currency of the education. If you look at the annual commission update course, that focuses on legislative changes. Contracts and closings, 72 hours of that is not going to touch on all of the legislative changes. And our General Assembly has been kind of going fast and furiously in the real estate industry as far as passing laws. That's really what we focused on, as like the statute really lays out 2 different alternatives. You take the 24 hours, and I was not around when they came up with the statute, but I would be inclined to think that you do the 24 hours, and if you don't do it, the punitive aspect is you got to pass the exam then. But the 2 other options are just not utilized very often.
Thanks for that explanation. And I do understand that. And I will say many, many years ago, I took the update course at the beginning of the year. And by later in the year, I lost the certificate. So I had no proof that I took it. And I had to take the 24-hour, 300 and something dollar course, which I did to protect my license, right? I didn't know if I would be audited, but I wanted to make sure I was compliant. So I do see the importance of having something there just in case, even if it's underutilized. Because I personally have experienced that. And since then, I made sure that I never lose a certificate. But what would be, I guess, the harm in allowing that course, especially with the changes? Because I suspect that there's going to be a lot of people that miss the mark of the July. Not that we want to encourage that, but also, I mean, the alternative isn't great. To have to sit through a 24-hour class, missing a 4-hour class is, it's almost punishment itself. So, how can we create a path? I thought that was a good path. How do we create a path for those individuals?
Well, I think in your particular instance, the provider should have reissued your certificate. And if for some reason they couldn't, depending on when in the year you caught
This
it.
was before
time
all the
ago.
technology. This is like, early 2000s.
We're open to suggestions, but I think the concerning thing is just taking 72 hours of contracts and closings is not speaking to the legislative changes. I haven't looked at the course outline for the broker reactivation course in quite a while, but that's for the people that have been inactive for a long time.
And the broker reactivation should probably have like legislative elements, right? Because again, those are people that have been inactive. They are not in the loop on some of those changes. So if those individuals even had that as an option, I think that would be a good thing.
I agree with Erica that we need to have something for just the remedy on that outside of just the exam, because things do just happen, and it is difficult to, instructors are there and then sometimes they're not, and trying to get a hold of them for that. That's just the one example of things that could happen. But, and do we, I mean, for the people that are teaching these classes, don't they come back and you guys reevaluate their course material every so often and approve it? So you could set out new standards for what needs to go back in there to update those?
I'm going to defer to David because his team does the education.
Commissioner Doyle, could you restate that question? I just didn't quite understand it.
Absolutely. So it seems like the issue may be that the concern is that these classes, if we left them in, are not necessarily addressing what the division wants them to address moving forward. So is that something that could be, we leave these courses in so that they are available for the one-offs when they're necessary, but that the next time they come up for approval, we're just making sure that the content that's in them is more applicable to what the division is wanting in those courses?
Thank you. So pursuant to the regulations that we are looking at here today, the commission does in fact update or have the authority to update the outlines for continuing education courses, such as closings, such as legal issues, and that also includes the broker reactivation course outline. However, these are what we refer to as qualifying education courses. So they are not expressly approved by the commission. They are approved by our another state agency, the DPOS, which is part of the Department of Education. So we don't have direct oversight over the course approval, only the outlines for those courses. So that is certainly information that we can present to the commission, these outlines for re-review. Some of these outlines, candidly, have not been really updated in any significant manner for a long time. Others have been touched upon by predecessor commissions in more recent years. So that is certainly something that we could bring to you all for review in the future if that would be of benefit to you all.
If that might be something that would be amenable, I would be open to leaving those in as long as we were recommending some updates. I don't know. That's a potential. Erica, what are your thoughts on some of that?
Yeah, I agree. I mean, I think we yeah, I think it's important to have that in there. And it sounds like because we can, so you mentioned, David, that we have some say in the outline, which, I mean, in that outline, I know that that there's a process to have it approved, but in that outline, you could specify some of those legalities in there. Am I understanding that?
I think so, yes. We certainly could include aspects of these current legal changes, for instance, as part of that process. That would be something that we could include in those. Again, because the specific material presented is not approved by the commission, it's not reviewed by the division. In ensuring that we communicate in any changes to outlines over to the DPOS, which is the Division of Professional Occupational Schools, DPOS, yes, and too many acronyms. We could certainly convey that information over to our sister agency.
Yeah, I think that's important anyway. I mean, that broker, what is it, re-administration course or something like that. I mean, it's important that information's in there either way. So I would move to keep that alternative process in place.
Both of them?
Because I could just see this being a nightmare, especially next year and in future years. And the fact that it's underutilized is not a bad thing. I think it's great to have that in the event it's needed. It looks like we have a hand, Laura, again. I don't know. Can we let her comment?
Yes. Laura, you are looks like you are already unmuted, so you can address the commissioners.
Thank you. Yeah, no, I just wanted to, I believe, and I could be incorrect, but I know when I've interacted with the 24-hour broker reactivation, it does include the current ACU as part of those 24 hours. So I just wanted to remind folks of that in case that's not something everyone was aware of.
Thank you, Laura. Okay, so I know myself and Erica have commented. Tom, did you have any thoughts on this? And Bernadette, did you have any thoughts on this?
I don't have anything to add, no.
I know Erica and I are really proposing to kind of keep that language. Did you have any feelings in regard to that specifically?
No, I would be in agreement with what you guys are proposing.
Okay. And then Bernadette, did you have any thoughts on this?
Sorry. I don't think it's a bad idea to keep it there, especially if it's going to create something that we could potentially be seeing when audits come up and they've missed that. So I'd be in agreement to keep it. So I would agree with you too.
Okay,
Okay.
to be clear, you want to keep the two options. We wouldn't be keeping the same language because the same
Right.
language is going to be referencing rules that have changed.
Yeah, I
You want to
noticed
keep the
that.
24-hour broker activation course and the 72 hours of contracts and closings.
Correct.
Yes.
Mhm.
Okay. And since that's being noted, I guess we can, if there's any other discussion regarding chapter 4 from
We're
commissioners.
taking public comment. Was there anybody else that had public comment on this?
Thank you, Commissioner Doyle. There are no other hands. However, if anyone does have additional comments, please raise that hand icon at the current time. No hands at this time, Commissioners.
Okay, so we have a motion on the table to accept the rule as proposed. However, we have some amendments to the rule. So can we get a motion to adopt this as amended?
I motion to adopt with amendments as stated.
I second that.
Perfect. Let's call the question. All in favor, say aye.
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 Any opposed? Okay, so motion passes as amended. All right, thank you. And at this point, Director Waters, will you please explain the proposed changes to Chapter 5?
So Chapter 5 is separate accounts and accounting. In 5.8a, we are recommending eliminating the permissive language of will not and changing it to prohibited from. We also use plain language for the sentence about providing the tenant with the owner's name and address. We are recommending the repeal of 511, which define the requirements for brokers accepting money from others for non-licensed duties. The commission no longer has that authority as a result of House Bill 26-1287. We are recommending the repeal of 521 as it is duplicative of the requirements set forth in Rule 625. And that is it for Chapter 5.
Okay, thank you very much for that explanation, Director Waters. At this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you're representing if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you have finished. If you desire to provide testimony on Chapter 5, please raise your virtual hand so division staff will know who to call on.
Any members of the public at this time, please raise your hand in the Zoom platform menu, and we can identify you. Seeing no hands, Commissioner Sanders?
Okay, thank you. We will now consider the proposed changes to the Chapter 5 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 5?
Motion to approve changes in Chapter 5.
Great,
Second.
do I have a second? Thank you. Okay, it's moved and seconded. Any discussion? I have a little discussion only because a stakeholder brought it up, and I just want to acknowledge the comment. Stakeholder brought up on 5.8B that they thought it should change to 60 days, or they wanted to change the 60 days, which I believe that's statutory. Maybe you can clarify, Marcia.
I believe so.
And so I just wanted to acknowledge that. And let me see what other comments. The other comment here, we actually addressed it in Chapter 1, but I think the comment maybe came here to add the definition of property management versus property maintenance, which we've already dealt with that. So I don't think we need to touch it, but I just had a note that that comment was in Chapter 5. And yeah, that's it. So I think the security deposit within 60 days is more than reasonable. I don't really see a need to make any adjustments there. Does anyone else want to comment on that? I don't know if you saw that comment in the stakeholder meeting.
No comments.
Okay.
Yeah, I think it's good.
All right, perfect. Well, we'll go ahead and call the question. All those in favor?
Aye.
Any opposed? All right, motion passes to accept the proposed changes of Chapter 5. And Marcia, Director Waters, I'm sorry, can you please explain the proposed changes to Chapter 6?
Chapter 6 is practice standards. We are recommending that you repeal Section E of 6.1 because it duplicates the law. The proposed changes to 6.3A reorganizes the language for ease of reading. The changes to 6.3C set forth the reasonable supervision requirements in active voice and eliminate guidance within the rule about how to supervise. Regulations set forth expectations, and position statements are designed to provide guidance. Individual employing brokers need to determine how best to manage their brokers. In D.6, we're suggesting adding during closings for clarification. In Section E, we are suggesting deleting references to delegations or supervisory brokers, since the delegation of supervision is addressed in Section F. The changes to Section F clarify that the supervisory broker must have the skills and knowledge necessary to supervise other brokers. We've added plain language written in the active tense to start subpart 1. In subpart 2, we clarified that the employing broker must also sign the delegation of authority. In subpart 3, we have revised the language so that it is plain and active voice. In subpart 4, we have changed the language to be more definitive and clearer. Based on the comments received, we recommend modifying 6.3A1 to eliminate the sentence, "The employing broker is responsible for ensuring that associate brokers comply with the relevant laws and regulations." In 6.3F1, we recommend changing the sentence to state, "The supervisory broker bears the same supervision responsibilities as an employing broker when discharging the duties delegated by the employing broker." And that was also based on comments. In 6.4B, in subpart 3, we have changed pursuant to as required by, that's plain language. In subpart 4, rather than restating the statutes, we have provided the statute citations. In subpart 5, we have changed the sentence to identifies how conflicts of interest will be managed rather than providing practice guidance. Again, rules are to establish expectations, not to provide practice guidance. In 6.5, the language in Part A was changed to active voice. In Subpart B, we changed price range, which could be considered confidential information under the Brokerage Practice Act, to consumer desires and interests. However, based on feedback from the stakeholder meeting, we would suggest changing consumer desires and interests to market conditions or property prices. In 6.6, Part A was revised due to the passage of House Bill 26-1426. Brokers must have a written agreement with a consumer prior to performing any license duties. The legislative change is significant because brokers can no longer provide broker services as a transaction broker without a written agreement, also known as a listing contract. In Part C, we added a sentence to clarify that either a new listing contract or extend must be executed to add or remove designated brokers. Both the designated broker and the consumer would need to be fully aware of the change and obligations. However, based on feedback from the stakeholder meeting, we are recommending changing C to indicate the employing broker or supervisory broker must provide written notice to the client when there is an addition or substitution made to the designated broker. 6.7, with this rule, we've added sides or side in the body of the rule and parts B and C to delineate the different principles in a transaction. The proposed changes to 6.8 provide clarifying language and include the more recently defined term of client. In 6.9, we are again updating the rule with the more recently defined term as more appropriate. We are also clarifying which contract is being signed. The changes to 6.10 include deleting the statutory language from the rule and cleaning up some of the language to make it more definite rather than permissive, and also reorganizing the content. We changed Part G to indicate that the owner determines the price of the property for which it's advertised. That is consistent with the license law. We are recommending deleting the reference to a multiple listing service in 6.11. The term advertisement seems sufficient. In Rule 614, Part B, we've added clarifying language about what types of legal documents brokers cannot charge a fee for preparing. The clarifying language is consistent with the summary of the Conway-Bogue case that John Gorsuch completed. You can find that in Chapter 10 of the Real Estate Manuals on pages 10-2 and 10-3. From Part C, we deleted the language about listing contracts being in writing. That is addressed in the law pursuant to House Bill 26-1426. In Part E, we've added some clarifying information about title and potential objections. In Part F, we've changed the section to indicate legal documents rather than deeds and made the language more definite. With 615, we modified the language to be more prohibitive. 618, the affiliated business arrangement disclosure requirements were amended in House Bill 26-1287, and the rule has been modified to reflect the changes, and the remainder of the rule has been reorganized. 619 adds the term client in Part A. The term standard form is added in Part B for clarification. We are suggesting changing the first sentence of Part C so that it is in active voice. In 621, in Parts A and B, we are recommending that will be changed to must. It's less permissive. The existing Part C misstates the statute. We've cleaned that up with the language to remove the misstatement of the law and to make it easier to understand. We are proposing to revise 622 to add clarifying language and remove the passive voice. Based on the comments received regarding 6.22.b, we recommend ending the sentence after performed and deleting, quote, comma, cause the title to a property to become clouded or to interfere with the transfer of title, end quote. With 626, we're recommending the addition of the term client to A4, B3, B6, and C6. And that is it for Chapter 6.
Thank you very much for those explanations. Before I go further, I just wanted to see if you could repeat some of the changes. I got some of them, but before we have, public testimony, let's just make sure we understand some of the proposed changes that we didn't have on our end. So the first one, I missed the first one. Was it at 6.3 that
So
you
the
said?
first one is 6.1, and we are
6.1.
proposing to repeal E because it duplicates the law.
And I'm referring to the changes that you've made on the actual proposed rules that we didn't have. You just mentioned a couple of them. For example, you mentioned on B, on 6.5B, you mentioned that you're now recommending that says instead of price range, market conditions and property prices. So I'm referring to those. There was like three of them.
So we've got some that we are suggesting modifications on the proposed language based on comments that we received. So the
That's what
first
I'm asking for.
was 6.3A1. Which we had in there that they are responsible for ensuring that associate brokers comply with relevant laws and regulations. We're proposing that you just delete that proposed sentence, that one sentence. And then 6.3F1. That one says the supervisory broker is responsible for ensuring that associate brokers comply with the relevant laws and regulations. We would strike that sentence and replace it with the supervisory broker bears the same supervision responsibilities as an employing broker when discharging the duties delegated by the employing broker.
Okay, and then the last one was the one that I read.
So there's two more actually. There's 6.5B, which the concern is just saying with the existing language, the price range, that can lead you down the path of having a consumer discuss confidential information when you haven't established a brokerage relationship. So changing the price range, rather than the proposed language that was in the rule, the consumer desires or interests, we would change that to actually market conditions or property prices. So you're discussing general market data.
Okay.
And then the last one is 6.6.
Can you say, I'm sorry, can you say that again? So we're changing consumer desires or interests to what?
Market conditions or property prices.
Thank you so much.
And then 6.6 with C, instead of the language, the sentence there that says a new listing contract or a listing contract amend extend must be executed to add or remove designated brokers, we would change that to indicate that the employing broker or supervisory broker must provide written notice to the client when there is an addition or substitution made to the designated broker. There's one more for this chapter.
6.6C now?
Yes.
Yeah.
And the, let's see here, I'm sorry. Can you read that again in its entirety?
So the new proposed language would get rid of what is redlined in 6.6C and substitute it with the employing broker or supervisory broker must provide written notice to the client when there is an addition or substitution made to the designated broker. And then there's one last comment that we incorporated, which is in 6.22 or 622.
Oh, 22.
It's in B.
Okay. Oh, wait. Okay, B,
So we've got the redlined performed part. We would just end the sentence at that point and delete cause the title to a property to become clouded or interfere with the transfer of title.
Okay. Okay. Thank you. I really appreciate you revisiting that and reading those again, just for us and for the stakeholders. And at this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask you when you have finished your testimony. If you desire to provide testimony specifically on Chapter 6, please raise your virtual hand so division staff will know who to call on.
Thank you, commissioners. It looks like we have 2 hands at this time. Patricia, I've asked you to unmute.
Hi, thank you. So my name is Patricia Elizabeth Hutchison. I work for Mission Rock Residential. And I don't want to have the risk of being duplicitous, so I want to just confirm something real quickly with you, Marcia, if you don't mind. The area of concern for our company, given that we have almost 9,000 units throughout Colorado, and we have several lease renewals that have happen on a at least on a 12 or to 13-month basis, sometimes less than that. This really puts an inordinate amount of burden if this says what I kind of define it, or I see that it's defined, that the employing broker should contact the associate. Excuse me, I'm sorry. So every executed the broker, the employing broker or associate needs to execute every contract and every transaction file. Is that correct?
I think are you referencing the requirement for the employing broker to review every transaction file and every contract, maybe?
Yes. Does that mean that they need to execute it as well?
So the employing broker doesn't have to execute every contract if there's a broker that's executed it. It's been a longstanding requirement that employing brokers review transaction files, including contracts, although that is something that an employing broker can delegate through a delegation of authority. So the supervision requirements themselves have not changed.
Okay. Yeah, because our feeling is that we look at it and then we review it, but if we had to go back in and ensure that it would, to execute it, or even that would be put an inordinate amount of strain on our organization. So I'm gonna just say that there's no change from last year's, except for that the employing broker, as always, is responsible for the delegated broker and all of the executed documents. Does that get the spirit of it, Marcia?
Yes, that has not changed.
Okay. All right. Thank you very much.
Thank you very much, Patricia. Does any of the commissioners have any questions for her?
No, thank you.
Okay. Is there anyone else, David?
Yes. Bill, I have asked you to unmute if you can.
Thank you. Good morning, commissioners. My name is Bill Ogile. I am a lawyer here in Denver at the Snell and Wilmer law firm, and I am representing apartment managers, consultants whose CEO, Brenda Barrett, submitted comments on behalf of that organization, which manages about 20,000 units in Colorado. 2 of the comments that we made specifically dealt with the issue that the last commenter and Ms. Waters discussed, so I will not repeat those. We do ask that the commission keep in mind that there are differing models of of apartment brokers, managers within the state, companies like AMC, companies like the prior speaker's company manage thousands of units, and they rely on the ability to create compliance programs based on reasonable delegations of authority and under the supervision of the employed broker. There are two issues that I don't know specifically which part of the rules that they would apply to, but I'll just give them now. There should be, once these rules go into effect, the commission should allow a reasonable time period for especially larger firms like AMC to create processes and policy manuals to build their systems in order to implement these, any restructuring that might be needed. And then also the issue, I'm sorry, final issue would be that there should be at least a review period that would allow for when a apartment complex may switch apartment managers. There is a transition period that's needed to transition files from one management company to the other, and to then look at those files and ensure compliance. The rules should allow for some period of reasonable transition between apartment managers. And I'll be happy to answer any questions the commission may have.
Thank you for your testimony, Bill. Does the commission have any questions for him? I guess my only question would be, you mentioned transition periods, and maybe I guess, Marcia, is there an issue with transition periods?
No, and I think you offer guidance for that through CP 15.
Okay.
And
Okay.
really, the supervision requirements aren't being changed. I think we clarified that whoever is supervising needs to have the knowledge and the experience to supervise the activities of their broker associates. I think what may have thrown some people off is in the existing rule, the section about on-site managers specifically talks about a supervisory broker, and we just relocated that to the delegation section because it didn't make a whole lot of sense that in the middle of that, the on-site manager section, it starts talking about supervisory brokers when the delegation can apply to any employing broker regardless of the activities. So we just moved that down to, I believe, section F of that rule.
Okay. Okay. And does the commission have any other questions? Okay, well, now we will now consider the proposed changes
Mr. Sanders, we do have another hand
Oh, you
here.
do? I'm so sorry. Okay, I'm sorry about that.
Oh, that's all right. Let's see. Tammy, I've asked you to unmute.
Good morning, commissioners. Thank you for your time. My name is Tammy Dietz. I am managing broker for Guide Real Estate. I just quickly wanted to discuss 6.3A in a word in here. It says the employing broker is responsible for ensuring that an associate broker comply with the relevant laws and regulations. And I just want to point out, if we look at it from a DMV situation, the DMV can educate people about the laws of the road and everything else, but ultimately they can't make them comply. Obviously, speeding tickets and all sorts of tickets happen all the time. Same thing with a managing broker. I can't force somebody to comply. I can educate them. I can write them up if they do something wrong. We can also let them go. But I think comply is a broad word that I literally cannot force an agent to comply. I can educate them. So I'd like to see that word possibly changed from comply to educate or something else that is less all-encompassing. Thank you for your time.
Thank you, Tammy. That last sentence was actually removed, but we appreciate your comment. Are there any other comments?
Yes, we do have an additional hand here. Let's see, Joel, I've asked you to unmute.
Yeah, how you doing?
Good.
Hey, I was just asking, I don't have no particular question, but I was wondering if y'all could minimize the time window because I was looking at the where we're going over, but it's like blocking most of the like the non-rulemaking hearing and it's taking up most of that real estate on there. If that's possible. If you can't, that's fine, but I would just like that timer is like taking up a lot of real estate.
The timer's messing up the screen, I think. Is that correct,
Oh,
Joel?
Yes, that's what
Okay.
I was saying.
I apologize. Now, thank you for that clarification. Yes, I can certainly think I can make this window a little bit smaller. How about something like that?
Oh yeah. Even yeah,
Excellent.
that's better. That's better.
Excellent. I apologize. Thank you.
Thank you. No problem. I ain't trying to cause no problem, but thank you.
Thank you, Joel.
No
Any
problem.
other testimonies?
There are no other hands at this time, commissioners.
We will now consider the proposed changes to the Chapter 6 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 6?
Motion to approve changes in Chapter 6.
A second? Yeah, well, I'll second. And discussion. The only thing that I wanted to ask, or oh, actually, no, never mind. I forgot. This has been addressed, so I don't have any. I don't have any discussion. Does anyone else have any discussion?
My questions were 6.5B and D as well, and they have been addressed.
Okay, perfect. And mine was C6. It was regarding the delegation, and we've answered that question. So, all right. Well, if there are no other questions or concerns. Oh, I do have one more, sorry. I know we got a lot of stakeholder comments also about 6.6A. And I just think maybe we could get a little bit of clarification here for the industry. Because now there's a requirement that we have to have a brokerage relationship established. I think where the industry may be confused, and I think clarification would be great, even if it's just on this call, is at what point do brokerage services begin? For example, at a showing, which based on at least my understanding of Colorado law, a showing would not be brokerage relationship, but advising in that showing would. So could you maybe get some clarification on that piece of this so that we have some guidance and maybe we need to add some language so there's not this confusion that there may be a need for a contract in order to show properties?
So you don't have to have a license to show properties or to host an open house. But when you start engaging in the conversations, asking for confidential information, really, I mean, you're going to start performing those duties on their behalf, submitting offers. Those, you're going to need to have a listing contract before you can do that.
Thank you. And that's it. Yeah. Okay, well, let's call the question. All those in favor to adopt the, I'll say amended changes, because what we had was a little bit different. So to adopt the amended changes that was presented by Director Waters. All those in favor of?
Hey.
Aye.
Unless there's any more discussion. Is there any more discussion? Let me back up. Is there any more discussion?
No.
No.
Okay. So I'll go back to the question. All those in favor to adopt the proposed changes to Chapter 6 as amended by Director Waters?
Aye.
I,
Aye. All right, any opposed? Okay, so motion passes. And we will move on to proposed changes to Chapter 7.
Chapter 7 is the use of standard forms. With Rule 7.1.g, we're recommending the addition of clarifying language that the broker needs to be performing license duties in a transaction if they're using a title company form and advising on its effects. With 7.2.f, we filed that in error, so we are not proposing to make any changes to it. So you can just ignore that one. 7.5, we're recommending repealing this rule. It is basically codified in the law that was passed, which was House Bill 26-1426. And that is it for Chapter 7.
Thank you, Director Waters. And you said, I'm sorry, what was the one that you're not recommending the change?
7.2F should not be changed.
Okay. Thank you. Thank you.
So all, just to clarify, so all of the numbering that's in there and tenant estoppel statements, that will stay as well?
Yes.
Okay, great, thank you.
Okay. Thank you again for the explanation. At this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals. Do not duplicate testimony. Should the commission or any of its representatives have questions regarding your testimony, we will ask when you have finished. If you desire to provide testimony on Chapter 7, please raise your virtual hand so division staff will know who to call on.
Any members of the public, please select that raise hand icon. However, commissioners, I am not seeing any hands at this time.
Thank you. Okay, we'll now consider the proposed changes to the Chapter 7 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 7?
Motion to approve changes in Chapter 7.
Do I have a second?
Second.
It is moved and seconded that the proposed changes to Chapter 7 be adopted. Any discussion? All those in favor say aye.
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 Aye. Any opposed? All right, motion passes. And Director Waters, if you can please explain the proposed changes to Chapter 8.
So Chapter 8 is the chapter on declaratory orders. With 8.1, we recommend adding, quote, to the petitioner for clarification. 8.3, we recommend changing will to must to make it an obligation. 8.4, we're recommending the addition of moot or in Part D. In Part E, we are recommending order be changed to relief and that the rule of civil procedure be included. 8.6, the proposed changes are to better organize and clarify the process for how the commission may rule on a declaratory order. And 8.7, we propose that the word disposing be added to the sentence. And that is it for Chapter 8.
Thank you, Director Waters. And at this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of your organization that you're representing. Finally, please limit your testimony to only the proposed rule amendments and repeals. Do not duplicate testimony. Should the commission or any of its representatives have questions regarding your testimony, we will ask you when you have finished. If you desire to provide testimony regarding Chapter 8, please raise your virtual hand so division staff know who to call on.
Chapter 8, public comments. Anyone that would like to address the commission, please do so now by raising that hand icon. No hands at this time, commissioners.
Thank you very much. And on this one, which was the same as Chapter 7, we didn't have any stakeholder comments. We will now consider the proposed changes to Chapter 1 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 8?
Motion to approve changes in Chapter 8.
Do I have a second?
Second.
It is moved and seconded that the proposed changes to Chapter 8 be adopted. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion passes to accept the proposed changes to Chapter 8. And Director Waters, if you could please provide a brief explanation to Chapter 9.
So Chapter 9 is the chapter on the Commission's review of initial decisions and exceptions. The proposed change to 9.1C is to fix an incorrect statute citation. We are proposing to remove which from the first sentence of 9.1E. 9.4B clarifies that the Commission can initiate a review on its own motion. 9.5A pertains to the designation of record. Overall, the changes to this rule provide clarity of the process and should be easier for licensees to navigate. The proposed language clarifies that the designation must specify the portions of the record that the party deems necessary and relevant to the Commission's review of the initial decision. That if one party designates a portion of the transcript, the other party may also file a supplemental designation of record. It also clarifies that what may be designated as a record. Subpart B sets forth a process for designating, ordering, and paying for transcripts. Subpart C clarifies the briefing schedule in relation to whether a transcript has been ordered or not. Subpart D clarifies that the exceptions must identify the specific basis for requesting the Commission's review of the initial decision. And propose to delete Subpart E, the ability to grant an extension still exists, and the delegation to staff as part of the Commission's delegations of authority to the division. 9.6B changes authorized to designated, and 9.7 deletes this, in quotes, whether after oral arguments or a subsequent Commission meeting from Part B. And that is all for the changes to Chapter 9.
Thank you very much for that explanation. And at this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing if applicable. Finally, please limit your testimony to only the proposed rule amendments and repeals and do not duplicate testimony. Should the Commission or any of its representatives have a question regarding your testimony, we will ask when you have finished. If you desire to provide testimony on Chapter 9, please raise your virtual hand so division staff will know who to call on.
Please select that raise hand icon if you have any comments on Chapter 9. Giving it a few moments here, Commissioners, but there are no hands.
All right, thank you, Dad. We also did not receive any stakeholder comments on Chapter 9, and we will now consider the proposed changes to the Chapter 9 rules. Do I have a motion concerning the adoption of the proposed changes to Chapter 9?
Motion to approve changes in Chapter 9.
Do I have a second?
Second.
It is moved and seconded that proposed changes to Chapter 9 be adopted. Any discussion? All right, all those in favor say aye.
Aye.
Any opposed? All right, it is moved that the motion carries and the proposed changes to Chapter 9 are adopted. All right, and that, I believe, concludes our hearing. Bear with me, let's see. Yeah, so thank you very much for your participation. This concludes the rulemaking hearing. I will now turn the meeting over to Director Waters to proceed with policy. Well, we're not proceeding with policy matters.
Not yet.
And since we're done with the rulemaking portion, I would like to request a quick break. We have a very long non-rulemaking hearing as well. And I think it would be sufficient to take a little bit of a break right now. Is that okay?
Agreed.
Okay. Like, does anyone agree?
It's like 10 minutes.
Yeah, like a 10-minute break. I think that would be sufficient. Great. Thank you.
Thank you.
Hello, while we're waiting, I have a question, Marcia.
Okay.
So before we get into the rulemaking hearing with the forms, several of the forms, probably like 20 some odd forms are non-substantial changes. They're just, and can we break this up to discuss those, vote on those, and then do the others? Because otherwise, I think it would just be lengthy and confusing.
Absolutely. Yeah, so you can take the group where the only change is we're
Yeah.
applying the intellectual property language.
Mhm.
You can deal with those and then
Okay.
go into the substantive changes on the
Perfect.
other forms.
Yes, perfect. Okay, thank you.
Good ask, Erica, because I noticed that same thing too. I was like, are we gonna have
Yeah.
to go through these all one by one and go over them?
Yeah.
So
Well, that
If
will
I
save
may,
us a
commissioners,
significant amount of
the
time.
highlighted portion on the shared screen right now indicates those that include those non-substantive changes at the current time. So that's agreement to amend, extend contract through warranty deed. And then substantive changes begin with the unhighlighted very bottom of the visible line, which is appraised value objection notice.
And then as I read my script, I'm thinking just read all of them, or do you think
Yeah,
I
and
should
then
separate
Melissa
them?
could say, okay, we're going to take agreement to amend, extend contract through warranty deed, and she'll tell you what the changes with those.
Yeah. Okay. So I'll
And
read
then
them
you just,
all. I'll read them all, and then when we get to Senior Advisor Phipps, then I'll make that summary. That the first will be, yeah, agreement. Let me just write my notes, and then we can go ahead and get started.
And she's also going to do, like I did at the beginning with the slides to explain the process, because these are different processes. And I think that's helpful for everybody to
Okay.
know that when we
Okay.
deal with the forms, it's not an actual rulemaking hearing.
Right. Okay.
And
Perfect.
Chairwoman Sanders, just to be clear, once we get past, I will take that IP language 22 forms as a group for you.
Perfect. Okay.
But then it's my intention to then go through each form individually and have comment after each individual form as
Okay.
opposed to, is that okay?
Including the IP
No,
form?
just,
No,
well,
okay. Yeah, no, the
just,
second forms we need to do that. I just want to
yeah,
make sure we didn't
okay.
have to do that on this one.
Yeah,
Yeah.
and there are a couple of, in the second group of forms, a couple where the changes are all the same, like the brokerage disclosures. So I'll take like that as a group of 3, but
Okay.
other than that, I'll just introduce each form with the changes
Perfect.
and then ask for public comment on each form.
That's perfect. All right. I think, are we ready to go ahead and begin? Let's get going. We have a long day. All right. Well, good morning. I am Erica Sanders, Chair of the Real Estate Commission. Today is Tuesday, August 4th, 2026. It is now 11:12 a.m. Can you please take roll call, Director Waters?
Erica Sanders,
Here.
Erica Doyle,
here.
Bernadette Bugarin,
here.
Tom Patton,
Here.
Autumn Rubal is absent. You have quorum.
Thank you. The Colorado Real Estate Commission, aka the Commission, has the authority to promulgate real estate forms for current use by real estate brokers pursuant to Section 1210-403 CRS. These forms are referred to as Commission-approved forms. The purpose of this informal hearing is to receive verbal comments and consider previously submitted written comments about proposed modifications to the following Commission-approved forms. And I'm going to read all the forms, so please be patient. Agreement to amend, extend the contract, assignment of lease, bargain and sell deed, bill of sale, contract to buy and sell real estate, bill of sale, personal property agreement, closing statement, counter proposal, earnest money receipt, earnest money release, energy benchmarking disclosure, estoppel statement, licensee buyout addendum to contract to buy and sell real estate, listing contract amend to extend, manufactured home contract amend to extend, manufactured home counterproposal, notice to terminate, personal property agreement residential only, Quitclaim deed, residential addendum to contract to buy and sell real estate, special warranty deed. Square footage disclosure, residential, warranty deed, appraised value objection notice, brokerage disclosure to buyer definitions of working relationships, brokerage disclosure to landlord definitions of working relationships, brokerage disclosure to seller for sale by owner definitions of working relationships, broker disclosure to tenant definitions of working relationships, brokerage duties addendum to property management agreement, leasing activities, brokerage disclosure duties to seller, REO, and non-CREC approved listing agreements, change of status, transaction broker disclosure, CIC property disclosure, new, deed of trust, assumable, not due on transfer, deed of trust, due on transfer, strict, deed of trust, due on transfer, creditworthy, definitions of working relationships, dual status disclosure, real estate broker and mortgage loan originator, earnest money promissory note, Section 1031 exchange addendum to contract to buy and sell real estate, exclusive brokerage listing addendum to listing contracts, exclusive right to buy listing contracts, exclusive right to lease listing contract, exclusive right to sell listing contract, exclusive tenant listing contract, green disclosure energy, home warning notice, right to cancel, Colorado Foreclosure Protection Act, inspection resolution, amendment to contract to buy and sell real estate, landlord's disclosure of information on lead-based paint and lead-based paint hazards as required by federal law, rentals, seller disclosure of information on lead-based paint and lead-based paint hazards as required by federal law, sales, lead-based paint obligations, landlord, lead-based paint obligations, seller, notice of cancellation, Colorado Foreclosure Protection Act, open listing addendum to listing contract, post-closing occupancy agreement, seller rent back agreement, promissory note, UCCC, no default rate, seller authorization, seller warning, equity skimming, paragraph 8, or section 18.5-8026 CRS, Colorado Foreclosure Protection Act, short sale addendum, seller listing contract, short sale addendum, contract to buy and sell real estate, source of water addendum to contract to buy and sell real estate, title related objection notice, worksheet for closing statement. In addition to my fellow commissioners, here with me today are Director Waters, Deputy Director Holleran, Senior Advisor Phipps, Commission Liaison Doreen Archuleta from the Division of Real Estate, and Gina Simonson and Irina Groen from the Attorney General's Office. In addition to the public comments today, the Commission will review any written materials to make the final decision on the proposed new and modified forms. Let's now have Senior Advisor Phipps explain the proposed modified forms. And Senior Advisor Phipps will provide a summary of the forms initially from the agreement to amend to extend the contract to the warranty deed. Hopefully that made sense.
Yes, thank you, Chair.
Thank you.
Before I get started going through the proposed changes, similarly to what Director Waters covered regarding the rulemaking, I just wanted to take a couple minutes to review the process by which the forms are promulgated and to acknowledge the various steps along the way where stakeholders have provided what really has turned out to be invaluable feedback to this process. So just as an initial matter, I want to point out that the process by which the forms are promulgated, it's unique. It's not governed by the same requirements that are set out in statute for formal rulemaking, as with the rulemaking hearing that we just went through. But despite not being required by law, the division has historically followed the traditional rulemaking procedures. We've published the forms and held a hearing for their adoption. But in recent years, the division has taken the extra steps to begin expanding that process and really trying to offer opportunities for broad stakeholder feedback along the way as the drafts are being developed, rather than limiting the participation to the formal methods at the very end of the process. And really our hope is that this allows for more meaningful participation to a broader stakeholder group. Interested parties aren't limited to speaking at the hearing. On just the day of adoption, they can provide both written and verbal input throughout the whole entire process. And as part of these changes, I think it's important to point out that the forms drafting process, having it being brought in-house to the division, hasn't changed the basic process by which the forms get reviewed. I look at this process as kind of like a three-prong approach, and that, like I said, that process hasn't changed. The first prong is just the standard scheduled review. The forms are scheduled to be reviewed every 3 years. So if a form is up on the list for review that year, division staff takes a look at it to review it to make sure that it's current, it's up to date, no legislative changes have been missed, or to address any issues that have been identified, throughout the year. And then another level of review is what we call the global list review. And in case anyone isn't aware of this, I want to point out that there is a link on the division's website that is live year-round. And using this link, any broker, attorney, member of the public, industry professional, anybody that has an interest can submit a suggestion regarding changes to any form or contract. And then these changes, along with any others that division staff has received, through email or, maybe at a presentation to the public. I know Director Rogers hears a lot of feedback from people. So any suggestions that we've received along the way are compiled into that global list. And then every year that global list is reviewed by the commission. So any forms that are up for review that year that have suggestions that have been made on the global list, the commission reviews those and then provides direction to division staff about which changes they'd like to see implemented. And then finally, the kind of last level of review is when the legislature is in session, the division staff is constantly monitoring any new legislation which might necessitate changes to the forms. So if any change is needed because of new legislation, those forms are automatically put on the list for the commission to review that year. So those basic processes to review for potential changes remain the same. What the division has been changing is the process by which the proposed changes to the forms are vetted before they're ultimately presented to the commission, and making an effort to expand this process to include more stakeholder input. So prior to today's meeting, the division has held 3 separate stakeholder meetings, which were open to the public. And during these meetings, participants were allowed to present verbal comments regarding any of the proposed changes. The red lines were published prior to the meetings, and people were allowed to provide verbal comments. And then also, as part of the process, for anyone who wasn't able to attend the meetings or maybe wasn't comfortable with providing verbal comments during the meetings, everybody had the opportunity to submit written comments on the proposed changes. And that submission platform to put in written comments has been open to the public since February. So we've had some very helpful feedback from that avenue as well. And so these meetings were held the first one was held in March of this year. I'm just trying to find the numbers here. There were 100 participants in that meeting. The second meeting, there were 60 participants, and at the third meeting, there were 83 participants. And in addition to those people who participated in the meeting, there were somewhere about 20 to 25 written comments that were submitted as well through the stakeholder engagement platform. So we're happy that this process has provided seats at the table for a significant number of people who previously didn't have access to actively participate in the process. And then in addition to that kind of increased stakeholder outreach, we've also, division staff has made a concerted effort to reach out to industry experts to really open up a dialogue to talk through concerns and speak speak to them and seek their input on specific issues. And by doing this, we've really gained what I think is really invaluable input from federal and state agencies. Commissioners, you can see in your materials that we've had discussions with the EPA. We've also reached out to the Colorado Energy Office for guidance. And we've had conversations with the Attorney Regulation Council. We've also engaged with attorneys and industry groups who specialize in different areas that are relevant to the forms. So as time progresses and we work through additional forms, we really hope to continue to expand this network of industry participants and experts that can help guide us through all of the changes and kind of work through some of these sticky issues that really need some expertise from the industry. So kind of just to sum it up, like I said, as we continue to work through new forms and hopefully refine and improve the forms review process, we welcome and encourage participation from members of the public, industry participants, because we're really looking to help the commission get a broad range of perspectives to take into account when making these important decisions and considering the potential changes to forms. So that's all I have for that. I can move in now to that first batch of forms that we were talking about. And that is the first group of the forms that are on the agenda. It's 22 forms, and all of those fall into the category of what I'll call the IP language change only. And for the sake of time, I think we'll take up these forms as a group rather than going through each one individually. And so as Chair Sanders, as you said, that group starts with the first form on the agenda, the agreement to amend extend contract, and that goes down through the warranty deed. So none of these 22 forms are up for review this year, so there are no substantive changes proposed to any of these forms. The only proposed changes pertain to this IP language. And that is on the top of the forms, there's the new form identification language, including the adoption and effective dates. That's the same change that we implemented in the past year. And as part of that part of that header this year, there is also newly revised intellectual property language proposed. And then going down to the footer on all of these forms, there's the addition of the language copyright 2026 Colorado Real Estate Commission on each form. So same proposed changes on all 22 forms. So I think we can open it up for comment and discussion on that group as a whole.
Thank you. Is it possible to pull one up so that stakeholders can see yeah, perfect.
There's David on it.
Okay, well, thank you for the explanation. Any comments or questions from my fellow commissioners?
I just have one quick comment. Before we get into this, I just wanted to thank everybody for all of their participation on all of this. I was hesitant for the new process, but I do think that it's working well. And the material that we are receiving is full of depth. There is a lot of it. And I hope that people are seeing that we are going through it, we are reading it, we are digesting it, as is the division, and changes are being made because of their commentary. And so I want to continue to encourage people to participate in those meetings and keep those comments coming so that we can just make this process better. And I just want to thank the division staff for doing everything that they did for this, because this was an enormous amount of work that has been in there. So thanks for everybody, and we will keep moving forward on all this.
Thank you, Erica. And then my only notes was to just say I really like this disclaimer. I'm definitely in favor of it. I think it protects the integrity of the form by preventing unauthorized reproduction and modification. And as Erica said, there's a lot of work that goes into that, and that should be protected. It prevents third parties from, modifying and circulating, and it clarifies, which I thought was really important. Although this can't necessarily be managed or controlled, it does clarify who's authorized to prepare and reproduce a form, which I think is highly important to note that brokers are the ones that should be preparing this form. And yeah, so I think they look great. Any other comments, commissioners? Okay. And so what we'll do is we're going to split this up into, I will ask for comments from the stakeholders now, and then we'll do it a second time. Is that, I want to make sure I'm okay and I'm not out of order. Okay. So at this time, we will start with the verbal comments. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your comments to only the proposed modified forms, and given the limited time, please refrain from duplicating previous comments. Should the commission or any of its representatives have a question regarding your comments, we will ask when you have finished stating them. If you want to comment, please raise your virtual hand now so the division staff know who to call on. And David, if you could just assist us with that part.
Love to, commissioners. So if anyone does have any comments from the public, please do select that raise hand icon from the Zoom platform. And it looks like we have Jim. Jim, I've asked you to unmute.
Yeah, thank you. Melissa mentioned that on the division's real website that there's a link to be able to comment on any form. And I went to the division website and I don't see anything of the sort on the division website.
I
I'll send you the
don't
link.
know without sharing the screen how best to describe to walk you through that. If you go to the, sorry, I'm gonna try and do it on my computer so I can follow along as I talk. On the division's
share
main
over
page-
for you here.
there you go.
Ms. Phipps.
So if you scroll down to there's a portion where it says broker contracts and forms. You click on that and then scroll down to, I think it's all the way at the bottom, right there, Colorado Real Estate Commission form, suggestion form.
Thank you very much.
You're welcome.
If I may clarify, that is the permanent year-round available list, a Google form that is available for to submit comments. I'm just going to take a jump back to our home page here, and from the page that we had developed for purposes of today's meeting. You can submit comments in this banner previously as well. So as well as to review all of the all of the red lines that are available for discussion today.
I do have one global suggestion, and that is that, or feedback, and that is that, for instance, on the listing agreement, there's on many of the agreements, there's section 3.9.2 on the listing agreement that says if any of the dates are on a weekend or holiday, they're extended to the next. Well, there are only 2 dates on the listing agreement, and it's the date that it's signed and the date that it expires. And that sentence, that provision is totally meaningless because, oh, okay, so we're agreeing to have this expire on a Saturday. We're agreeing to have an expire on a Saturday. That really is a portion that is only in there for when you're using MEC dates. It's not appropriate on contracts that don't have dates and deadline sections. That's my only feedback.
I'll add that to the global list.
Thank you, Jim. And then for any future comments, if you do have comments about a specific contract, let's wait till we get to that section and then we can add those, those testimonies at that time. But thank you, Jim. And are there any other comments for this first group?
If anyone does have comments, please do select that raise hand icon. However, commissioners, I am not seeing any at this time.
Okay, thank you very much. Well, that ends the comment portion of this informal hearing on the agreement to amend to extend contract all the way through to the warranty deed. We will now consider the proposed new and modified forms. So I have a motion regarding the proposed forms. Agreement to extend through warranty deed.
Motion to accept the modification.
Yep, no second.
Great. So it is moved and seconded to adopt the modifications of forms. Again, the agreement to amend, extend contract through the warranty deed as presented. All those in favor, or sorry, is there any discussion? All those in favor, please say aye.
Aye.
Aye. Any opposed? All right, thank you. The motion carries and the proposed new and modified or modified forms are going to be adopted all the way through the warranty deed. And now if we could please have Ms. Phipps take us through the remainder of the list.
All right, thank you. So I'll start off with the next one on the agenda, which is the appraised value objection notice. The changes shown on the version that you have in paragraph 1.2 are the same changes that we had. Actually, before I get into that, I just want to take a step back and just clarify that on each one of these forms that I go through with the substantive changes, that proposed new IP language is also included on each one of these forms. So I just wanted to point that out, but because it's the same on each form, I won't go through it individually and mention it each time. So just be aware that that change is also there. So going back to the appraisal value objection notice. So in paragraph 1.2, the proposed changes on the version that you have changed the word attached to provided. And this change was instituted in 2025 after some discussion. And the intent was to address the situation where a document couldn't be physically attached to the form or to the contract. And there's been a little bit of discussion about whether really that was an appropriate change or not. And so after some further research, staff now recommends that the commission revert back to the original language and that the use of the word attached to be retained rather than switching over to provided. And the issue that we came across really is that the term provided could be interpreted as simply it was just made available, and it doesn't really accurately convey that the reference document was actually transmitted or it was actually received by the party. So other than that, the paragraph below that change remains substantively the same, but the intent is to rewrite it really in a more clear and straightforward manner. And those were the only changes to that form.
Thank you for the explanation. Couple of things. As we go through, are we able to show the red line version just so it's there? And then second, do we want to address comments individually or collectively on this?
I can let your counsel speak to that, but from my perspective, I think it may be easier to go through each form individually and have comments presented on each form, if that's okay.
I think that would be best. And then I guess another question, will I need to state, as I did with the others, on every form, will I need to state that, the speaker's going to have 3 minutes to speak, et cetera, et cetera?
I think you can be a little less formal with this process because it is different from the rulemaking process. So if you just want to open it up to public testimony, and knowing that the rules are you get 3 minutes, please don't duplicate testimony and state who you are and who you represent.
Okay, perfect. Thank you for that point of clarity. And so what I'll do is I'm going to just kind of read our rules on how to handle this. once, and then we won't have to keep revisiting this on every single contract. So at this time, we will start with verbal comment. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing if applicable. Please limit your comments to only the modified form that we're discussing and limit your time. Please refrain from duplicating previous comments. Should the commissioner or any of its representatives have a question regarding your comments, we will ask when you have finished stating them. And if you want to comment, please raise your hand. And again, please keep your comments to 3 minutes or less.
So if anyone from the public would like to address the appraised value objection notice, please raise that hand icon. No hands at this time, commissioners.
Okay. If we could, do any of the commissioners have any comments?
No.
No.
Okay, I do have one. And so then I'm kind of doing the comment section first so that we can make the motions second. But the only thing in reviewing this, there's 2 things I noticed. Number one, this is very small, but at the bottom footer, it says valuation instead of value. So that's just a small, like, typographical error. Also, under 1, okay, so yeah, let's go right there. Yep. So I actually found this kind of complicated to read. And I thought I would like to at least present a different way to say this. And then you guys can let me know if it reads clearer to you. Because when I read this, it just read complicated to me. The way I would recommend it be read is the contract will terminate if the buyer and seller have not reached a written agreement to resolve the matters identified in this appraised value objection notice on or before the appraisal resolution deadline, unless the seller receives written notice from the buyer withdrawing this appraised value objection notice on or before the appraisal resolution deadline. I just think it reads a little smoother having that first sentence at the end.
I like that better. It is clearer.
It's a little clearer. Yeah.
Mm-hmm.
I think that's fine.
Okay. Well, I would entertain a motion to adopt as amended the proposed changes to the appraised value objection notice.
Motion to adopt as amended.
Do I have a second?
Second.
Any discussion?
Mm.
All right. Well, all those in favor, say aye.
Aye.
Any opposed? Nay? All right. Well, motion carries and the proposed new and modified adopted as amended has been accepted.
And Madam Chair, if I could request that you could send me that language that you read in
Yes.
writing, just
Sure.
to make sure that I get it correct.
Okay. Can I do it after the?
Absolutely.
Okay.
Yep.
All right. A lot going on here right now.
Got a lot going on, I understand.
Okay, perfect. Well, thank you for that. And if you can please take us to the next form.
Okay, so the next 4 forms actually on the agenda are the brokerage disclosure to buyer, brokerage disclosure to landlord, brokerage disclosure to tenant, and brokerage disclosure to seller for sale by owner. And the changes made to these 4 forms are pretty much all the same, with one exception that I'll cover at the end. So I'll just go through them all together. If you go down to the last sentence of the transaction broker paragraph, and that scroll up a little bit there. Further, a little further up, a little further. Keep going. Oh, the version that this does not show red lines on this one.
Let me try one of the other ones then. I apologize. Here's the for sale by phone.
That is weird.
Forgive me if I may have.
There should be a version that's labeled 7/20/2026.
That is this one.
Yeah,
I don't
that's the
know
one I
why they're
have.
not showing. Okay, well, I apologize, commissioners, that I'm not able to work through those on the screen with you, but I'll just go through them.
Now, there were some red lines. They just started on page 2. Well, outside of the top.
Yeah, there should be red lines that show up on page 1, though.
Oh, okay.
Starting.
Bring me a question. I do have a question on this because I'm wondering if we could maybe do this in a different order on these in particular, because the definitions of working relationships does have changes on it to these definitions, but they're not here. And so I'm wondering, if we were changing those definitions, we should probably edit that form first and then come back to this. That would just be my suggestion, or if we're allowed to pop into that one maybe first and then come back here, because if we're editing definitions and we would want to bring that in here, and maybe those are the red lines that were supposed to be in here, I don't know.
Yeah, that makes sense.
If you guys prefer to skip forward to the definitions of working relationships, we can certainly do that. Cover that one first.
That'd be great.
Let's do that and then come back.
Okay. All right. So the first suggestion on here is to change the freestanding statement regarding the type of different brokerage relationships. Change that into the body of the document. In the seller's agent's paragraph, there's the addition of the line, the buyer may either be unrepresented or represented by another agent. That proposal there is not reflected on the red lines, but I'd like to clarify now to change the word agent in that to broker, just a more general, more accurate statement. And the intent of the change in the sentence as a whole is to clarify for the consumer that a broker cannot represent both the seller and buyer as an agent. And then the line that is suggested to be deleted after that has just been moved to a later part of the document where the duties of an agent are explicitly stated in list format. This is done for clarity and ease of reading for the consumer. And then the same changes are made in the buyer's agent paragraph. And then going down to the transaction broker paragraph, the changes again were intended for the sake of clarity, rather than having everything contained in a lengthy paragraph that a consumer has to kind of work their way through. The suggested new format takes out the duties and responsibilities and lists them separately in an easier to read list format. The suggested change makes a clear upfront statement that a transaction broker is not an agent for either party and does not advocate for the interests of either party, without making the consumer read through a paragraph of the duties before seeing that. And then that last change in the paragraph there is necessitated by House Bill 261246, which now requires a written agreement to establish a transaction broker relationship. And then the change, the change in the customer paragraph at the end of that paragraph, there seems to be some red line issues going on there.
There's some numbering issues too, because my page 1 says page 2 of 2, and then my page 2 says 2 of 2, and my page 3 says 2 of 2.
2 of 2, yeah.
Yeah, okay, so I'll make note to make sure that that numbering change is made. Okay. All right, so sorry, I lost track of my changes there. So below that, you'll see the duties and obligations section. That's the new proposed section. As I just talked about, the duties were taken out of the preceding paragraphs where they were kind of mixed in with other information and placed here where they're listed out, expanded, and put in bullet point format. And the overall intention is just to make it easier for consumers to be aware of and understand all the duties because they're an easy to access and easy to digest format. And then presumably the list would be also easier to reference in or refer to in a later discussion between a broker and a consumer. And then below that, duties and obligations, there is a brief list of what agents and transaction brokers do not have the duty to do. And then below that, there is a suggested addition of a paragraph titled General Information. And this is intended to provide a consumer with a more complete picture of the brokerage relationship, including the structure within which the broker is working and the knowledge that there may be other brokers, such as an employing broker, that have involvement in their transaction and may have access to their information. This additional information also equips the consumer with the knowledge of the statutory constraints that apply to the other broker's involvement. And then below that, we are just proposing to flip the broker's acknowledgement to come first. Seemed to make sense because they're the ones who are providing the document. There's also the addition of a line for the broker to include the employing broker or managing broker's name, if applicable. Again, and if there is another broker that is involved in the transaction, even just for the purposes of supervision, there's really no harm in the consumer being fully informed as to who that person is. Those are the changes to that document.
Okay. Thank you for that explanation. First, do we have any comments or questions from my fellow commissioners? No one? I do. So we talked about some of the changes with the numbering. I guess I'm trying to understand what the purpose of the changes were and I'm trying to understand how we are supposed to use this because we also have, the broker's disclosure. My questions were, are they supposed to mimic each other? When would we be using this? Now I think people use it just more as a informative, right? So maybe take a listing, you probably include this just to inform the consumer. There's a strikeout of this is not a contract, so that was confusing for me because this is a disclosure, but then we struck that it's not a contract. So I guess I just want to, if you could just walk us through a little bit, kind of the idea behind the changes and then how you visualize us using this in a transaction. And then why the contract part was struck, because it's a I wouldn't identify this as a contract because it's a disclosure. So if you could just maybe just give us that background and then we can have a discussion from there.
Melissa, do you want me to take this one?
I've heard you give a great explanation of it, so I will definitely defer to you.
Thank you.
So definitions of working relationships are used when a broker or a brokerage firm don't offer all of the brokerage relationships available. So some brokerages don't offer transaction brokerage. So if they're going to only offer single agency, then they need to give the definitions of working relationships to the consumer so that the consumer can evaluate and decide if that's sufficient for them. So that's when this form is used. Melissa did a lot of research of different state forms and was just really kind of looking at trying to make this more consumable for the consumer so that they understand what brokerage relationships are and what the duties are. So that's why the form looks significantly different than the current one. is really just to make it more consumer friendly.
Okay, and I can get behind that for sure. But then my next question, the contract, did we strike through that this is not a contract?
Well, it's never been a contract, so that's probably why it's been struck through as it's not a contract. It's just putting them on notice. These are the relationships offered.
Yeah. Because I do provide this, it was always, well, I guess maybe it's not that big of a deal when I think about it. Because, it was always nice to be able to show the consumer, especially if you're presenting this right away, that, hey, this is not the actual contract. There's a different contract. And I liked having that there because it did give them notice right away that it wasn't a contract. Do any of the other commissioners have any additional comments or questions?
Yeah, I'll jump in, Erica. I had questions right alongside with what you were asking because, and it came out of reading the BD 24 that they were doing, because there's so many changes to both of these documents. Are they trying to change how we use these? And in my experience, we want to use, when we're going right into contracting with a client, we're not using necessarily the BD 24. We are using the definitions with the contract so that they know all of that. And I do agree with you. We would say, this is not a contract because it said that on there. But we want you to be aware of the variety of ways that you could be helped in Colorado. So you have that there. I think it's important. I would still remove that. This is not a contract. We're going to give it to them. And you would use that with them. But there's occasions when someone would only get the BD 24. That's all they would be getting. So when we have that BD 24 and on the bottom of that, it refers you to then, if you have questions, look at the definitions of working relationships. So there's confusion for me when I look at these two forms and the suggestions. You wouldn't put these two together necessarily. It's overkill and it would be very confusing to a consumer, particularly because as I was looking at it, the definitions in this form did not match the definitions that are in the BD 24. So we want to start here. I don't necessarily have a problem with what's been done here at all, but I do want to match it moving on to the next one. And I want to make sure that we're giving clear direction as to when this would be used, required, not used, and just make sure that we're all on the same page with that. So I'm in alignment with you on that one. But I would remove this is not a contract.
Yeah. I definitely would like to see that stay. And same concern.
Yes, I would like that to stay, not remove it.
Yeah. And same concern, which we haven't gotten there yet because we went here, but is this intended, because there is a reference to this, which I highlighted in the other as a question, because there's a reference to this. Obviously, this was different than the definitions on that one. So what's the intent there? Is the intent that the broker's disclosure matches this, or was it intentionally different? I guess that's
yeah, and I don't want to, I mean, normally I wouldn't confuse forms. I would be like, let's just stick to this one, but these two reference each other and they are talking about definitions. So I felt like we've got to get this one ironed out, but it does tie into those other forms that we're going to work towards. And we use them in similar, but not the same instances.
So I think if you want to have them consistent, we can definitely make them that way as far as the definitions are concerned within the forms themselves. They do have sort of different purposes. I mean, the brokerage disclosure is when a consumer contacts you wanting to go see a property and you end up with that form putting them on notice that you don't work for them yet and that you'll be treating them as a customer, and the different relationships available. But and I'm not aware of us ever, like, I'm not aware of the commission ever disciplining somebody for doing overkill by having definitions of working relationships, the brokerage disclosure, and then the contract. But I think we just need direction if you want the brokerage disclosure forms to look similar to this one, we just need that direction.
I mean, I think they probably should look the same because they're titled the same. So it will cause some confusion even to brokers when they have the definitions of relationships here, and then in that section of the broker's disclosure, it says definitions of working relationships, and they're different. That would, to me, cause confusion within the industry. So I do think that the definitions should be consistent and they should be the same across both documents. And I think also, I know this is jumping ahead a little bit, but we might provide a little clarity in the broker's disclosure, and I'll get there, and I'll get there when we get there on, because I think there's confusion on when to use what. There's confusion on when to use what. So, and I appreciate you giving that explanation, but I was personally always a little confused, so I would just do both of them a lot of times. Kind of depends on the situation. Definitely this one I would always use with the listings. The other one I would mostly use with buyers. Kind of in the scenario that you mentioned. So, I guess my recommendation would be, yeah, to just have them consistent. For the rest of the commissioners, do you have any thoughts or comments about that? Tom, maybe?
Yeah, no, I would agree. I mean, they should be the same. Otherwise, yeah.
Yeah.
I think consistency could be key for this, because looking at it on the consumer side, if you do receive both of these and it has the same name but different descriptions, it'll be confusing to the consumer. And then
Yeah.
we just end up having to fall back on the explanation from the broker.
Okay.
Does that leave room for misinterpretation or forgetting and then not knowing what each after the fact, if you're looking back at paperwork, confusion as to what meant what on it.
Okay. Well, it sounds like our comments are in sync. We think that this should stay. We do not really have a problem with a lot of the other changes. We think that this is not a contract, should remain. And at this time, I think it's, we want to allow the stakeholders to have comments, and then we can make a decision there. So at this time, we'll start with the verbal comments. If any of the stakeholders want to speak, you have 3 minutes, and we can go ahead and open that up now.
Please select that raise hand icon if anyone from the public would like to address the commission on the definitions of working relationships. After your robust discussion, no hands are raised.
Okay. So, I guess the question for us, are we keeping the language here? Or are we keeping the original language of the definitions? And I would love some guidance from the division on what you think would be best on that section. Since both languages are present, which one would be most appropriate for this document if we were going to do a consistent definitions document?
Are you
You're
asking?
muted. Oh, you're muted, Marcia.
I think what Melissa put together for the definitions of working relationships is easier for consumers to understand.
Okay, so we go with this one. Perfect. Okay, so with that being said, if there's no further discussion amongst us, I guess we'll go ahead and make a motion. Does anyone want to make a motion to accept the definitions of working relationships with the proposed changes, which would be, as we stated, leaving or changing the numbers and then leaving this is not a contract in.
Motion to adopt as amended.
Do we have a second?
Yep, I'll second.
All right, all those in favor say aye.
Aye.
Any opposed say nay. Okay, well, motion passes and this definitions of working relationships with the amended changes are adopted. Okay.
Commissioners, if
Thank
I
you.
may, to
yeah.
clarify the record, when
Yeah.
you were approving the prior form, approved value objection notice, there was some disconnect between the form that was displayed and the language that you were approving. So you approved attached language on that form. The form that was displayed looked like the provided language was the one that will be moving forward. So I just want to clarify for the record. I think the verbal discussion supports that you adopted approved language. I just want to make sure that there was no
Yes.
confusion for someone.
Yes. Absolutely. So the motion was to adopt the approved language and the amended portion of that motion was to leave this is not a contract in place. But otherwise we're adopting the form. Oh, and then correcting the page numbers. So there were two corrections. Page numbers and then this is not a contract would remain and all other elements of that form would remain the same.
And Eric, I think she wants us to also go back to the previous form, the appraised value objection notice.
Okay.
And clarify that change as well, that we approved, that it was attached versus provided.
Okay.
The change.
So on the, sorry. So on the, can you make the motion, Erica? Because if you have it in front of you.
Oh, sure. Just to clarify our motion on the appraised value objection notice, we are utilizing the word attached instead of provided was the change. Do we need an additional motion, Irina?
Oh, you're muted. You're muted, Irina.
Sorry. I think even your original motion was great. It's just the form that was displayed during that discussion was misleading. So I wanted to make a record of us that was the intent to keep approved despite of different form being displayed.
Yes. Okay, thank you. So we've now done that on record. So we're okay, right? Thumbs up. Okay. All right. Okay, so we will move on to the next form.
You guys want to go?
And we're gonna go back. Yeah, we can now go back to the broker's disclosure.
All right.
All right. There we go.
All right. So going back to the brokerage disclosure, I'll just go through the proposed changes first, and then you guys can discuss additional changes that you'd like to see. So as of now, the proposed changes, the last sentence of the transaction broker paragraph contains a proposed change that is necessitated by the law change contained in HB 26-1426. Again, I do not know why that's not showing up on the red lines on the screen. But so I'll try and pull up another version here. It's basically just reflecting the change that and that a written agreement is now required to establish a transaction brokerage relationship. So let me just pull it up so I can read you guys the exact language. Here. Okay, so the proposed change is the last sentence of the transaction broker paragraph. It would now say a separate written agreement is required to establish a transaction broker relationship between the broker and the party or parties to be represented by the broker. And then in the customer paragraph below, the proposed change is just to add at the end of the sentence by written agreement. Again, just to clarify that if a party is going to be represented by an agent or a transaction broker, a written agreement is required. Again, necessitated by HB 1426.
And can you please read the transaction broker sentence again, just so I
Sure.
can make note of it?
Yep. So the last sentence of that paragraph would now read, a separate written agreement is required to establish a transaction broker relationship between the broker and the party or parties to be represented by the broker.
Okay, can I just read that back?
Absolutely.
Oh, wait, hold on. What was the first, the second word,
Separate written
thank you.
agreement.
I knew it started with an S, but I couldn't jot it down that fast. A separate written agreement is required to establish a transaction broker relationship to the party or parties to be represented by the broker. Does that sound about right? I may have gotten it wrong a little bit.
Close. So a separate written agreement is required to establish a transaction broker relationship between the broker and the party or parties to be represented by the broker.
Okay. Thank you. I appreciate it. And then the last sentence it just says by written agreement.
Correct. At the very end.
Customer. Okay. Okay. Thank you for that.
Yep. Okay. So then on the second page, there's the proposed removal of the paragraph containing the blanket waiver of confidentiality, as it doesn't meet the standard of license law as amended in HB 26/1287, which requires a broker to obtain the express written consent prior to the sharing of confidential information. Below that is an expanded statement regarding the disclosure of settlement service costs. This new language conforms to the changes to similar provisions that were approved by the commission last year. So this change is just for the sake of consistency with those previous changes. The statement of this is not a contract has just been moved down to just below the tenant acknowledgement. And then there's this also the suggested addition of a statement which refers the tenant buyer to the definitions of working relationship disclosure document if they need further information to understand the different relationships. And I think that was our intent, was that they would be complementary, and that if they needed further detail, then they could refer back to the definitions of working relationships, because all of the information, I heard a lot of discussion about them being conflicting, but the substantive information is the same. It's just in a different format. But I'll let you guys get into discussion about that. And then there is another proposed change that was not reflected on this particular form. I think that's up before you and on the screen. And that is, again, just the addition of the employing broker or managing broker's name, just to fully inform the consumer of all the brokers who could be involved in the transaction. So that's all we have as far as proposed red lines. And
okay, where would that be? The employing broker's name?
Just scrolling down.
Would it be a signature or just their name?
It's intended just to be their name.
Okay. Yeah, I'm just curious where on the form that.
Yeah, just it was under the broker acknowledgement, brokerage firm, broker. But I can see your point where that would be confusing. That would might require the employing broker's signature as well.
Which I think would be like maybe an overkill.
Okay.
Okay. Well, thank you very much for providing this information. And do we have any questions from or comments from my fellow commissioners?
No.
I mean, I still think we should align them as much as possible. So you know, I think if we've got the definitions brought over and they are the same, then we don't necessarily need the paragraph in there that is referring them to look at the definitions of working relationships disclosure as an additional document. So we wouldn't need that.
And a real quick question. Maybe I just don't have it in front of me, but you may know off the top of your head, Melissa. Do you know if the definition of working relationships has the correct language regarding separate written agreement? I think it did, but I'd have to pull it up.
It did. Yeah.
Okay.
But let me just pull it up it was worded differently. But under transaction broker, it says a broker must be considered a transaction broker unless a single agency relationship is established through a written agreement between the broker and the party. Okay, no, it doesn't say that it's required. It says no written agreement is required.
Okay, so
that does need to be updated.
Yeah, we need to update. We missed out on the last when we did that one. Okay. So it sounds like the recommendation right now on the table from the commissioners, or at least from Erica, would be to keep the language from definitions of working relationships, insert that in this section, the first section. But we also need to make corrections about the written, separate written agreement being required.
On the definition of working relationships form, there is a proposed change under the transaction broker paragraph. That's what we went over about the separate written agreement being required. Just wasn't on the red line form that was on the screen. But that's what we covered when I read it that you wrote down.
Well, I wrote it on the broker's disclosure, but I don't think I caught it on the let me see. I don't remember catching it on the definitions. Oh yeah, it does. A broker must be considered transact unless a single, oh no. It says, it does still say no written agreement on mine.
Yeah, mine too.
So under transaction broker on the definitions, it says a transaction broker is not an agent for either party and does not advocate for the interests of either party. No written agreement is required. A broker must be considered a transaction broker unless single agency relationship is established through a written agreement between the broker and the party or parties to be represented by the broker. That's what mine says under transaction broker. This is back to the definitions of working relationships. So I think we need to have that correction on here too.
And when we get through all of these forms at the end, we will ask you for a delegation of authority to be able to fix any typographical errors. But we will likely also ask to have that delegation specific to the changes for transaction brokerage as well.
Okay. So
the other thing oh, sorry, go ahead, Erica.
Oh no, I was just gonna clarify that, but maybe you go first. You go first.
somebody brought up in stakeholder one or multiple times, I don't know, that there was a suggestion on this form in particular that we have one form that is the page 1 and 2, or maybe now we've got 4 pages, or we could have more after that. But then one where we don't have the buyer broker's compensation agreement at the end if that was not necessary for the person that you were giving that to. Because right now people are just striking that if it wasn't necessary. Is that something that was considered?
But I guess with that, couldn't you potentially use definitions?
Well, no, because if you are telling them that you are the customer and you're the seller's, they're the customer and you're the seller's agent. So you're in that mode there. You're just giving them the disclosure, but you don't have anything to do with the buyer's broker's compensation at that point. So that form isn't necessary in that particular scenario. And so then it's just confusing to the consumer. They're like, well, why do I have this on here as well?
You're talking about the seller. Sorry, I thought you were talking about, okay.
Yeah.
On the seller, yeah.
Just an option to be able to have the form in both of those aspects. One, you still have it to give to people, you're giving them the form, but you're like, this extra page is not necessary for what we're doing here.
Okay. So, okay, so we can get to that because that's on the seller disclosure, right?
No, it's on the BD 24. It's page 3 and 4 of that. Broker disclosure to buyer.
So just to confirm what I'm hearing, you would like a version of this form without the compensation language in it?
Correct.
Okay.
Okay. Okay, so I just want to point of clarity regarding the so I'm going to go back to our motion regarding the definitions of working relationships. I just want to be clear that in addition to the change, which was the pages and sorry, this is not a contract. We want that to remain in this document. We also need to make corrections in regard to written notice being required. So I just want to put that on the record that as part of that motion, because we motioned that we would keep it as written, we didn't have the copy that showed written agreement would be required. So I just wanted to make that, like, note that on the record. And is that sufficient?
Thank you.
Okay. Okay, so if we can get back to our broker's disclosure to buyer. The changes that you were recommending, Erica, was to make the definitions consistent with the definition document.
Correct.
I think you said, and I think it would make sense to remove after Megan's Law, the part that says buyer can refer to the definitions of working relationships. We can remove that.
Correct.
And regarding the compensation, we would have 2 documents, one with broker compensation agreement, one without. And I'm guessing that would be a document that's noted something to the effect of broker's disclosure to buyer, no compensation, or something like that.
I agree.
Are those all of the changes that you're
Let me just
proposing?
look at my notes one more time.
And Chair, if I could just interject about removing the reference to the definitions of working relationships.
Yes.
Just a point that I would raise about that is, I understand if you're moving the definitions over from the definitions of working relationships to this disclosure. But by doing that, what we're leaving out is all of the actual duties that are explicitly laid out in the definitions of working relationship. So I would think that would be one reason, because these new definitions are very limited because all the duties are listed out separately. So just if you would leave that reference in the disclosures, it would at least give a party a place to go look for all of the duties to be listed out. That makes
Okay,
sense.
and let me just ask Commissioner Doyle a question. Was when you mentioned making the definitions of working relationships consistent, were you intending that those definitions would be in this document too?
I assumed they would bring all that over. Did you?
I did too, but I just want to make sure that was what your
Okay.
thought was. So
Then-
if those are brought over, I know it creates a long document, but if those are brought over, then we wouldn't need this line.
Okay, thank you for that point
I
of
think that makes it
clarification.
cleaner instead of having to now have both. Now you absolutely have to have both because there's a reference, you know?
Okay.
So I think just take that out, put the whole definitions in this document, and there we have it.
Okay, so just to clarify, since I'll have to be making these changes, when you guys are referencing the definitions, you are also meaning to include the duties and obligations section on that second page
Yes,
where it lists out all of the duties and obligations?
correct.
Okay.
It's good for the consumer at that point, then they have a full understanding of where they're at, even if they only get this BD 24.
Yes, great. Okay, thank you. I just need that clarification. I make sure I include the right information.
Okay. Okay, so thank you. Now that do we have any other commissioner comments or questions? Okay, so let's turn it over to the stakeholders. If anyone has a comment, please raise your hand virtually, and you have 3 minutes.
Any members of the public that would like to address these documents? Yes. Eric, I've asked you to unmute.
So this has been a point of confusion forever, to be honest with you. The BDB 24, which used to just be the BD 24, and the definitions. Folks, agents have used definitions as their disclosure for a long time. If you're going to put everything from the definitions of working relationships into the BDB 24, then perhaps what you need is a BDS 24, broker disclosure to seller, and get rid of working relationships. That takes the confusion out for the agents. Just a thought, because right now you've got two forms that say the same thing, and it's created a lot of confusion. Second point would be, I didn't understand the reason for getting rid of the compensation page, making that an option. Can that be clarified?
Erica, do you want to?
Yeah, we had requests for this when they were coming up with it. They've had requests for this in the past, but if you are checking the box that you are a seller's agent and the buyer that's walking through the door is just a customer, so you are paid just by the seller, the buyer broker compensation agreement is potentially not at all in play. You don't need to have that there. And so then your option is to just cross that off or still have to review this. It can be very clean if you just have the document that you need, which is the first couple of pages. You don't need the rest of that.
All right, thank you. That makes perfect sense. I appreciate that. I missed it. And that's all. Thank you.
Thank you, Eric. Any other public comments?
Any other hands at this time? Not seeing any commissioners.
Okay. Well, what we can do right now is, can I have a motion to adopt as amended the broker's disclosure to buyer definitions of working relationships?
motion to accept as amended.
Okay, can I have a second?
Second.
Any more discussion? Okay, so just for clarification, and record purposes, the motion that's on the table is to retain the definitions of working relationships content, to include, the entire definitions and, remove the section that says buyer can refer to the definitions of working relationship disclosure document for additional information regarding brokerage relationships. And we are also going to create a version that removes the compensation. So that's the motion that's on the table. And just one more ask if there's any more discussion. And let's call the question. All those in favor say aye.
Aye.
I,
Any
Aye.
opposed? Any opposed say nay. And the motion to adopt as amended passes. And if you could take us to our next document, Melissa.
I think, and perhaps Irina can jump in to make sure I'm guiding you correctly, but I think it would be helpful to have pretty much the identical motion for the brokerage disclosure, for the other brokerage disclosures, since the changes are the same. I don't know if we have to go through everything again, or if we can make the same motion for these same changes for the brokerage disclosure to landlord and brokerage disclosure to tenant. Or if we need to go through it, each form individually again.
Irina?
If commissioners are clear on what changes will be made to those forms that are almost identical, I'm fine with that.
Okay,
And then,
before you do, Melissa, real quick, hang on, let me just verify. Because there was one thing. Hold on. Where was it? I just had a note on it was on the disclosure to landlord. And I have a note that says, and I was trying to remember why I have this, on page 3 of that. I think, so on page 3, under broker acknowledgement, landlord, okay, never mind. So on mine, I guess on the seller disclosure, seller remains, where this one landlord is struck through. So I was just saying keep those consistent. I just had a note about that. That's more of a clerical thing.
okay.
So I'll just kind of say that. That might be one of those clerical corrections that you guys
I'll
have
make note of
authority to
that
do.
for the clerical. Okay.
Okay, just so that they match, because on one it was struck through and one it wasn't. Outside of that, yes, if we can make that same motion for the broker's disclosure to landlord, and it would be the broker's disclosure to seller FSBO, right? And tenant, would it be all of them?
Well, with the brokerage disclosure to seller FSBO, there were some different non-substantive formatting changes. It's basically just kind of moving around. There were some checkbox issues so just formatting changes. So not anything substantively different. So I don't know, Irina, if that would require a separate motion or if it could go in the same bunch with the disclosure to landlord and disclosure to tenant.
Well, it sounds to me that commissioners are clear on landlord and tenant form, but you suggesting that there is maybe a little bit more discussion on FSBO. So let's do the two, landlord and tenant, together and discuss and see if there is any substantive discussion on FSBO.
Thank you.
Okay. So if we can amend our motion or strike the motion, I hope I'm doing this properly, but if we could strike the motion regarding the broker's disclosure to buyer so that we can include the broker's disclosure to landlord. So can we make a a new motion to make those changes for broker's disclosure to buyer and broker's disclosure to landlord.
I think alternatively, you could maybe make a new motion to make the same changes to the brokerage disclosure to landlord and brokerage disclosure to tenant that you previously approved on the brokerage disclosure to buyer.
Thank you for that. Okay. So do we have a motion?
Okay, motion to approve brokerage disclosure to landlord and brokerage disclosure to tenant with the same changes we made to the brokerage disclosure to buyer.
Second?
Second.
All those in favor?
Aye.
Aye. Any opposed? All right, motion passes.
Okay, so then taking up the brokerage disclosure to seller, the for sale by owner, this, I would propose that you adopt the same changes that you just discussed and approved to the other three brokerage disclosures. On this particular form, there, like I mentioned earlier, there are just some formatting, non-substantive changes. Like there was a portion with the checkbox only where the formatting was just kind of messed up. So again, checkbox only was just deleted there, moved up to just kind of get the formatting in order. So no substantive changes. So at this point, I would ask you guys to make a motion to approve the brokerage disclosure to seller for sale by owner with the same changes previously discussed to the brokerage disclosure to buyer, as well as the non-substantive changes that are reflected on the red lines.
Okay. Can we please get a motion? Erica, you're muted. I see your lips moving, but.
Thank you. Motion to approve the brokerage disclosure to seller for sale by owner with the same changes completed on the brokerage disclosure to buyer, in addition to adding the non-substantive changes.
Perfect. Is there a second?
Second.
All right. All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. We can go to our next form.
All right. Excuse me. So then moving on, it looks like the next form would be the brokerage duties addendum to property management agreement.
Okay.
And on this form, the defined terms were not changed. They were simply moved up to the start of the document for clarity and ease of reading. The proposed change that is probably not reflected on the red lines before you is that in the new paragraphs 2.1 and 2.2, the phrase as defined below would be removed because it's no longer accurate since the definitions were moved up. So it's not a substantive change, just kind of a Scrivener's error there by including that language still in there. It is proposed that paragraph 4.3 be removed, is that again, it contains that blanket waiver of confidentiality that does not meet the new standard in statute. And then again, at the end of the document, there is addition of a line to identify the managing or employing broker's name. Like I talked about previously, just to kind of inform the consumer about all of the brokers that are involved in the transaction or could potentially be involved in the transaction. So those are the only changes there.
Fine to me.
Thank you for that. Any comments or questions from commissioners?
Mm-mm.
No.
Okay, so can we get a motion to adopt the brokerage duties addendum to property management agreement with the noted change, which is striking through as defined below.
Commissioner Sanders, could we just have a brief moment for any comments from the public before you
Oh
take
yeah,
the vote?
I'm so sorry.
Oh, you're quite all right.
I am so sorry.
Anyone
Thank
who
you.
does have
Thank you
any
for
comments from
keeping
the
me on
public,
track.
That's
It's
all
a
right.
long morning already. Thank you, David.
Of
Yes,
course, if there are any hands, please raise them now.
Yes.
But I'm not seeing any, so thank you.
Thank you. Misstep on my part. And just continue what I said. So do we have a motion to approve with that amendment, which is striking through as defined below?
Motion to approve brokerage duties addendum to property management agreement leasing activities with the amendment as stated.
Any second?
Second.
All right. Is there any more discussion? I'll call the question. All those in favor?
Aye.
Aye.
Any opposed? Okay, motion to approve or to adopt is accepted. And we can move on to the next.
Right, the next one up is the brokerage disclosure to seller, the REO non-CREC form. So the provisions of paragraph 2 are proposed to move to paragraph 1. This proposed change is intended to have the pertinent details of the transaction at the beginning of the form, just for the sake of clarity. And the corresponding changes were made to the new paragraph 2. Again, the as defined below was eliminated. The next suggestion is the same one that we covered in the previous brokerage disclosures. Removal of the paragraph containing the blanket waiver of confidentiality, as it doesn't meet the new standards of express written consent. And then below that, again, the expanded statement regarding the disclosure of settlement service costs. That change would just conform this language to the changes made in previous years to the other forms. And then this form.
See a misspelling right there. Broker cannot require seller to use a certain settlement service provider and sellerer.
Okay. Just make a quick note of that. And so on this, then the next change, we just added on to this is not a contract statement. The suggested language is the same language that you guys, I think, ended up not including in the other disclosures, which is just referring them to the definition of working relationships for further information. And then again, below that, it's again the suggestion of the employing broker's name. And then on that red line, there's a suggestion to put in signature. I don't think it's actually necessary to add signature. And when you're filling out a contract, just the identity of the person that is signing the document is sufficient. So not really anything substantive, but I just think that's an unnecessary change that I'll leave out if you guys are okay with that.
And we I just thought about this on that last document. Did we strike through the managing employing broker's name? I don't know if we put that on the record because we removed it from the other, or we kept it removed from the others.
I think on the last document that stayed in. And I think the difference with these documents, that the last one and this one, is there's already a spot for the brokerage firm's name, which that to me doesn't contemplate a signature by the brokerage firm. It's just informational. So I think the managing employing broker's name also is just informational. I don't think that there's an expectation that there's a signature.
Okay, so we're going to strike through signature.
That. I'm sorry.
So you were saying strike through the signature.
Yeah, just after broker's signature, I just think that's unnecessary. You don't need to have the word signature there.
Okay, thank you. I agree. Okay.
Yeah.
And are there any comments or questions from commissioners?
Mm-mm.
No.
Okay, well, let's take it to public comment. If we have any stakeholders that would like to speak, just raise your hand virtually and you have 3 minutes.
If there are any members of the public, please raise that hand icon now.
Mm-mm.
No hands at this time.
Okay, well, thank you. So at this time, can I have a motion to, well, regarding this, can I have a motion regarding the proposed forms?
Motion to approve as amended. The broker's duties, disclosure to seller.
Do I have a second?
Second.
Okay. Any discussion? And I will just clarify that the amendment would be removal of the broker signature at the end of the document. And also actually, can I see the page numbers on your screen? Because it looks like mine's are off. And then correction of the page numbers.
Yeah, I think sometimes when you accept the changes, that self-corrects.
Okay.
But I'll make sure that on everything after the red lines are accepted, that the page numbers are accurate.
Okay. So that is the motion. We've had discussion. All those in favor say aye.
Aye.
Any opposed? Okay, motion to adopt as amended has carried.
Okay, so the next form is the change of status form. And on this form, there's obviously a lot of new proposed language. And this new language is added with the intention of making it consistent with the changes to the brokerage relationships, the definition of working relationships. Sorry, my brain is already kind of falling apart here. So all of that language on the second page there, that new language is consistent with the language that we've discussed in the brokerage disclosures and the definition of working relationships. But just going through this individually, at the top of the form is the proposed addition of the disclaimer regarding the important legal consequences. For the document, that's the same disclaimer that you'll see throughout many of the commission forms. The language added in the note section is language that has been moved up from a later point in the document. The titles of the parties have been capitalized. The language in that deleted paragraph below that has been moved to other locations in the document. There is a proposed addition of adding property to be a defined term to mean the specific address listed. And then below that, the added language is intended to explicitly clarify that the broker and buyer or seller has entered into an agency relationship originally. And then the corrections below that, it just accurately reflect the names of the contracts. And then, as I said before, all of the language added on page 2 is explanatory language intended to inform the consumer of the full implications of the change in the brokerage relationships. And then the language added at the bottom of page 2 was just moved down from earlier in the contract. And then the changes to the signature block were just kind of broken out to have a specific place for the seller and the date, and then the buyer and the date.
Okay. Thank you for that explanation. And those are all the changes, correct?
Correct. Yes. Sorry.
Okay. And commissioners, did you have any questions or comments regarding this form?
No.
No.
I only have one. It's just a typographical error and it's at the bottom header or footer, I'm sorry. There should be a S for change of status. I mean a C. Oh goodness. A C.
Okay.
A C for change of status.
Got it. Okay.
Okay. Well, we can go ahead and invite public comment. If we have any members of the public or any stakeholders that would like to make comments on this form, please raise your virtual hand. And you have 3 minutes.
We do indeed. John, I've asked you to unmute.
Hi, thanks for taking the call. This is John Went, Coldwell Banker Mesa Morris over in the western slope of Colorado. And I believe that this form, it says the disclosure, I think this should say this notice rather than a disclosure, because you're really notifying them that you're changing your status. You already got permission in the listing contracts that you work through, whether it be the buyer agency contract, exclusive right to buy or exclusive right to sell, about the possibility of a change of status. Now you're just giving them notice that that's occurred and what the relationship is, with the other, that you've defaulted to being a transaction broker. So I believe it's a notice more than a disclosure. That's my opinion.
Thank you, John. Do we have any other comments?
No other hands at this time, no.
Okay, commissioners, did you want to discuss that recommended change? And what he was recommending is it would still say change of status, transaction brokerage notice, right? Did I say that right, John?
Yeah.
Not sure if he's still on. That's how I understood the question.
I agree. I think that's exactly what he meant. If it's just a notice, does that mean we need to have him sign this, or it's just giving them something to state that?
Well, while I appreciate the comment, I define them similarly when it comes to, documents. But yes, I think to your point, Bernadette, when you hear notice, it's more of I'm giving you information, but you're not agreeing to it, where a disclosure requires you to agree to it.
Sign
So
it.
there's a signature
Yeah,
element of that, where a
in my
notice,
mind,
I mean, it's almost, apples to apples, honestly, to me. I'm okay with it still saying disclosure because I don't think we're so far removed from that definition. But would be interested in, if anyone else would like to visit that change.
I think of notice as not needing a signature and disclosure is needing a signature so that they're aware of it. So I would stick with disclosure.
Any other comments from commissioners?
I don't think I have a strong opinion either way. I'm kind of similar thought to Erica that it's not a strong change one or the other, or one way or the other. I'm okay leaving it as is at this point.
Okay. Well, that will end the comment section of this, and so we'll go ahead and motion. I would invite a motion in regard to this proposed change of status form.
I motion to accept
Except as amended, because
accept as amended.
Okay. A second?
Second.
Okay. Any more discussion? And I'll just note in this discussion segment that the only amendment is making the correction in the footer. I'll call the question. All those in favor?
Aye.
Aye.
Any opposed? Okay. Motion to adopt as amended is accepted. And if you don't mind, let's go over the next contract.
Melissa, you appear to be muted.
Thank you. I was trying to cover up my coughing. Got to turn it back on. So the next form is the Common Interest Community Disclosure, and that is a proposed new form. This was something that came up as a global list suggestion. And during that global list review, the commission tasked division staff with kind of just trying to come up with a proposed draft for your review and approval. And so division staff, including the HOA information officer and the other staff members involved in the HOA office, including Mr. Donnelly, we worked on creating the draft that is before you today. This draft was also presented to a couple of different attorneys who specialize in HOA work that were willing to just kind of volunteer their time and take a look at it and lend their expertise and input. There's also been stakeholder feedback on this draft provided both in writing and orally at the previous stakeholder engagement meeting. So I know there is some written feedback that was provided to you guys prior to meetings. So hopefully you've had a chance to look at that as well. So that's kind of it. That's what present this to you here for discussion purposes to see if you guys have any specific thoughts on it, any changes you'd like to see, or if you would, you don't have to go with this form at all. You can go in a different direction. So I'll just open it up to commission discussion and public comment.
Thank you, Melissa. Do any of my fellow commissioners have any questions or comments?
The only comment I have is in the check boxes down below. It says initial the boxes. They look more like they'd be checked. I don't know. There's not enough room to initial there.
Oh, and there some of the feedback that we received that initialing those statements would be better than a checkbox because it just kind of requires more intention. So one thing we could do is change those checkboxes to lines for initials instead.
Yeah.
Sorry. Okay. So it doesn't sound like we have any question comments from commissioners. I will say I really appreciate the hard work and time put into this. I think it still needs some work. And I would love to open it up for stakeholder comments. So let's just go there if there's no other commissioner comments.
Certainly, it looks like we do have a hand here. Connie, I've asked you to unmute. Looks like we have you unmuted, but can't hear you yet, Connie.
Were you ready for me to speak? Sorry, I missed that last part, David.
Yes, absolutely, Connie. Go right ahead, please. Thank you.
Awesome. Well, so good afternoon, commissioners. I'm Connie Van Dorn, an 8-year HOA homeowner advocate. I served on the HOA Homeowner Rights Task Force. I'm a member of several HOA homeowner advocacy organizations, served on multiple HOA boards in every position except treasurer, and have served on Community Association Institute's Rocky Mountain Chapter Board of Directors. Here's why I'm here. Every year in Colorado, people sign their names to mortgages they've carefully shopped, inspections they've thoroughly reviewed, and title commitments their attorneys have explained. And then they move into a community where a private corporation can fine them, restrict how they use their property, and ultimately foreclose on their home And nobody told them that in plain language before they signed. Colorado has no minimum education requirement for board members making those decisions, no regulation of the management companies executing them, no guarantee the documents a buyer receives are complete or accurate, and no requirement that any of this be explained to a buyer before they close. The common interest community property disclosure fixes that, not by adding regulation, not by creating new legal rights, not by increasing governmental oversight. It simply requires that before a buyer signs, they see and agree to plain language statements confirming they understand what they're getting into, that they can be fined, that they can be foreclosed upon, that any reserve fund may be underfunded, that the rules can change. In a state where housing costs have pushed homeownership to the edge of affordability for many families, the least we can do is make sure that when someone stretches to buy a home in a common interest community, which is increasingly the only option available to many, they know what mandatory membership actually means before they close, not after their first surprise assessment. The form doesn't protect people from HOAs, it protects people from not knowing. So thanks to the division for bringing it forward and to the commission for considering. I respectfully ask for the commissioner's support in securing the ultimate adoption of this form for all home sale closures.
Thank you for your comments, Connie. Do we have any questions for the speaker? Okay, if no other questions, if the next person would like to speak or make comments, if there are any.
A few other hands, yes. Eric, I've gone ahead and asked you to unmute.
Thank you. I forgot to tell you earlier, Eric Edwards, I'm with Remax Alliance. So it seems like a lot of redundancy to the section 7 of the contract to buy and sell. You have the statement in bold print already stating a lot of what's already in here. So that's just, as you consider this form, is there going to be redundancy? A lot of it. Second would be, how do you implement this? Is it a requirement at the time of contract? Is there something that needs to be in the contract to buy and sell that references this form? Because otherwise, how do you make sure it is actually implemented? Because if they're writing a contract to buy and sell, shouldn't they have that form in advance if you feel if it's an important form? Thank you.
Thank you for your comments, Eric. Any questions for the speaker? If none, we'll move to any other questions.
Yes.
Or comments.
John, I've asked you to unmute.
Yeah, John Went, Coldwell Banker Mason Morris. I'm a little nervous about the form that it has check boxes and it says, I understand by signing below. So my question of it is thinking from perspective in our area, if a lawyer gets a hold of this form after closing because there's issues and says they didn't check the boxes that they didn't understand, are we going to, I think the disclosure form is great. I think the check boxes don't make sense to me because if they don't check it, I think that's going to be the issue that's going to come up, that they gave them a form that they didn't understand. And now we have an issue in the future regarding that specific form that it's in the hands of a possible lawyer and possibly going to court because of did they sign something they didn't understand or explain to them if the check boxes aren't checked. So I like the form. I would get rid of the check boxes and initials.
Thank you for your comments. Any questions for our speaker? If none, let's move on to any other comments or questions.
Any other hands? Please select that icon at current time so that we can identify you. But no hands at this time, commissioners.
Thank you. Okay, well, we can make a motion in regard to this proposed form. So I will invite a motion and then we can have discussion. Do I have a motion?
Motion to accept the form.
Okay, do we have a second? I'll second. And any discussion?
So I had some notes on it. I think, thank you for all the work that went into this form for sure. And we had an alternative form that was suggested, which gave me, just some pause on the overriding goal, because one form was definitely driven at more of a warning type form. And then the other form was geared towards data collection. And so I thought maybe we would talk a little bit more about, when we don't have to at this moment, but the overriding goal of what we wanted to do on that. Was it a warning disclaimer, or were we trying to get more information for that buyer? Because this form wouldn't do that. And then also, I do believe that our purchase contract does an excellent job of warning buyers and telling sellers what they need to provide in Section 7. And then our SPD covers quite a bit too. So when we've got this overlapping information, we do have that there. So the combination of the two forms might be beneficial if we took a little more time and kind of looked at what it is we want to do there. Neither was certainly comprehensive. And so are we going to be making this mandatory? That was a question of mine. I did think the recommendations of removing the checkboxes, I think, would be critical, because I see exactly what John's talking about there, which would be problematic. The other form reminded me more of an SPD, and it was a lot of work that person put in, but it would also be a lot for a seller and a buyer to go through. So I don't know if we wanted to get quite that detailed in there. I don't know. So I just had a lot of questions, honestly. I think we're heading in the right direction. I really do. I just don't know if I was fully behind this specific one moving forward with at this time. So I don't know, what is everybody else's thoughts on some of those potential issues?
Thank you, Erica. And my thoughts are kind of similar to yours, to be honest. I like the idea of having a disclosure. I think that this one has some language that is complicated. An example of that is like paragraph 2. It's just like sunshine laws. The general public doesn't know what that is. I think that there's some other areas. For example, it mentions let me find it. It mentions, that I forgot somewhere in here. I'm sorry right now, but there's voluntary associations, not all associations. There's some associations that it's voluntary to participate. That's not reflected here. And I like the idea. I agree that this isn't quite it, and I would love to maybe have a little more involvement with the stakeholders and try to come up with something that seems to be more comprehensive for our industry. But I think this is a good start. I just agree that I don't know that I'm in love with this one just yet as written. I think that we can really make this simpler as well, with still providing, a potential buyer with very important information. But I do think that this overwhelmingly, to me, trying to put myself in a consumer's position, I felt it was complicated and confusing. And it did just kind of seem like a warning instead of more of a disclosure. And so I think that we can make this better, but I don't think it's quite there yet, in my opinion.
This, to me, it seems redundant because we're already disclosing that there's an HOA and there's an HOA fee, and then in the schedule, there's due diligence to review HOA docs, right? And if the buyer chooses not to review that stuff, I mean, there's only so much handholding you can do, or a broker doesn't review it for them. I just, it seems like it's more paperwork. I don't know. That's
Well,
because
and
it is already out there that there's an HOA or multiple HOAs.
And in defense a little bit, there are some elements to this that aren't really well communicated. For example, the fact that an HOA can foreclose, maybe that's not completely understood. I think there's some good things in here. I just think that we probably need to hone in on the important takeaways here and kind of not do the redundancy, as you guys are saying.
Yeah, at the minimum, I do agree about the check boxes. Those need to be removed because if someone doesn't check one,
Mhm.
then what? And they're saying they don't understand that particular element. And then if it becomes an issue later, then what? There's going to be a lawsuit.
Yeah, and like I said, there's some really good aspects here. I think we need to work on it a little more. Bernadette, any thoughts?
Yeah, I mean, I don't know. So, they're moving away from a lot of HOAs and putting them into metro districts at the same time. I mean, there's some that have that. How does this play into something when it's moved into a metro district or the covenant? They're like kind of like the covenants. Um, and what I'm not 100% sure is if when it does do that, can they still foreclose on a property? So I guess that maybe I do have some questions on that, I suppose. Or just more clarification on that, if that is the case. Um, I don't know.
I think that's a good point and you being a public member reading this are kind of demonstrating there's a little bit of confusion. So,
Yeah,
um,
I mean, I don't know. I hear a lot of people talking about wanting to get rid of HOAs, and what if there is a situation where they do get rid of it? How does that would that affect any of this? Do you know what I mean? Like, is there, I don't know.
do you mean on a particular property?
Yeah,
Like if a community votes to no longer have an association, is that what you mean?
mm-hmm. Yeah.
Well, like I said, I appreciate the work that's done here. I'm not opposed to having some sort of disclosure regarding HOA because I do think there's some things that we're not touching. Um, I just think this is a little confusing to the consumer, and I would like to work on it. So I'm gonna now ask the division your thoughts on our comments in terms of it sounds overwhelmingly like we're not completely behind this, but we're not opposed to something. So maybe give us your thoughts on our next steps.
If you want to just kind of not adopt this and tell us to work on it more, we can do that.
And then maybe to work on it more, um, what would that look like? Would we just do, because I think probably what's needed is the engagement on it, right? Some comments from the brokers, from the HOA community, just public. So would this be something that would be open to stakeholders, I'm sorry, to comment on and help us make this document better?
We can do that. I mean, we've previously done it. It was part of one of the stakeholder meetings, but
I know.
we could do a stakeholder meeting specific to this. I think we need to flesh out like HOAs, and David can correct me if I'm wrong. HOAs typically don't become a metro district because a metro district is kind of a quasi-government organization. So you're typically not seeing that. But we can take the feedback that we've gotten here today and we can just kind of add this to the global list of what we work on in 2027 and maybe do a special stakeholder meeting just for this form.
Okay. Because, while I see what, and I understand that about the metro districts, but if we're going to talk about HOAs, right, there's that element that is very real in Colorado that's not even mentioned here. So that's why I think it needs a little work. And I would love that if we could just have a little more engagement and create something that is going to be a little bit more suitable. So I guess, do we have a motion? I mean, we can motion to reject or table or adopt, but can we get a motion in regard to this document?
I think we had a motion. Does Bernadette want to withdraw her motion?
Yeah, let's
Oh, do we? Okay, thank you.
withdraw the motion and maybe make a motion to, I guess we would table it so that we can do, there can be more work on it.
Okay.
Is
Yeah. So
I think
motion to table.
yeah.
Do we have a second?
Second.
Okay. I'll call the question. All those in favor of tabling this document until we can have a little bit more stakeholder involvement?
Aye.
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 Any opposed? Okay, so motion to table this passes, and we can move on to our next document.
Okay. So the next three documents on the list, actually, I'll take together. And those are the deed of trust, due on transfer creditworthy, deed of trust assumable, not due on transfer, and deed of trust due on transfer strict. So these three forms were up this year for substantive review. However, division staff doesn't have any substantive changes to propose at this point. So the only changes that are proposed on the red lines that you see are the updated IP language changes. So that's all for those three.
Okay, thank you. Any questions from my fellow commissioners?
Nope. That makes it easy.
Yep. Can we open it up to public comment, David?
Certainly, if any members of the public have any comments, please select that raise hand icon at this time. No hands, though.
Okay. So our motion on this one would be for all three. So does anyone want to make a motion?
I'll make a motion to approve as amended.
Okay.
Second.
Actually, it would be approved as written, actually, on this one, or adopt it, because there's no changes, right?
To the header, there was.
Oh, the header, sorry. Okay, sorry about that. Yes, thank you. So motion to adopt as amended. We had a second by Erica.
Yes.
Okay, any discussion?
Nope.
If no discussion, I'll call the question. All those in favor, say aye.
Aye.
Any opposed? Okay.
All right.
Motion is accepted.
Was there any public comment related to these?
Oh, I did ask that.
Oh, you did, sorry. Okay.
Yeah, I did, yeah. And if we can go through the next one.
All right, so the next one is the dual status disclosure. This is a form that hasn't been updated in a very long time. So the proposed changes really just update the form to use the current terminology and statutory citations. The term mortgage broker is no longer used. The correct term has been mortgage loan originator for quite a while, so that change is made. Similarly, the MLO program is no longer a director model program. Regulations now accomplished through the Board of Mortgage Loan Originators, so that change is reflected. At the bottom of the page, the statutory citations are updated to the correct citations. And then in looking at the broker acknowledgement on the last page, it looks like the line to identify the name of the buyer broker has been deleted. And I can't really tell by just looking at the red lines now. So if that was in fact deleted, I think that was inadvertent, and I'd like to just put that line back in there, identifying the borrower, because I think it's important to identify that person. So that would be, I guess, a potential change, but non-substantive. That would probably fall into the kind of Scrivener's error corrections. So those are the only changes.
Thank you. And commissioners, do you have any questions or comments? I only have one comment, and that's again in the footer. Just a reminder to make the correction there too.
Oh, good point. Thank you.
Sure. Okay, can we open up comments from the public?
Certainly, if any other members of the public have comments, please raise that hand icon. I'm not seeing any hands though, commissioners.
Okay, thank you. Well, I'd entertain a motion to adopt this form.
Motion to adopt the form as presented or as amended.
Do I have a second?
Second.
Okay, any more discussion? All those in favor, say aye.
Aye.
Any opposed, say
Aye.
nay. Okay, well, with no one opposed, motion passes to adopt.
Okay, so then we move on to the earnest money promissory note. On this form, there's just the addition of the disclaimer. That's the standard, excuse me, the standard disclaimer that we talked about before, advising the consumer about the importance of seeking legal advice. It's proposed to move up the address of the property that the earnest money is related to the top of the contract, just to make it more easily identifiable what property the document pertains to. The subsequent red lines under that are just formatting fixes. And then going down to the signature blocks, there's a proposal to add signature blocks for corporation and partnership to make it consistent with other promissory notes. And that's it.
Thank you. And commissioners, do you have any questions or comments regarding this form?
Okay.
If no commissioner questions or comments, can we open it up to the public, David?
Any members of the public with comments, please raise your hand. No hands at this time, though.
All right. Well, does anyone want to make a motion to approve this document?
Motion to approve the document as amended.
Second.
Okay, all those in favor say, or sorry, any more discussion?
Mm-mm.
All those in favor say aye.
Aye.
Any opposed, say nay. Okay, motion to approve this form is accepted. And we can go to our next form.
Okay, that one is the exchange addendum to contract to buy and sell real estate. There's a suggested change to the title simply for clarification purposes. Then following that, those are just formatting changes. Moving down to paragraph 4, the substance of the paragraph is the same. The proposed changes are merely intended to reword for clarity and ease of understanding. And then down below that, that proposed change just fixes the incorrect spelling of the word exchange. And that is it.
Thank you. Any questions or comments from my fellow commissioners?
Nope.
All right, well, let's open it up to public for any comments.
If any members of the public do have any comments, please raise your hand. Seeing none.
Okay, well, with no further comments, I'd like to welcome a motion.
Motion to approve is amended.
Second.
Okay, thank you. All right, so motion is to approve this form as amended. Any discussion? All right, let's call the question. All those in favor say aye.
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 Any opposed say nay. Okay, with nothing opposed, motion to adopt this form as amended is accepted. And we can go to our next form.
Sorry, I was trying to wait for a cough. The next form is the exclusive brokerage listing addendum to the listing contract. Paragraph 1, that is just intended to be a non-substantive change for ease of reading. In paragraph 7, proposal is to change the word commission to compensation for consistency with the new language implemented in all the commission contracts. And then the changes in paragraph 7.2 and 7.3 are simply updated paragraph references that reflect changes previously made to the listing contract. And that is all.
Okay, thank you very much. Do we have any questions or comments from fellow commissioners?
Nope.
None.
Okay, if no comments, let's open it up to the public. David, if you don't mind.
Any members of the public, please raise your hand if you have any comments on the exclusive brokerage listing contract to listing addendum to listing contract, excuse me. However, there are none.
All right, thank you. Well, since there are no other comments, I would like to welcome a motion to adopt the form.
Motion to adopt the changes on the form.
Thank you. Do we have it? Okay, perfect. Any discussion? All those in favor say aye.
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 Any opposed, say nay, please. All right, with none opposed, the motion to adopt is, or I should say, the motion to adopt passes.
Okay.
Okay, go on our next one.
All right, so the next forms on the agenda are the listing contracts, and the changes are the same in all of them, except for one minor change to one of them, which I will cover. But just to keep us moving time-wise here, I'll take up the 4 contracts together. Those are the exclusive right to buy listing contract, the exclusive right to lease listing contract, the exclusive right to sell listing contract, and the exclusive tenant listing contract. These forms were not up for review this year. As we know, we looked at them last year, but there was the implementation of House Bill 26-1287 that necessitated changes to these forms. So in all 4 of these forms, the same change was made in paragraph 5.2, which reflects that the standard of consent for the disclosure of confidential information has been lowered from informed consent to express written consent. And again, that's based on HB 26-1287. So that change is reflected, as I said, in all 4 of those documents. And that is the only change that is made across the board. In the exclusive right to lease listing contract. There was just an error that was fixed in paragraph 9.4. The term seller is used instead of the term landlord, which is the appropriate term. I think it just somehow when all the forms were probably copied and pasted at some point in time, the wrong term was used. So that's all the changes to those four.
Yeah, okay. Thank you very much. Do we have any questions or comments from fellow commissioners?
My video is not working right now. I don't know why, but I am here.
Okay. If there's no questions from commissioners, if we could please open it up for public comment, David, if you don't mind.
Absolutely, commissioners. Thank you. Jim, I have asked you to unmute.
I just want to, this is Jim Smith from Century 21 Golden Real Estate. I just want to reiterate what I said before, which is that in these contracts that don't have MEC type of dating, and there's only two dates, the date it's signed and the date it expires, there's no reason to have 3.9.2 include a provision that if the date is on a weekend or holiday, it should be extended. That's all.
Thank you, Jim. Any other public comments?
Yes, bear with me for a moment here as I make some clicks, but David, I have asked you to unmute.
Hello, I'm Dave Alpin. I'm an instructor with Armbrust Real Estate Institute. I guess I'm not understanding. You want to change or 9.4 from seller to landlord? Is that not under or carrying through from 9.3 where it's simply talking about the seller? I'm not sure why you're changing that to landlord. Oh, because I'm sorry, because the 9.3 is now specifically references the landlord. And the only copy that I'm used to still references the seller. So I'm sorry, I didn't see that. I thought that still referenced the seller. So excuse me, that's specific reference to the landlord. So I see the change. I understand.
Thank you, David. Any other comments?
Any other hands on these documents? Not seeing any though, commissioners.
Okay, if no other public comments, before we call the question, let's address the concern that was brought up in regard to the MEC.
So tell me if I'm wrong, and it's already been a long day, but in 3.6, you could technically put in MEC plus a couple of days. So then it would be valid, or just MEC, and it could fall on a holiday or weekend, and therefore 3.8.2 would still need to remain.
Yeah, that's kind of my thought. I get it, because like for me, I don't necessarily use that clause, right? I don't need to extend it or whatnot, but for those that do use that and do want to make sure it doesn't fall on a holiday or Saturday or Sunday, you can mistakenly, especially holidays. I think Saturday and Sundays, a lot of us can catch that, but holidays sometimes are hard because it may be a holiday that doesn't fall on the same day all the time and you just miss it. So there's still a place for it, you know, for those that
I don't think it hurts to be in there, you know, when you need it. I don't think it hurts.
Yeah, but I do get the point that was raised for sure. So let's go ahead and open this up for a motion to adopt. And this would be, just for reference, this would be the exclusive right to buy, exclusive right to lease, and exclusive right to sell. Correct, Melissa?
And the tenant listing contract.
Oh, an exclusive tenant listing contract. And this would include the corrections to the exclusive right to lease, I think it was.
Yes.
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 Okay, so does someone want to make a motion to adopt all 4 of those?
Motion to adopt. Go ahead. Exclusive right to buy, exclusive right to lease, exclusive right to sell, exclusive tenant listing contracts.
Great.
I'll second.
Perfect. Thank you. Any discussion?
Nope.
Let's call the question. All those in favor say aye.
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 Aye. Any opposed say nay. All right. With no opposition, motion passes to adopt all 4 of those contracts. And we can move to our next contract.
Okay, the next contract is the Green Disclosure Energy. And this is another form that hasn't been updated in a long time. In this case, I think it's been about a decade. And I think it goes out saying that green energy features have progressed since then. So to obtain expert advice about potential revisions, we reached out to the Colorado Energy Office, whose staff took the time to complete a comprehensive review of the existing form, and they really provided very thoughtful, extensive feedback. And that helped us update the form, hopefully to current standards and practices, and really allow this form to actually be a helpful tool for sellers to use to disclose the green features of their property. As you can see, there are numerous proposed additions to the substantive part of the form to include the updated energy features that were suggested by the Colorado Energy Office. So I won't go through each one of them individually, but hopefully you had the chance to look them over. Going back up to the top of the form, the initial paragraph has been deleted because it's duplicative, as it's stated below at the end of the form. We propose to delete the date, property address, seller, because that information is all already contained in the form. And then moving on to page 3 of the form, the proposal is to delete that first paragraph. The first line, this is merely a disclosure by the seller that's made clear that it's filled out by the seller and not the broker. The second 2 lines, the substance has been incorporated into paragraphs 1 and 5 of the advisory to the buyer. And then in paragraph 5, which I think trying to figure out if looks like the numbering is thrown off there. So I'll make sure that that numbering is fixed correctly. But what's showing up is paragraph 6 on the screen there. The proposal is that the second line will be deleted. And it looks like my notes are from an updated version. So the language there, I don't need to read it. It's already laid out there. So delete that second line and then just replace it with the line that's there on your screen. And the reasoning behind that was it's just a more accurate statement, as this disclosure doesn't state any information about the condition of these items. That existing line looks like it maybe was a cut and paste from the SPD, where there is information about the condition of the items, but that doesn't really fit the content of this form. And then on those last pages, those are all just definitions, and those definitions have been updated to include the new terms that were added to the form. So that is it.
Thank you very much. And commissioners, do you have any questions or comments in regard to this form?
No.
Okay. Can we please open it up for public comment? David, if you don't mind. You're muted, David.
Oh, you'd like to hear. I'm sorry. if there are any members of the public that would like to discuss the green disclosure for energy, please do select that raise hand icon. No hands at this time, though, commissioners.
Thank you very much. Well, if there's no public comments in regard to that, I invite a motion to adopt the green disclosure form.
Motion to adopt as amended.
Okay, so Tom has a motion to adopt, and then do we have a second?
Second.
Okay, Erica with the second. Any discussion?
Mm-mm.
All right. Well, let's call the question. All those in favor of adopting, say aye.
Aye.
Any opposed, say nay. And with none opposed, motion carries to adopt the green disclosure. And we are ready to go on to the next form.
Okay, and the next one is the homeowner warning notice, right to cancel.
Okay.
And really, there are only minor proposed changes to this form for the sake of clarity. It's proposed to add that standard disclaimer at the top of the form about the important legal consequences. And then note at the top, the word "the" is changed to "this." And then below that, the reference to contract is just expanded out to clarify that what is being referred to is the contract to buy and sell residential Colorado Foreclosure Protection Act, as the full name of the contract hasn't been previously used in the document. And those are all of the proposed changes.
Thank you very much. Commissioners, do you have any questions or comments?
Mm-mm.
Okay. If none, let's go ahead and move it over to our public comments.
Any attendees with comments on this document? No hands, commissioners.
All right, with no public comments, let's go ahead and get a motion to adopt this form as presented.
Motion to adopt the form as it's been presented to us.
And do we have a second?
Second.
Any discussion? All those in favor, say aye.
Aye.
Any opposed, say nay. With nothing opposed, the motion to adopt is approved. And we can go to the next.
Okay, the next one is the inspection resolution form. And there is only one proposed change to this document, and that's in paragraph 3. In that paragraph, there's a reference to the damage, liens, and indemnity provision in the CBS, which is paragraph 10.4 of the CBS. That provision uses the term work and defines it narrowly, which doesn't include correcting or resolving the unsatisfactory physical conditions. So the reason for referencing that paragraph 10.4 in the inspection resolution was unclear. The proposed change makes it clear that there is no automatic obligation that the seller must bear the cost of repairs, but it does maintain a presumption that it will happen, since that is common practice.
Thank you. Any questions, commissioners, or comments? All right, with no questions from our commissioners, let's open it up to the public comments.
Members of the public, if you have any comments, please select it for the raise hand icon. No hands.
All right, with no public comments, let's go ahead and get a motion. So will someone make a motion to adopt the inspection resolution?
Motion to adopt the inspection resolution as
Second?
presented.
Do we have a second?
Second.
Okay. And any discussion? All right, with no discussion, let's go ahead and call the question. All those in favor say aye.
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 Any opposed say nay. And Motion to adopt passes.
Okay, that moves us down to the landlord's disclosure of information on lead-based paint and the seller's disclosure of information on lead-based paint. Since the same changes are proposed to both of these documents, I will take them together. So I'll dive right in. The first change that you see on this form is just a change to the title to make it more descriptive of the purpose of the form. The next suggestion is to insert the date of the CBS that the disclosure is an attachment to, just simply for sake of clarity and ease of reference in case there's been more than one contract related to the property. Based on information received from the EPA, we are proposing to update the fine to the current amount, which is $22,263, and that is subject to increase in the future to be adjusted by for inflation. And then that heading below that, disclosure of information on lead-based paint and/or lead-based paint hazards is proposed to be removed since it's no longer necessary with the expansion of the title of the form. And then the remainder of the suggested changes to the form were made to match the changes that the EPA made to their sample form. And the stated purpose of those changes by the EPA was to provide greater clarity and specificity. These changes include the current version of the form asks sellers to explain their knowledge regarding lead-based paint and hazards. The changing of the language to describe what is known about the lead-based paint and or associated hazards present is intended to elicit more information and detail from the seller so that buyers and renters may be better informed about the existing lead-based paint and lead-based paint hazards prior to buying or leasing housing. There is a change to indications for sellers, purchasers, and lessees to initial the form rather than using a check mark. This is intended to increase clarity regarding who is responsible for the disclosure and acknowledgement parts of the form. The updated forms also allow renters or buyers to indicate whether they received all records and reports related to lead-based paint or lead-based paint hazards in the housing, such as lead-based paint inspection or a lead-based paint risk assessment report. Previously, renters or buyers could only confirm if they had received copies of all of this information. And then below that, there are updates to the real estate licensee's acknowledgement portion of the form. Now, we've received a lot of feedback on the proposed changes to this section, with people expressing concern regarding whether a buyer or tenant's broker had the ability to ensure a seller's compliance with their obligations under the law. The proposed change was intended to highlight or clarify that based on federal law, a buyer's broker may have some responsibilities to ensure the proper disclosures have been made by the seller or seller's agent prior to allowing their client to become obligated under a contract. So we've read over the feedback, listened to the concerns, and we've tried to work to address those concerns and have come up with proposed new language to replace those current red lines under the buyer's acknowledgement. So the proposed new language is essentially going back largely to the original language that existed with just a slight modification. So I guess the only way to do it at this point is to read it for you guys, and then I can try and highlight what the change is from the original language. So the new proposed language is each real estate licensee signing below acknowledges receipt of the above seller's disclosure, has informed seller of seller's obligations, and is aware of licensee's responsibility to comply with 42 USC 4852D. So this new proposed language shifts the focus away from a buyer's broker ensuring a seller's compliance with their requirements to making sure that each broker is complying with their own obligations under the law which may be determined on a case-by-case basis. The obligations will not be the same for every buyer's broker. Under federal law, that depends on how the buyer's broker is compensated. So again, just to reiterate, all these same changes were made to the disclosure form for rentals and sellers. So that is it.
Thank you very much. And I would like to ask the commissioners, do you have questions or comments regarding this?
I did have some. I just want to double check that what is in front of us now, is this the same? I'm just going through mine. So this is different than what is in my red line.
Right.
Yeah. So I want to read it.
And Melissa, it's just from the real estate acknowledgement on is what's changed, right? That's the only change that we don't have?
Sorry, I was muted. That is correct.
Okay.
Can you
No,
put this up so we can see? I'm sorry.
Sorry. The fine language, I think, is a new change. The change from $10,000 to the 22,263. That's not reflected on the red lines.
Right. Okay. Thank you.
Other than that, it is the change in the broker's acknowledgement or the license.
I see section 8 through 10 on your screen. So we removed 9 and 10 then from what I had, so that just ends at 8. The acknowledgement, I'm just comparing from what I have to what is in front of us now. Okay.
Oh. Yeah.
All right, that is better. Because that was the bulk of my question.
Mine too. I just had one other, this is more clerical. So I have the same concerns. I just wanted to make sure the penalty, I had notes on the penalty and obviously some of the stuff that we just struck through. So remaining are just really simple. And it's just a language thing, and I just want to verify this is how it was meant to be read. For example, section 2 says seller has no knowledge of any lead-based paints and or lead-based paint hazards present in the housing. I just want to make sure that's how we want it to read, because it reads kind of weird, but if that's how it's supposed to read, great. To me, like I was thinking it would say house, but if it's supposed to read in, housing, great. And never paid attention until now. So just want to ask that question. Other than that, the other pertinent things have been addressed.
Let me just confirm it. I think housing is the language that's historically been used in there.
It could be. I really never paid attention until reviewing this.
And then I have a question when you are caught up on that one.
Yeah, housing is the language that's always been used in our form.
Okay, thank you for that clarity.
And I think that just mirrors the language that the EPA uses in their sample forms.
Okay, I appreciate it.
So my question is going to adding the date on the top of the form. We haven't had that in the past, and so sellers, when listing, they can complete this prior to going under contract with all the information that they have. And so it can be provided to a buyer prior to going under contract. It can be provided to a buyer at any point. But if we put this on here, it seems to me like it could potentially cause a delay because now you've got to wait to fill that in until you've got a contract dated on there. And so I think part of the concern of the EPA was they really would like it provided sooner rather than later. And this actually, just by adding that, adds some delay in there.
I can see that point, and I absolutely defer to you guys as the experts on that issue.
I can see that. And I know we'll probably get some comments. I don't know. I know we got some stakeholder comments in regard to the timing of this too. So just, I guess, for clarification, I think we want the ability to be able to provide this right away, but we also want the ability to be able to provide it in accordance to the contract, which allows a date. So I guess the other question would be, would this hinder the ability to be able to still identify a date in which this is due?
Yeah, and my thought, our contract is really good right now. I mean, somebody put a lot of thought into that, where we have a date that is to be provided by. So, if for some reason they didn't have it in advance, it's clearly outlined by when they have to do it. But this is absolutely preventative, that they could do it prior to actually getting a contract in place. And so if it were me, and I'm not an attorney, but I would remove the dated portion there, leave that as it had been, and then allow our contract to guide when it must be provided, because that then sets the timeline for the 10 days for that buyer to tackle whatever they want to do with lead-based paint in that home.
Yeah, I agree. Do any of the other commissioners have any comments on that?
We do not.
Mm-mm.
And bear with me, I'm just making sure I'm not missing anything else before we turn it over for public comment. I don't see anything right now, so if there are no other commissioner comments, if we could please invite the public to comment on this document.
If there are any members of the public, please raise that hand icon and I can identify you. Yes, Eric, I've gone ahead and asked you to unmute.
Hi, yes, Eric Edwards again. So during the stakeholders meeting, they talked about making this mandatory prior to contract. So from what I'm understanding now, we're staying with the way we did it before, or we have been doing it for about the last decade, where we have the dates in the contract, et cetera. So I just want to clarify that that is now what we're doing. And then the second would be, I don't see an issue with having a contract date referenced here, due to the fact that you also have your place below where the buyer's going to fill stuff out after they receive this anyway. So I don't find that to be an issue because it ties it to that particular contract with that date. That's it.
Thank you for your comments, Eric. Do we have any questions for him? I know he asked a question, and that was the thing that I wanted to verify, because we've reviewed a lot of documents over the past few weeks, and I wanted to make sure there wasn't a place in here that illicitly said that we would have to present this prior to contract. And in skimming over it again, I don't see it, but I do want to verify that that's not here. So if anyone else, like Melissa, for example, if I'm missing it, let me know, because I think that is really, really important for most of us, that we want the ability to be able to present this in advance or according to the contract.
Mm-hmm. Yeah, and that language that is being referred to has been removed.
Okay.
I think where it threw up the red flag was in the lead paint obligations, and that language has been taken out, and we'll cover that when we get there.
Okay, thank you.
Mm-hmm.
Any other public comments?
There are no other hands at this time, commissioners.
Okay. So really now the only question is, do we leave the, it sounds like we all approve the changes. So thank you for making those strike throughs, Melissa, you and your team, for listening to stakeholders. And I think most of us have the same concerns. And now the question, do we leave the dates or not leave the date? And I could go either way. I mean, I can see both. I can see that it's kind of like, let's say, I'm going to use an example of is it the closing instructions? Where you can come, like, once you have a contract, you can fill that date in. But I also understand where Erica's saying this is just making it, just that extra step is probably unnecessary. So, let's just get a quick little vote on, do we want the date or not? That way we can move forward. So Tom, are you partial to the date or no date?
Yeah, I can go either way. It's
Okay.
I'll go with the flow on this one.
Melissa, I mean, sorry, not Melissa, sorry. I just saw your name there. Bernadette, you're muted.
I agree with that too. I think it's fine. I could go either way on that as well.
Okay. Well, since I think it doesn't really matter either way, let's just go with Erica's recommendation. I don't think it hurts to remove it. I don't think it hurts to keep it. So, all right. Well, that being said, can we please get a motion? We have several amendments to this, so we would need a motion to amend or adopt this as amended, I should say.
Motion to accept the lead-based paint disclosures as amended.
Can we get a second?
Second.
All right, any discussion?
And for my clarification purposes, that's removing the date, correct?
Correct.
Yes.
Okay.
So motion to, and I think it's confusing because we have a different version. So the motion, yes, is just to remove the one that you have on the screen, remove the date, but you've already made the corrections on your end, so we don't need to amend what we have. That's where I was getting confused because mine is a little different. But so yeah, the motion is just to adopt this with removal of the date. And we had a second. All those in favor?
Aye.
Any opposed, say nay. All right, motion to adopt as amended carries. And we can move on. And sorry, that was for the lead-based paint disclosure rentals and sales, correct?
Correct.
Yes.
Okay, so that just clarifying that motion is for both of those documents. And we can move on to the next
Okay,
form.
that takes us to the lead-based paint obligations landlord and the lead-based paint obligations seller. Again, I'll take these two documents together since the changes that are proposed are the same. Okay. So the first suggested change is the addition of a line that identifies the property at issue at the top of the form rather than its previous location at the end of the form. Changing use of the word shall to must to comply with principles of contract writing, in which using the word shall is discouraged. In paragraph 2, there's proposed changes to the language that mirror the language in the federal law. And then this, trying to look at the date on that. Okay. So this change in paragraph 3, and then I think down in 4 too, that is, the language that goes kind of hand in hand with that change that was struck from the previous disclosures. That was intended to reflect that under federal law, the buyer's broker's responsibilities could vary depending on how they're paid. So I guess the discussion point is if we want to leave that language as is or amend that. And then going down to the bottom of the form, just a kind of a non-substantive change, added in the language of no less than 3 years, just for clarity, as the previous language could imply that the requirement is to maintain records for exactly 3 years. That's it.
Thank you. Okay, any comments or questions from commissioners? I think we probably should discuss 3 and 4. And so we just probably want this to be consistent, right? Is that the sentiment? Does anyone want to comment on that? If we have no comments, we can take it to stakeholders and. Okay, since there are no comments from commissioners, can we open it up for public comment, David?
Certainly, if anyone would like to address these 2 forms, please do select that raise hand icon. Yes. Ray, I've asked you to unmute.
Good afternoon. On this last one, it said record keeping for 3 years. Why keep it? Why not keep it for like the rest of the record keeping rules that we have?
This
or did I hear something wrong?
This particular record, in here, this record keeping requirement, the 3 years comes from the federal law. So that's where the 3 years is instead of the 4 years.
Okay, that's okay then. I just was wondering why it wasn't oh, by the way, my name is Ray Brienza. I'm a realtor with Coldwell Banker. So just to make for the record, but I just thought maybe because otherwise it might get confused down the road. And so I think most people might keep it for the 4 years like everything else, because that's what we're conditioned to. But thank you, Ms. Phelps, for the clarification.
And thank you for your comment, Ray. Any questions for Ray, commissioners? Okay. So, and actually I missed this. I had it highlighted, but I missed it in our comment section. Number 1 of this document should say tenant instead of buyer. And then Melissa, if you can revisit what you were saying about 3 and 4 once more, what your thoughts and recommendations were in regard to that language, since we've made changes to other documents.
So when we were working through these documents, the issue came up with just trying to make it more explicit that our understanding of federal law is that if a buyer's broker is compensated in part by the seller, then the buyer's broker has additional obligations to ensure compliance with all of the obligations under federal law. That could include obligations of the seller as well. And I know that caused a lot of concerns amongst stakeholders about I think these obligations have been there all along, but I guess drawing more attention to these obligations of a buyer's broker. So I just didn't know if this language about like if tenant's broker is paid by the landlord or through a cooperative brokerage agreement with landlord's broker, that is, you know, the related language that goes hand in hand with kind of the discussion on the disclosure. So I just didn't know if that was going to be a point of concern here as well.
Well, and what I remember, didn't the EPA's statement kind of say a little differently too? They like it's on the seller side. That's what I remember reading. So I'm not sure if this is it's very confusing.
It is very confusing. But ultimately, I mean, we all have the communication from the EPA that was provided as part of your materials. So, you know, that was the position that we got. I think not everybody necessarily agrees with that. Not everybody thinks it's entirely clear. So,
and I don't know what I took away from that it ultimately is a seller. So that's why I'm like, I know there was mention, but it just seemed like overwhelmingly the responsibility lies on the seller side. So that's why I'm wondering if this is necessary. Maybe I interpreted it incorrectly. This is where like the other commissioners can chime in and kind of like maybe give some insight on what you pull from that and if we want to leave this or not. We didn't really get any public comment, so I think, you know, whatever we decide is fine. But I would probably just want to be consistent with what we've done on the other documents, which if that's strike it, let's strike it.
Yeah, and to be consistent with the previous document, that may be just reverting to the original language.
I'm good with that. Does any of the commissioners have?
Is this a new form? Or no?
No.
No,
I've never seen this one before.
It just looks different, but it's the obligations for the seller and the landlord. So it's a form you give when taking a listing of a house before 78, built before 78.
So is it intended for in this one, I'm looking at the landlord one, intended to be given to the tenant?
This would be to
the homeowner.
Landlord. This is to the landlord. The one that we're looking at would be to the landlord or homeowner. And then the other one that we're voting on is to a seller.
Okay.
I would probably revert back without the language necessarily.
Okay, so two of us want to revert. Do you guys have thoughts, Tom and Bernadette?
I don't know. I'm just still. So this is different than the disclosure to the this is between like a property manager and the homeowner.
Yes, when you're listing for sale or lease, this should be given to the landlord or the seller
Okay.
at the time that they're listing or before, so that they know what their obligations are.
Okay, I've got to review my forms. I haven't seen this one before. Yeah, I don't know. I'm fine with whatever you guys think on this one.
Any opinions, Bernadette?
We can revert back to the other one, make it easier.
Okay. So I think we're all in agreement. We'll revert that language back. We're going to change tenant because it says buyer, so it needs to be changed to tenant, and I think that's it. Okay, so I would like to entertain a motion to adopt as amended the lead-based paint obligations. And this would be the two. So this would be the obligations for the landlord and obligations for the seller.
So moved.
All right. So do we have a second on that motion?
I'll second.
All right. So we've gotten a second. So let's go ahead and make sure there's no further discussion. If no further discussion, I'll call the question. All those in favor say aye.
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 All those opposed say nay. And motion passes to adopt as amended both of the lead-based paint obligations for the seller and the landlord. And we can move on to the next.
Okay, so that takes us to the notice of cancellation. And on this one, again, the proposal of that standard disclaimer about the legal consequences of the form. And then there's no other changes until going down to the final language at the end of the document. And the reason for this proposed change is really, language pertaining to the calculation of dates can be confusing. And the concern here was that the language used was a paraphrase of the language used in the statute that this form is based on. So the thought process behind the proposed change is that it would be cleaner to use the same language as the language that is used in the statute, just to avoid any potential conflict or misinterpretation. And those are all the changes.
Okay, thank you. Do we have any questions, comments, commissioners?
I had one. Let me look at my note. One second. So that there was a note on here that requires mailing this notice to the buyer. And could we do this electronically, since we do that with almost everything else? We're not provided with mailing addresses. So is that something?
That's a requirement of the underlying statute.
Okay, and that was my question. I didn't know if we could update
Yeah,
that, but if it's statutory, then no.
Yeah.
Thank you.
Okay, perfect. And any other comments, questions? Well, let's open it up to our public members.
Do any members of the public have any comments on the document in question, the notice of cancellation for the Colorado Foreclosure Protection Act? No hands at this time, though.
Okay. If no other comments, can someone make a motion to adopt the notice of cancellation, Colorado Foreclosure Protection Act?
Motion to adopt as
Okay.
amended.
Second.
Okay.
All right, we have a motion and a second, and let's go ahead and make sure there's no other discussion. Okay, all those in favor say aye.
Aye.
All right, any opposed say nay. And motion to adopt as amended and passes. And before we go on to the next one, my intent was really to try to push through these because, it's a lot. But we are about an hour or so in, and I just want to make sure that everyone is okay. No one needs a bathroom break, stretch their legs, whatever.
I would like that. I think a little break
Okay.
would be reasonable.
Yeah, because we still have quite a few more. We're through the good portion of it, but there's still quite a few more. So let's maybe, what do you think? 5-7 minutes or something like that? Or do you want to do a 10-minute break?
I think 10 is reasonable.
Okay.
Yeah.
All right, so let's do a 10-minute break. Everybody stretch and maybe get some water.
Thank you.
All right, see you back in 10. Do we have everyone?
I'm here, just still no video.
I'm here.
All right, maybe we can go ahead and get started.
Okay. We're ready to just jump back in. The open listing addendum to the listing contract is up next. And the same changes are proposed to this contract as were proposed to the exclusive brokerage listing. So previous one that we covered here. Hold on, make sure I'm tracking with my notes here. Scratch that comment, I'll just go through the changes. So in paragraph 1, there's a non-substantive change for clarity and ease of reading, and an updated paragraph reference to reflect changes made to the listing contract. Then paragraph 7, again, the change of the word commission to compensation for consistency with the new language implemented in all the commission contracts. And then the changes and new paragraphs 7.2 and 7.3. Again, those are just updated paragraph references that reflect changes previously made to the listing contract. And that's all. Sorry.
Okay, thank you very much. Commissioners, do you have any comments or questions?
Nope.
All right. Can we open it up for public comments, please?
Any comments from the public? Please select the raise hand icon. No hands, commissioners.
All right, thank you. Since there are no public comments on this, I would like to see if anyone wants to adopt the open listing addendum.
Motion to approve, open listing addendum to listing contract.
Do we have a second?
I'll second that.
Okay, any discussion?
No.
All those in favor say aye.
Aye.
Aye. All those opposed say nay. All right, and motion passes to adopt the open listing addendum.
Okay, so that takes us to the post-closing occupancy agreement. And this form wasn't scheduled for review this year, but the changes to the form are necessitated by SB 26054, which is titled Security Deposits and Post-Closing Occupancy Agreements, which was signed into law on April 20th. Current law prohibits a landlord from requiring a tenant to submit a security deposit in an amount that exceeds 2 monthly rent payments. The new bill creates an exception to this prohibition for cases in which a buyer and a seller of residential real property have executed a post-closing occupancy agreement in connection with the sale. So that exception takes effect January 1st, 2027. So this updated changes to this form that is also effective January 1st, 2027 will take care of that statutory change. And that change is reflected in paragraph 16. Additionally, in that paragraph, the first line is proposed to be deleted. I think we had this discussion last year during the forms approval adoption meeting as well. And division staff couldn't find any support for the requirement that a landlord must charge rent in order to collect a security deposit. So that was the reasoning behind the deletion of that proposed deletion of that language. So I'd be curious to hear your thoughts on that. And those are the only changes in that document.
Okay, thank you. Can we go to page 3 on your sheet? Is that intentionally left like that?
I think that will hopefully disappear. It's not intentional. Hopefully that'll disappear
Okay.
once the red lines are accepted. If not, I will make sure that that
Okay.
is taken out.
I know, well, commissioners, do you have any comments or questions on this document?
No.
I just want to address a public comment that essentially stated there are times when they use this document and they are maybe having to recreate it more than once. And so they wanted to see in addition that the most fully executed version of this agreement would supersede all prior versions. So if we could just have a brief discussion about that. And I don't know that I've had to recreate it multiple times. But there was mention that, there are individuals that have to do that in their day-to-day activities. So if we can just have a discussion and address that, that would be great.
I guess I must have missed that. Was it recreating, like it's just not executed and they're kind of going back and forth on it, or?
Yeah, they said that they were recreating this so I guess, maybe it changes, right? And which I can see if this changes, you do want the most recent version, because to supersede the others. Because I can see how that could be problematic. Again, in my experience, I haven't had to recreate it much, but I'm sure that there's others that have. So, I don't know if we can maybe entertain that language. I don't think it hurts to add it in there. But I would like some.
Why would that need to be recreated multiple times?
Maybe there was, this is just something I'm throwing out. Maybe initially there was no rent, right? The buyer's not charging rent, and then through negotiations, now the buyer's charging rent.
Okay.
Or maybe there was no security deposit, and then, through further negotiations, it's determined, what, buyer does want a security deposit now.
Would you do that through an amendment and not a new post-closing occupancy agreement? I'm just trying to think about how you would. Like, would you just amend, water and sewer? Now I'm just trying to think about how you would best.
Right. According to the individual that submitted the note, I think it was actually on the video, on the actual meeting, they are recreating this document. I guess to anyone in the division that may know, if this is, it's a great question that maybe many of us never thought about, but if this document is changed, are we expected to do the changes through creating another post-occupancy agreement, or are we expected to do the changes through an amendment? I guess I would assume you would redo the post-occupancy, but I guess I don't. Again, I've never had to recreate it really, but I could see where you would.
I think you could do it either way.
Okay.
I don't know how many times we see in complaint investigations, how many times we see these having to be redone or amended.
Mm-hmm. So I guess the question on the floor is, do we want to add language that the most fully executed version of this agreement shall supersede prior versions, or something of that nature?
I mean, that doesn't seem unreasonable to me. I'm just thinking, and I can see where, your closing date goes, and so your possession date changes on here, and you've got to make some changes, and then all of a sudden they want more time, and so you've got to change how much they're paying. So I do see reasons why this could come up. It hasn't come up to me either, so I'm just wanting to make sure that that is the best way to do that versus amending a piece of this. But
yeah, I mean, I think because people could do both, as just mentioned, and maybe we just, add that. Melissa, would it be possible to put some language together that basically says, something to the effect of, the most recent executed versions will supersede any others that were.
And I can read you guys the language that was proposed in the stakeholder comment.
Okay,
Maybe
yeah.
we can use that as a starting point to work from.
Okay.
The language that was proposed there was the most current, fully executed version of this agreement shall supersede all prior executed versions of the post-closing occupancy agreement relating to this transaction, and such prior versions shall be deemed null and void upon execution of the newer version.
Okay. I don't have a problem with that language.
Yeah, and that sounds good. I was just reverting back to our counter proposal and what that says. It's pretty simple but similar. The counter proposal supersedes and replaces any previous counter proposal. This counter proposal amends the proposed, goes on. But so something along those lines.
I think for consistency's sake, I think that's probably a good idea to mirror the language that you just read, Erica, that's used in other places.
Okay.
Yeah, I like
so,
that.
I will let you do your magic.
Okay.
Okay. All right, so we've had our discussion, and let's I'm sorry, is there any more discussion from commissioners? Any other comments? Anyone disagree with what we just talked about?
I would be fine with that.
Okay. Now, where's Tom? Is he here? I don't see him on my screen.
He is there.
Muted.
Okay. And okay. And let's open it up for public comment at this time.
If any members of the public have any comments on the post-closing occupancy agreement, please select the raise hand icon and we can unmute you. No hands, commissioners.
Okay. Well, if someone would like to make a motion, so we would be motioning to adopt as amended. If someone wants to make a motion on the post-occupancy agreement.
Motion to accept with the, how do I want to say this? Motion to accept as amended with the
addition of
the accepting the most recent
version,
I guess. Yeah.
I think sounds okay to me. Do we have a second to that motion?
Second.
Okay, so we have the motion on the floor. Any further discussion on that? If no further discussion, all those in favor say aye.
Aye.
Any opposed say nay. And with none opposed, the motion to adopt as amended is accepted. And we are ready to move on to the promissory note.
All right, the promissory note. The changes here essentially amount to the language in the deleted paragraph being split out into 3 separate paragraphs for clarity. I'm just trying to make it kind of easier to understand. The proposed changes in new paragraph 7 are also non-substantive and just made with the intent to try and make it a little more consumer friendly. In paragraph 9, you'll see that the word personal was added to delivery in relation to the buyer, but inadvertently that also wasn't added to the statement regarding the note holder. So I think for consistency's sake, we would have to add personal on that like third from bottom line there. That says personal delivery to note holder to make those changes consistent. And that's the only changes.
All right, thank you. Any questions, comments from commissioners? I just had a note that said email question mark. And quite honestly, I'm guessing it was somewhere in paragraph 9, the new paragraph 9. Any notice or communication must be in writing. I guess maybe my question was, is email accept? Because it's okay, because it says by mailing such notice by first class mail. So I guess I was wondering if email is an option for that as well, because it wasn't mentioned. In section 9.
Wasn't there another form earlier that they couldn't, and because it was required to go this way?
Yeah, but that was, I think, the Foreclosure Protection Act. This is
That one was noted, that one was required because of statute. This one
Yeah.
isn't.
Yeah, this is a promissory note. So are we able to add email, or is that not
I
an option?
don't have an answer for you on that. I mean, nothing is coming to mind why you couldn't, but that might be
I mean, I'm just
more of
thinking
a
of the
legal
days we
question.
did promissory notes, which was like early 2000s again. I haven't seen one since that era. But I don't remember having to first class mail it, but maybe we did. I don't remember that though. So I guess that would be my question. I would, if we can add email, that would be great. It just that speaks to our environment. I'm guessing this probably hasn't been touched in a long time because again, we haven't used promissory notes in a really long time in this industry. So I don't know if we can get a clear answer. If we can add email, that would be awesome. But I think, with the climate today, and efficiency, reasons, I would say if we could add email, that would be great.
I agree. If we're allowed to, we should add it.
I mean, fairness, but when this was created, we didn't even have, well, we weren't really using electronic contracts.
No, we're not.
So we're just in a much different environment. I just, would like to add that.
And just for clarification from our council, would it be acceptable to make some kind of motion that, authorizing division staff to make that change pending research to make sure it's acceptable, something like that?
I'm good with that.
Was that a question? I think she was asking council, right? Was that a question for our council?
Yeah, I believe
Is
it's a question for me. So, Melissa, you're asking if we can move forward with the motion subject to doing research on that specific aspect, whether email is acceptable form of delivery for this specific form. That's your question, right?
That's it.
Right. I think if everyone clear and if that's the commission's inclination to include email as an acceptable form of delivery, subject to specific prohibition, why we shouldn't, I think that is okay to make a motion, move forward with that, and then update the commissioners what was the outcome of our research.
Thank you.
Okay, thank you. Okay, thank you very much for the discussion. And do we have any public members that would like to speak in regard to the promissory note?
Any members of the public, please select the raise hand icon and we can identify you. No hands, commissioners.
Okay, great. All right, so we are looking to get a motion that adopts the promissory note, including the language to add the email subject to verification by the division. Oh, sorry. So if anyone wants to make a motion for that.
So moved.
Okay, do we have a second?
Second.
All right, any discussion? Okay, so let's go ahead and call the question. All those in favor say aye.
Aye.
Any opposed, nay? Okay, well, motion passes, and I assume the division will let us know if the adding the email is approved or not, or is acceptable.
Yes, I will let you know.
Okay. All right, well, we are clear to move on to the next.
Okay, so that is the promissory note UCCC no default rate. The proposed changes to this document are substantially similar to those made in the promissory note that we just discussed. The information previously contained in paragraph 1 here has been broken out into multiple paragraphs and expanded just as in the previous document. And then I'm also noticing now that division staff could make the corresponding changes to what is now new paragraph 9. They're based on the discussion that we just had, that will do the research about whether notice is acceptable by electronic means as well, and we can make those corresponding changes to this document as well.
Okay.
So that is all.
Thank you. Commissioners, any questions or comments?
No.
If none, are there any questions, comments from the public members?
Any public members at this time, please select that raise hand icon. No hands though, commissioners.
All right. Can someone please make a motion that we would accept this really under the same circumstances as the other promissory note?
Motion to accept. Motion to accept as amended with the possible change of
adding email.
The use of email.
Yeah.
Second.
All right. We got our motion. We got our second. Any more discussion?
Mm.
All right. All those in favor say aye.
Aye.
All those opposed say nay. And with none opposed, motion passes as amended, as discussed.
That takes us to the seller authorization form. Good news is the only proposed change to that is the addition of that legal disclaimer at the top. There are no other proposed changes.
All right, thank you. Any discussion, commissioners?
Nope.
Okay, let's send it over to the public.
Public, please select the raise hand icon if any comments. No hands.
All right, can we get a motion to adopt the form? Sorry, I don't have it for me.
Motion to adopt seller authorization.
Thank you. We have a second.
Second.
Okay, perfect. All those in favor say aye.
Aye.
And any opposed say nay. All right, with none opposed, motion passes to adopt the seller authorization form. And seller warning is next.
That is next, and same as the previous form, the only proposed change is adding that legal disclaimer at the top.
Okay, any questions, concerns, discussions, commissioners?
No.
Nope.
Okay, let's move it over to the public.
Members of the public, if you have any comments on this document, please select the raise hand icon. No hands.
All right. Well, with no comments, does someone want to make a motion to adopt this form as presented?
Motion to approve seller warning equity skimming form.
And do we have a second?
Second.
Any discussion? All right, all those in favor say aye.
Aye.
Any opposed, say nay. Motion passes.
Okay.
Short sale addendum, right?
Short sale addendum to the seller listing contract. The purpose of addendum provision that was in 2.1 is proposed to be moved to paragraph 2.4. And new paragraph 2.1, the addition of this language simply clarifies that if there's more than one lien or lien holder, this addendum applies to each of them. And new paragraph 2.2, the proposed changes are intended to provide a more expansive definition of short sale. The proposed changes to new paragraph 2.3 involve the change from short sale acceptance to short sale approval for the sake of accuracy. As lenders approve a short sale, they don't accept it. Lender is not a principal in a short sale transaction. The offer is negotiated with the seller, just like a traditional sale. So then that offer is then submitted to the lender, not for an acceptance, but for approval of the terms and net proceeds. The changes in paragraph 3 are all changing the term acceptance to approval. And then looking at paragraph 4, these disclosures are found in federal law at 12 CFR 1015.4B3, known as the Mars Rule, which was issued in 2009. And the Mars Rule requires companies offering mortgage assistance relief services to disclose certain information to consumers about the services they provide. It bans collections of advanced fees and prohibits false or misleading claims. After that rule went into effect in 2009, real estate professionals, who are the ones that are helping consumers with short sales, they raised concerns about complying with the rule. And then, so in researching the issue, staff found guidance from the FTC issued as far back as 2011, which states that the FTC will not enforce most of the provisions of the Mars Rule against real estate brokers who assist consumers in obtaining short sales from their lenders or servicers, with the exception of the rule's prohibition against misrepresentations. So that stay exempts real estate professionals who meet the requirements from the obligation to make disclosures and from the ban on collecting fees. Obviously, the brokers still remain subject to the rule's ban on misrepresentations. So given the lack of enforcement related to these disclosures, division staff thought that it may no longer be necessary to include them here. We've asked for feedback on that question in the stakeholder process. Really didn't get any input on that. So again, curious to hear from the commissioners their thoughts on that proposal. And that is the entirety of the proposed changes for that form.
Thank you. Any comments or questions, commissioners? And does anyone want to address the question that was just posed to us?
I think that with the feedback and
cut out.
research that they did, sorry, my dog's saying hi, reason to leave that in there.
And I'm sorry, what'd you say?
We can go ahead and remove that. I didn't see any reason to leave that in there.
Okay. And we'll see if any other stakeholders have any comments on it, since you didn't get feedback from them initially. So let's go ahead and open it up to the public.
So for the short sale addendum seller listing contract, if any members of the public have any comments, please select the raise hand icon. No comments at this time.
Okay. Well, I think with no comments from the stakeholders, I don't really know, I'm gonna be honest. We'll just follow the guidance of the division, unless any of the other commissioners would like to do, something different, but that would be my recommendation. Okay, well, can we get a motion to adopt?
Motion to adopt the short sale addendum seller listing contract.
Can I get a second?
Second.
All right, do we have any discussion? All those in favor say aye.
Aye.
Any opposed, say nay. All right, with none opposed, then motion to adopt passes. And then
Okay,
now
so
the
that's-
contract.
Yep, the short sale addendum, CBS. All the proposed changes in paragraphs 1 through 4 are the same as those presented in relation to the short sale addendum seller listing contract that we just discussed. There is a proposed deletion of paragraph 5.2 regarding the seller's consent to lien holders' release of information. This is an automatic waiver of confidential information, which raises a concern that we have seen throughout some of the commission's contracts, that there is not adequate information provided to a consumer regarding the risks and rights associated with waiving the confidentiality of their information. There's also a question of whether this automatic waiver is necessary given the seller authorization form that can be used by the seller to consent to the disclosure of such information in a more informed manner. Then looking at paragraph 7, the proposed statement in 7.1 is just an expanded version of the first part of existing paragraph 7.3. The proposed new excuse me.
Take your time, Melissa.
She's been doing so very good this entire day.
Yeah, she's doing great. So much.
I know. Get some water, Melissa, if you can hear
Yeah,
me.
take your time, water, be okay. The amount of reading she's having to do.
I know. Only after this, only 3 more, I think.
We're getting there.
Sorry, I've been battling a cough that I've been trying to limit to muting muting points, but apparently it caught up with me.
Yeah, if you need to step away, it's totally okay.
So I guess if I can just ask David to scroll through, there's only a couple of minor changes on the rest of that form in paragraph 7, paragraph 8, and then paragraph 9. And then hopefully with that, we can open up the discussion, and I will mute for a minute.
Okay, so sorry, let me go. So it looks like the changes that are being requested are the IP at the top. And then I believe she said this mimics the other addendum that we just approved.
Paragraphs 1 through 4 do, yes.
Okay. And then 5 is where that is being deleted. I just want to take a minute to review that real quick. So, oh yeah, that was a confidential information. They changed short sale acceptance to approval, just like the other one. And then under 7, There's some changes here. Okay. These look like, you know, just some disclosures that I think make sense being here. And does anyone need more time for 7?
No, we're good.
And then 8, it's just changing acceptance to approval and some, you know, sounds like clerical stuff. Again, changing approval from acceptance, termination, a small change there. And then looks like there's nothing significant till we get to 9. I just want to read that for a second. Okay, just asking, yeah, just stating that they should seek it legal, or we'll say advice from appropriate professionals. Okay.
One quick question. In 8.32, it does change buyer's written notice received by the seller on or before, and they took out 3. Is there a limit on days, or how does that, why would we change that, or what would be the reasoning for that, getting rid of the 3 days?
It looks like they put a blank so that that could be filled in and maybe part of the negotiation.
On or before. Okay, so but it's open to however many days they need, or
I think the way I interpret this is it's open to whatever's negotiated with that buyer.
okay.
Yeah.
Okay.
So before it was a mandatory date, and now it's subjective to based on, you know, your transaction. So you know, so it sounds like parties can negotiate that, which I think makes sense. Any other questions on this from the commissioners?
Nope.
Okay. Well, can we open it up to the public for any comments or questions or discussion?
Absolutely, commissioners. Any members of the public that would like to comment on this document, please select the raise hand icon and we can unmute you. But I'm not seeing any hands.
Okay. Well, if we could please get a motion to adopt the short sale addendum contract to buy and sell, that would be great.
So moved.
Do we have a second?
Second.
Okay. Any discussion? All those in favor say aye.
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 And any opposed say nay. And with none opposed, motion passes to adopt the short sale addendum contract to buy and sell. And then are you better?
I think I'm good. Sorry about that.
Okay, no, don't
almost
worry.
made it.
Yes, you're okay. We only have 3 more. So source of water.
Okay, so the source of water addendum to the CBS. So in reviewing this form, division staff did consult with attorneys who specialize in water law just to get some guidance and get some advice. And through that process, the proposed changes that we came up with are as follows. In paragraph 2.1, there's just a formatting change regarding the position of the well permit number. And then in that version before you, you'll see that the attached has been changed to provided, but as we previously discussed, we'd like to keep that as attached. And then the addition of paragraph 2.4 provides a clear disclosure to the buyer that there is no source of potable water for the property. This hopefully eliminates any confusion as to whether there was simply a failure to fill out the form or if there's actually no source of potable water. And then there is the addition of clarifying language to the disclosure to the buyer to include both wells and other water providers. The intent with this proposed language is to make it more expansive and clear that any groundwater source is potentially limited, which is particularly relevant in designated groundwater basins. So that's it for that form.
Thank you. Any questions, comments, commissioners?
Someone in the hearings, and I think this has come up before, asked if a deadline could be provided for this disclosure since we don't currently have one. And I think I hate to ask Melissa to talk at this point, but I think you were going to look into this to see, because I'm surprised we haven't had this come up before. But in your opinion, why do we not have a deadline for this form? I mean, I typically get them relatively quickly after going under contract, but there is not a deadline for it.
And that deadline would be in the CBS, correct?
Yeah.
Yeah, and I don't know, I can't speak to historically why that hasn't been put in there. And I think that was an issue that I put on the global list to look into and further research the next time the CBS comes up. But I'd be curious to hear if you guys have any input on that we can use.
I definitely don't know. I always just assumed it's because the source of water can also be identified in the seller's property disclosure. So I just kind of thought maybe that's why it wasn't in there, because you had, if you provide this information in the property disclosure, then you don't necessarily need this addendum. But I guess it wouldn't hurt to be in there.
And I think, one of the points that was brought up was an excellent point of if you're trying to get well permit information, the sooner you can get that, the better, or at least, negotiate a date that you feel like would work well for the parties to try and obtain that information for you. So that would be my feedback when you get to that point. I do think that it's important. Although it has not become an issue for me, I can see where it would be. And I was just very curious as to why it hadn't been addressed in the past. But that's all. Thank you.
I think so. I'll definitely take note of that. And like I said, we'll look into it when we look at the CBS again.
Okay, thank you. Any other comments, questions from commissioners? If none, let's go ahead and invite the public to speak on this form.
Regarding the source of water addendum, if there are any public comments, please select the raise hand icon. No hands, commissioners.
Okay. Well, does someone want to make a motion to adopt the source of water addendum?
So moved.
Second?
Second.
Any discussion? All right, let's vote. All those in favor say aye.
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 Any opposed say nay. And motion to adopt passes. All right, on to the next.
Okay. This title related objection notice that was put on the agenda in previous discussions. It was a suggestion that had been made as part of the global list. All right, now I've got my notes. My wires crossed here, sorry. Okay, so I was thinking about that proposed resolution form. My apologies.
Okay.
So for the title related objection notice here, pretty basic suggested changes in that first paragraph there, just making it clear that kind of really trying to emphasize the buyers that, hey, we're saying, kind of tip the hat that you are the ones that should potentially consult an attorney. And then if you can scroll down, sorry, I don't have this in my notes, so I just need to scroll down. And then just the changing of preparation to reporting. That's really when we were talking about the title potential title resolution form, there was a lot of concern about brokers maybe engaging in the practice of law and whether brokers should be preparing title objections. So that language was just intended to clarify that brokers shouldn't be preparing them at all. They should just be reporting the objections. And then an addition of a space a line in case more space is required. And then I think that's it.
Okay, thank you. Commissioners, do you have any questions or comments?
Someone had suggested expanding the title of this form, and I know it says title related, but then people have a hard time trying to find this form when they're addressing maybe survey or due diligence. Is that something that was contemplated? That would be a very long title, but title, survey, and due diligence related objection notice, since that covers all of these, and then people might have an easier time locating the form they're supposed to be using.
I saw that suggestion and I thought it made sense to me.
Yeah.
Okay.
So any thoughts, Melissa, on, I know it, like Erica said, it would make for a very long title, but I wouldn't correlate if I've never had to terminate on a survey or ILC, and now I do, and I'm trying to see if there's a form for that. I wouldn't correlate that to this title. So yeah, I like changing the name.
Okay. Yeah.
What was your recommendation, Erica? It was
title, survey, and due diligence related objection notice.
Yeah, I like it.
Okay.
And then I would have to be changing the footer too, of course.
Okay.
Okay. All right, perfect. Do we have any public comments that we'd like to entertain?
Any hands related to the newly named, formerly named title related objection notice? Please do select that raise hand icon now. No hands though.
All righty. Well, with that being said, does anyone want to make a motion to adopt this as amended, this form?
So moved.
Do we have a second?
Second.
Okay. Any discussion? All right. Well, let's call the question. All those in favor say aye.
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 Any opposed say nay. Motion passed to adopt the new form as presented. I won't say the name right now because I'm sure I'll mess it up.
Okay, so I feel like we need some sort of confetti or something to mark this last form, but
Yes.
I'll just power through it to get us done.
Right.
Worksheet for real estate settlement. This is another form that just hadn't been updated in quite a while. So when reviewing the form, I reached out to some brokers for feedback about items that may no longer be relevant or that should be added. And you'll just see some additional items that are proposed to be added at the end of the list there. And that's it.
Okay. All right. Thank you. Any comments to the commission?
Nope.
Okay. Can we see if we have any public members that want to comment on this document?
Any members of the public? Please do select that raise hand icon. No hands on the worksheet.
Okay, so can we please get a motion to adopt the worksheet for closing statement?
So moved.
A second, please.
Second.
All right, we have a motion, a second. Any discussion? All right, if no discussion, let's call the question. All those in favor say aye.
Aye.
Any opposed, say nay. And motion to adopt the worksheet for closing statement passes. And I just want to say thanks everyone for your participation in this hearing and all of your feedback. We really appreciate the shareholders and all the work on behalf of the division. So thank you. And I can say with a lot of joy that this concludes the hearing. Thank you very much. Do we need a break before we dive in? I'm just checking with everyone, just see how everyone's feeling. I know it's been a very long day.
I'm good.
I still have a little energy, so I would be okay for a little while.
I can keep going for a little while.
Yeah.
Okay.
To the next
Same here.
section.
All right. Yes, let's just kind of push
Bernadette, I
through.
see your mouth moving, but you're on mute, I believe.
I need just 1 minute to go close my door because I left my door open so my dog could get in and out.
Yeah. Don't worry, I have to figure out where we are on the agenda, so
Need 1 minute.
no problem. Okay. Oh goodness, I forgot we still have policy matters. All right.
I think you can move through these fairly quickly, though.
I kind of forgot about those. Back on it. Okay. Where's my?
Okay, I'm back.
All right. Well, we are going to move on to policy matters. And this portion of the meeting will be run by Director Waters. Any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board. Is there anyone who has signed up to speak or anyone who wishes to speak at this time? Anyone who wishes to speak, please state your name and who you represent. All right.
There are no hands at this time, and if, in case you have not heard me say it before, if you would like to address the commissioners, please select the raise hand icon. And,
we heard that 63 times. I'm gonna tell you.
But of course, commissioners, I do not see any hands in the attendee list at the present time.
Okay. Okay, well, I'm gonna just turn it over to Director Waters.
So commissioners, you have several position statements in front of you today. Many of them we are looking at either revising or repealing due to legislative changes. One was a concern brought to us by some stakeholders. So we'll start off with CP1. We are proposing just to change some language in the first section about broker representing buyer. That's to be consistent with House Bill 261426. And then later on, down on the first page as well, we've got just some kind of clarifying language, really encouraging real estate brokers to look at the rule and kind of analyze what they are doing based on the rule language. And then there's just a minor typo cleanup in the very last sentence on the first page.
Thank you. Now, just a question that I have. Are we opening this up the same way we did the others to comments, or did my invitation in the beginning kind of cover that?
So unlike rulemaking or non-rulemaking, this is just for you all to make a decision on.
Okay, thank you. Okay, and then are you okay with us discussing after each position statement? Perfect. Okay, commissioners, do you have any questions, concerns in regard to commission position 1?
No.
Doesn't sound like anyone does. And so we can, I guess, vote. Should we vote after everyone too? Is that good?
Yes, please.
Okay. So let's go ahead and get a motion, if someone doesn't mind, provide a motion to accept commission position 1.
Motion to accept commission position 1.
Okay, can we get a second?
Second.
All right, any discussion? All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion passes to accept commission position 1.
So with CP5, we are just clarifying that this applies when brokers are performing license duties, and this comes about as a result of the passage of House Bill 26-1268.
Okay. Do we have any questions, commissioners, or comments?
No.
Okay. And if no questions, can someone please motion to accept?
Motion to accept commission position 5.
Okay,
Second.
perfect. And any discussion? All those in favor?
Aye.
Any opposed, say nay. Okay, and I will say this since it'll probably move it a little faster because I'm asking for comments in the beginning. We can just go straight to motions on this one, and then if we have any discussion, we'll deal with it during discussion. That'll save us, about 30 seconds per issue.
So with CP7, we just did kind of some language cleanup. The goal was to also kind of clarify some things. With the change of, I think it's rule 6.8, the last paragraph, so if David scrolls down to that, the red line that says a new listing contract or a listing contract amend extend must be executed, we would, based on what you adopted today with the rule, we would change that to say the employing broker or supervisory broker must provide written notice to the client that there has been a new designated broker appointed. And David, can you go back up a little bit towards the paragraph at the end of the page? I know that you got some comments about this, how it sounds like it's obligatory that the brokerage firm must consent to the assignment of a listing contract. This is a position statement, so it only provides guidance. And the reason that we had put the language about the brokerage firm must consent is to make it clear to the licensees that these listing contracts are for the brokerage firm, not the individual designated brokers. So if the designated broker changes a brokerage firm, they don't automatically get to take that listing with them. The original brokerage firm has to approve the assignment.
Okay. All right. Well, can we get a motion? It sounds like we would need a motion to approve as amended.
Correct.
Okay. Motion to approve is commission position 7 as amended.
A second, please.
Second.
Any discussion?
Nope.
All right, well, let's call the vote. All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion to approve as amended passes.
So CP13, which is about office policy manuals, we're proposing to delete the reference to 6.3 because that has to do with supervision. This has to do with office policy manuals. In part 1B, we're just trying to clean up some of the language about PII. With 3, confidentiality, we're updating the statutory language that changed with the passage of House Bill 26-1268, just to make it clear that the employing broker or supervisory broker is prohibited from using the confidential information to the detriment of the associate broker's client. With 4, we're not providing guidance on how to manage conflicts of interest. We're putting that onus on the employing broker to determine through the policy manual how they will do that. And then in Q of under 5, we've just deleted the language about trust accounts for non-real estate related activities.
Okay. Thank you. All right. So does anyone want to make a motion to approve CP 13 changes?
Motion to approve commission position 13 changes.
Do we have a second?
Second.
Any discussion?
No.
All those in favor say aye.
Aye.
Those opposed say nay. All right, motion to accept CP 13 passes.
So with CP 15, this is about leasing and property management. There were essentially 3 different laws that have been passed, 2 in 2025, 1 in 2026. And so we are updating the position statement to make sure that it is consistent with those laws.
Okay. And I guess I'll just can we get a motion to approve?
Motion to approve CP 15.
All right, second.
Second.
Any discussion? I actually have one thing. It's just a small like typo on page. See if I can see what page it is. I can't tell what page it is. Let's see. Scroll down to page 6. Okay. It just says on that first paragraph, it says next to private property by tenant or members of his. I think we could just say their.
Okay.
Small thing, but. And so I'd like to make a friendly amendment to the motion that we approve, what is it, CP 15 with the correction.
So actually, Commissioner Sanders, that's a direct quote out of the statute language.
Oh, is it?
Yeah.
Okay. Okay. Well, never mind.
Sorry.
That's okay. That's okay. All right. Well, let's go ahead and call, sorry, not call the question. Yeah, call the question. We have the motion already. So all those in favor say aye.
Aye.
Any opposed say nay. And motion to accept CP 15 passes.
CP 17 is single agent versus transaction broker, and this was updated to address the changes that came about with the passage of House Bill 26-1426.
Okay. There's a couple places in here that I thought might be typos. On that 1 to 3rd paragraph on page 1.
Okay.
It still says informed consent, should not say written, or express written. Do you see? It's the 1 to 3rd paragraph.
So that's kind of an interesting nuance. So sharing of confidential information is express written consent. This is discussing when you're changing brokerage relationships. And that's kind of one of the interesting things that we picked up on as we were reviewing these was informed consent is woven through the position statements in different areas, and it's not in the context of brokerage duties related to confidential information. And I would think that if you're going to have a conversation with your client about changing your status from being a single agent to a transaction broker, you would want to have a more robust conversation than you signed something that said I could and you're stuck with it.
So then do all the, I just, trying to make things legal but easy. So now would all of the things that would normally be required with informed consent be required here? Because when you look at our change form, it doesn't really have that. It doesn't define it in this way. Does that make sense? I hope my question makes sense. So to me, it still seems like we would just want this to coincide with that, which would be the express written consent, because that's essentially what that form is requiring. Does that make sense?
And I will throw this out there for you. I have not asked for this, but at some point you may want to get a legal opinion on what express written consent is. It's a unicorn is what has been created, basically.
Okay. And then the other thing that I wanted to just touch on, this isn't a big deal, but it's not consistent. Part of this document is referencing consumers, and then part of it's referencing client. I think we would probably want some consistency there. So like in section, I think I can't see it completely, but I think it's paragraph 1 and 2 references consumers, and then when you start to get to paragraph 3, it starts to reference client. Or no, sorry, paragraph 4 starts to represent client. So just some consistency there, I think would be good.
Okay. We try to make the distinction. The consumer would be somebody that's seeking brokerage services versus the one that has entered into a relationship. That's the client. So do you want me to change informed consent to express written consent?
I think it should be, but I would love to hear from the rest of the commissioners on that. And I'll go with.
I mean, I just feel like we had a whole lot move from informed consent to express written, and then to keep this here with informed consent. I mean, I'm with Erica. I don't want to cause confusion. I like to keep clarity as much as possible. I like to keep consistency as much as possible.
So do you think leave it or go with express written?
Well, I would have thought express written.
And then Tom and Bernadette, do you have an opinion on that?
I would think written as well.
You have to do amend extend that you have to do for this is written consent, isn't it? Is that am I missing that?
You do the change of status.
The change of status, yeah. So I mean that is written consent, is that not? So it would be accurate to say that.
So it sounds like we all wanted to say express written consent instead of informed. And then, I gave my thoughts on the consumer versus client, but if there was a purpose, it's really not super important. It was again just about, but I understand why you put it there, because you're now talking about broker relationships. So you've kind of explained that out. So that's fine for me.
We can definitely go through and review it to make sure that each of those terms is being used appropriately.
Okay, great. All right. So now, if someone could please make a motion to approve, what is this, CP 17 with the amendments.
Motion to approve CP 17 with the amendments.
And do we have a second?
Second.
All right. Any discussion? All those in favor say aye.
Aye.
Any opposed say nay. All right, motion passes.
So CB 20 is the one about licensed and unlicensed real estate administrative professionals. We're just proposing some cleanup of the language in the second paragraph. It speaks about liability. And we wanted to basically, it wasn't necessarily consistent with the statute itself. So we changed it to be consistent with the statute, clarified in number 1 below activities that they can function as a scrivener. And then again, under the licensed REIPs section, we're just clarifying that you've got to have a written agreement before you provide brokerage services.
Okay. Well, let's just go straight to a motion. Does anyone want to make a motion on CP 20?
Motion to accept 20.
Okay, we had a motion to accept by Bernadette. Was that Bernadette?
Yeah.
Okay.
I'll second.
And then a second by Erica. All right, any discussion? All those in favor say aye.
Aye.
Any opposed say nay. And motion passes.
CP 22 is the position statement on conflicts of interest. And in the very last paragraph, we change informed to express written consent. That's the only change.
Okay, thank you. All right, does someone want to make a motion?
Motion to approve CP 22.
Perfect. Second, please.
I'll second.
Okay, any discussion? Let's call the question. All those in favor say aye.
Aye.
Any opposed say nay. All right, thank you. Oh, sorry, motion passes.
CP 26 is currently titled Reducing the Buyer Pool. We are proposing that we change the title to Creating Barriers to Access. This position statement, the division was approached by multiple representatives from different MLSs about concerns with private listing networks and the implications that that marketing plan has for consumers. So because of that, we are proposing changes to this position statement. Number 1, changing the title, because depending on the type of marketing that is done, it can be detrimental to both buyers and sellers, not just sellers. We're hoping to also address through this that there are implications regarding fiduciary duties and who the loyalty the broker has rests with. It should be the client that comes first, not the brokerage firm. Additionally, that there are also fair housing implications and steering implications when you are engaged in that type of marketing model.
Thank you. If you don't mind, I'm just taking a moment because for some reason I went straight from 22 to 29. And maybe I just downloaded everything early and didn't have
I
this.
got loaded a little later because I did want to float the proposed changes with the representatives that we spoke to. So I uploaded it later than the other position statements, but I think I
Okay.
sent you guys an email about it.
And you probably did. I somehow missed it. So I'm just really quickly reviewing. But if any of the other commissioners have any comments, that would be great.
Yeah.
Okay. So it's just highlighting just things that the brokers need to be thinking about with regard to their decisions on how they market the property. But it doesn't say you can't do it, so it's still, because we don't want to do that, but it's just giving them something to consider.
Correct.
Okay. Did anyone else need to read it, review it? I know I think maybe I'm just the only one that missed it initially because I downloaded this stuff kind of early. If not, then since someone can make a motion.
Motion to accept CP 26.
Okay, do we have a second?
Yeah, I'll second.
Okay, any discussion? All right, let's go ahead and call the question. All those in favor say aye.
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 Any opposed say nay. Okay, motion to accept CP 26 passes.
So commissioners, the next two are fairly easy. We are proposing that you repeal CP 29 and CP 31.
Okay, can we do those together?
You can.
Okay. Does anyone want to make a motion on repealing CP 29 and CP 31?
Nope.
And a lot of those, I don't know if we could put, oh, good, you put CP 31 up. Perfect. Okay. Anyone want to make a motion to repeal those?
Motion to repeal CP 29 and CP 31.
Perfect. A second?
Second.
And any discussion? All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion to repeal CP 29 and CP 31 passes.
And is there anything that you would like placed on your agenda for the next meeting?
You know, I always like to address any public comments, and there was one today that I have to find. It was a question about reconsidering. I'm just gonna like summarize it, but for those that are instructors, they want to reconsider the hours, and they want to maybe receive credit for training the trainer. So any kind of resources that you could provide us so that we could look into that, that would be great.
Yep. Thank you, commissioners.
Thank you. All right. Bear with me as I figure out where we now are on the agenda.
Complaints.
Complaints. Okay. Is everybody okay? Do you need a quick break? Because we got like a lot of complaints.
I'm good.
Okay. All right. Well, next we'll move on to complaint matters. The lead investigators will identify the complaint matter on your agenda, the case number, read a summary of the case, identify potential violations, and recommend a possible case resolution. They will also notify the board regarding who from investigations is there to answer any questions. All right, let's just dive into it.
All right. Good afternoon, commissioners. Your first item up is investigative matter A. This is audit number X 2025-152. The respondent became the employing broker after the previous employing broker voluntarily downgraded their license after signing a stipulation for diversion in March 2025. The brokerage deficiencies during the previous employing broker supervision were resolved. New deficiencies were found during the respondent's audit. Dozens of ledgers in the operating account had negative balances totaling upwards of $60,000. Only a small improvement was completed over the course of 5 months based on audits of monthly reconciliation reports. Additionally, nearly 80,000 in brokerage funds were commingled in the operating account, which mostly consisted of corporate funds utilized for debt funding. The same operating account contained hundreds of aged unreconciled transactions as old as 2021 and totaling almost 115,000. Lastly, the respondent stated her brokerage is in the process of transferring its trust accounts from a bank that does not currently have any branches located in Colorado to a bank that does. Possible violations include 12-10-2171H, 12-10-2171I, 12-10-2171M, Rule 5.9, Rule 5.10, Rule 5.14, and recommended disciplinary action includes diversion, a $5,000 fine, coursework and trust accounts, and a follow-up audit within 3 months. And myself and investigator auditor Jay McLean are here to answer any questions you may have.
All right, thank you. Any questions, commissioners? And does someone want to make a motion?
A motion to accept staff recommendations.
Do we have a second?
I'll second that.
Any discussion? All those in favor say aye.
Aye.
Any opposed say nay. All right, motion to accept staff recommendation passes.
Right, your next item is investigative matter B. This is complaint number 2026-1065. On March 26, 2026, the respondent was convicted of sexual assault, no consent, class 5 felony, and assault 3, knowingly and recklessly causing injury, a class 1 misdemeanor. The respondent was sentenced to a deferred judgment of 4 years of probation. The respondent was also sentenced to register as a sex offender and pay court costs and fees totaling $5,276.50. The respondent is on a $150 a month payment plan, and the probation is scheduled to end on March 26, 2030. The respondent did not notify the division of the conviction. Possible violations include 12-10-2171M, 12-10-2171N, 12-10-2171P, and Rule 623. Recommended disciplinary action includes diversion, a $500 fine, and probation to run concurrent with criminal probation. And again, myself and auditor investigator Jay McLean are here to answer any questions you may have.
Thank you. Do any of the commissioners have questions, comments?
Well, I had some questions on this one. I thought that if the courts felt like he needed to be registered as a convicted, well, let me go in here.
Convicted sex offender.
Sex offender. That really raises some issues with what we do with our license going into people's homes with our clients, and they would not be aware of this conviction at all. So I felt like this needed to be handled differently than the recommendations. I'm curious about the other commissioners' thoughts on this.
Yeah, I actually noted that I was concerned with the nature of the crime, and I was also kind of curious because it was, felony assault. The person has to register, why the discipline was what it was, and I just wanted some background to that, maybe understanding, because I also was anticipating it to be a little harsher just because of the nature of the crime.
So I'm sorry, Commissioner, you were asking why the recommendation was what it was?
Yes.
Yeah. So consistent with other criminal conviction cases that are presented, the disciplinary action that was recommended for this one, it would be similar to other criminal conviction cases that y'all have heard. Now, that said, the statutes that this individual was convicted of are certainly different and warrant the conversation that y'all are having right now.
Right. I think it's not because I mean, I understand with most convictions, but when we have certain convictions, I just kind of anticipate that it would be a little harsher, particularly when it's a sex crime. There's other crimes that would fall into the same category, right? But this is a act that this person was convicted on against another individual. So it's
I would also say that I don't think there's any standard for how these particular cases have been handled when the convictions are outside of what y'all may typically see.
Okay.
it-
Tom and Bernadette, do you have any comments on this?
Yeah, when you read his account, I mean, they were totally different. Was it definitively proven that he was guilty? I mean, it sounds like it was.
He was convicted of it.
He was convicted and he has to register.
Yeah.
Right. He was convicted of the crimes that were presented to y'all. His accounting of it may differ than that of the victim and that of the police report, but you
Which is
all were
probably
presented with
typical.
that information to ascertain what you feel.
Yeah.
And he's on probation till 2030.
Correct.
So, I mean, I think I'm kind of in tune with Erica in that I just thought the crime was a little more serious than sometimes we see. And given that and given that his relationship with client, like you have to her point, you're going to be in houses, you're going to be having, potential buyers and sellers. I just think that is something we need to take in consideration.
Well, it's a sex crime is a little bit different than like theft crime, right?
Or a DUI or something.
And how if you are just a buyer or a seller, you may not look up your agents, I don't know, or your brokers, like their
criminal history.
criminal history.
Yeah.
You're thinking they're licensed, it's approved, they're technically safe. And I'm not saying that you're not safe with him, but I'm also not saying that you are, right? Because I mean, every situation's different. Is this something that he's gonna do again? I mean, there's all kinds of stuff. Who knows? But the sex crime piece of it is the tough piece on that, and the trust piece of the public. I mean,
yeah, and I just don't know if he's like, we don't know yet because his probation just started. We don't really know if this person will be rehabilitated. I think that there would be an opportunity for them and a path for them to come back and get a license. And I rarely ever recommend revocation, but this is one I'm kind of like, maybe, I don't know. I would love to talk more with the commissioners and get on the same page, but I found this to be concerning.
Well, what was the proposed punishment or?
A diversion, a $500 fine, probation that runs concurrent with his crime. And
Well, he would keep his license.
Yes.
Okay.
Yeah, those are all Tom, they're all in the ESP referral.
Yeah.
Look at that in the link.
I'm with you, Erica. I think that revocation is reasonable considering we're on the front end of any potential rehabilitation. There was no report made by him to tell the commission about it that was required. At bare minimum, I don't find him truthful. And I think that it poses a risk to the public who will likely not look this up as they're walking into homes or selling them at this point. I think that there's a direct correlation in that aspect. And I think that I would be on board with that.
Just to clarify for y'all, I believe this respondent pled guilty
Yes.
to these convictions. So not necessarily that they were convicted, but they entered guilty pleas to the specific crimes that were mentioned here. And
Okay.
the initial recommendation was a diversion, $500 fine, and probation, license probation to run concurrent with the respondent's criminal probation. But as any case, y'all are, it's up to y'all's decision to decide ultimately what the disciplinary action will be.
And commissioners, this is Investigator McLean. This respondent was arrested at his brokerage firm for whatever it's worth. I mean, his employing broker is very well aware of what has happened. He is also a commercial real estate broker. He is not working with residential clients. I just say that just so you're aware. I don't know if that has any impact, but it was just important to say.
He does commercial and not residential?
That is correct.
I don't know if that really matters too much. I mean, I guess he's less at risk of being in a bad position, but still.
One other thing that you all have done in the past with certain cases where you may be concerned, because I heard somebody say something about, potential repeat. As part of the probation, there can be a higher level of reporting. In other words, they would be required to report. We've asked this of other people to report not only a conviction, but even an arrest, just to keep you apprised of any kind of conduct that might be occurring. And I think, yeah, I'm just throwing that out there. That's another tool that's been used in the past.
How long did we say he's been a broker? How long has he been doing this?
You give me a moment, I can
I apologize,
look that information up.
Rose. I don't have that in front of me.
Let me see why.
First issuance, which is on the top of the report. I want to say 2016. I am not certain.
And he's had no other issues while he's had his license since 2016, so 10 years.
Well, and if you read, this is where I also concerned. I mean, when you read the situation, there was some dishonesty too. He didn't present himself who he really was. And it's rare, but I don't feel comfortable with that. I think that does pose a threat to the public. I mean, it would be one thing if even in that scenario there was truth, but there was dishonesty from the gate. He wasn't truthful about who he was to the person. And so that, I think, speaks a lot to this person's character or lack thereof in this instance. They may be able to be rehabilitated, like I said, but I mean, this just happened in May. So like I said, it's very rare that I would ever recommend that, but I'm kind of thinking revocation makes sense.
Yeah, that's right. This one did say he was a different name. And she had to find out who he was. Because she didn't have a real name.
Any other comments?
Lead on it, Erica.
Huh? What'd you say?
That I'd follow your lead on it. I would. Yeah.
I feel like it doesn't make me feel good, but
yeah, well,
the nature of all the details,
Yeah, it never feels good, but at the same time,
I think it's the right thing to do for the public.
Yeah.
So I'm gonna tell you what, just so we keep this just keep things going, because we do have a big agenda. I'm gonna just make a motion and then we can vote accordingly. And we can, if the motion doesn't pass, that's okay. We'll work through it. But I'm gonna motion that we don't accept the disciplinary recommendation, and that instead we go with the, I guess the FAO would have to go with revocation. Is that correct?
Correct. And then typically max fines as well, which I think in this case would be $5,000
Okay.
And public censure.
in public censure.
Okay. So I recommend we don't go with staff recommendation on this one, but that we go with the FAO, public censor revocation, $5,000 fine. And that's it. And like I said, I think there's a path for this person to demonstrate redemption from this. And I think that once they kind of get through this, they can always reapply. But I just think right now, this feels very much like a threat to the public. So I made a motion. Does anyone second that motion?
Second.
Yeah.
And then we'll call a vote and, we'll see if we all agree or not. All those in favor, say aye.
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 Any opposed? Okay, well, motion passes.
Commissioners, I'm sorry to bug you again and bring up another policy matter, but we forgot to ask you for a delegation of authority during the non-rulemaking hearing on the forms to allow staff to fix any typographical errors and also make sure that the forms have the appropriate language about transaction brokerage and needing to have a written agreement. So could you give us that delegation, please?
Okay, I gotta write that down. That was a lot. So we make a motion to do that, right?
Yes.
Okay, motion to, delegate authority. I'm just writing notes. Delegate authority to the division, right?
Yes.
To make typographical corrections.
And I would probably include non-substantive as well.
Okay. And non-substantive corrections, including, you said something about transaction broker.
And also to ensure that the forms comply with the changes to transaction brokerage and the requirements of written agreements.
Okay.
And then I promise I will not bring up any more policy matters after this.
Okay, bear with me. I think I got it. I'll make the motion since I wrote it. Okay. Motion to, regarding the right? This is only just for the rulemaking hearing.
Correct.
So regarding the non-rulemaking hearing, motion to delegate authority to the division to make typographical and non-substantive corrections and ensure forms comply with transaction brokerage and written agreements. Hope I said that right. Okay, second. Can I get a second? Erica, second. And any discussion? All those in favor say aye.
Aye.
Aye. Any opposed say nay. Motion passes. Okay. All right, so back to, oh shoot, where were we?
Investigative matter C.
We're still on, yes. So we were gonna call the vote. Oh, we all call, oh no, we passed that, sorry.
Yep. Okay.
Yeah,
So
we're done
next
with that one.
item
Sorry.
is investigative matter C,
Okay.
which is audit number X 2025-153. This audit was opened due to a stipulation for diversion that the respondent signed as a result of a previous complaint investigation, which had found issues in part with the respondent's trust accounting. The respondent required many extensions to respond to this audit due to personal reasons, as well as a nearby building fire that damaged the respondent's brokerage firm office and records. While the respondent did address and provide many of the records requested during the audit, the respondent was unable to provide compliant through reconciliations for all the respondent's accounts holding money belonging to others. Additionally, the most recent three-year reconciliation provided for the respondent's rental trust account showed approximately $138,000 negative ledger balances, as well as $138,000 in broker funds being held in the same account. Furthermore, the respondent was unable to provide signature cards for any of the respondent's accounts holding money belonging to others, stating that each of the banks used by the respondent refused to provide him with those records. However, the respondent never provided documentation from the bank supporting that stance. Just wanted to give y'all a few updates because there have been a couple since this was initially drafted, including the disciplinary action recommendations that are recommended to you here in a minute. But on July 18th, the division received an email from the respondent with a complete bank statement. On July 30th, the division received an email with responses to the questions that were submitted to the respondent on July 8th. The respondent clarified that the negative balances were due to owners who had worked on the properties without sufficient funds to cover those balances, and that the broker funds in the account were being used to offset those negative balances. Additionally, the respondent stated that the bank still will not release the signature cards to us. Additionally, there was an email on July 30th indicating that the accounts are being moved into a trust account. And then just recently, yesterday on August 3rd, there was an email indicating that some of the negative balances were maybe less than appear because they belong to owners who have multiple properties. So some of those properties have positive balances that are offsetting those negative balances. So just to give you some additional information before I read out the possible violations and recommended disciplinary action or recommendations that were drafted before getting that additional information. So the possible violations are 12-10-2171H, 12-10-2171I, 12-10-2171M, and 12-10-2171Q. And possible rule violations are 5.2, 5.9, 5.10, 5.14, and 5.21. And the recommended disciplinary recommendation was a final agency order, public censure, revocation, and a $20,000 fine. And myself and Auditor Ashley Lutz are here to answer any questions you may have.
Okay, so I do have a question because you mentioned that there were updates, which was like actually, I'm glad you gave that update because that was my main question on this one. But you also mentioned that there was going to be a different recommendation. I thought I heard you say that.
This was the initial recommendation that was drafted for y'all before receiving this additional information. So I don't know if the additional information warrants a change in the recommended disciplinary action for y'all.
I guess, are they still commingling if they have?
Yes, it appears as of the response yesterday that they are admitting that they've been commingling funds, but they're using their broker funds to offset the negative balances for the certain owners who have had work on their properties that didn't have sufficient funds to pay for those balances. So it appeared through the email that they were admitting to the conversion and the diversion that took place in the account, as well as commingling that took place. Prior to, these recent responses, there was still quite a bit of kind of lack of communication that has been going on.
Okay, and then they mentioned that they're going to be opening a new trust account because I know that was an issue of getting the signature cards.
So
they
still haven't provided any signature cards, and they're insisting that the banks are refusing to provide them. They did provide an email from a banker at one of the institutions they're currently using, indicating that they're moving the account into a trust account. So that appears to indicate that the funds were not being held in a trust account, but are in the process of being transferred into one. Still not completed yet, though.
Okay. On this one, I know that there was a pause in communication, but I don't know. I know there was a fire. I don't know what's all going on here, but in this one, I feel that maybe we could pull back revocation and add some audits, and probably the fine needs to come down just a little bit, but I don't know. I think it sounds like maybe they're headed in a better direction. So I'm open to hear what the other commissioners have to say about this one, but my knee jerk wasn't like revocation when I initially especially if there were some updates. So
Have they ever gone through an audit before?
They've gone through an
Past-
investigation before in the past.
They have or haven't?
They have, which resulted in a stipulation for diversion that required this follow-up audit.
Okay, so this was a follow-up from previous issues, same type of issues, I'm assuming?
Correct.
Okay. Do you know how long they've been operating?
Since 1998.
Yes, he's been licensed. This respondent's been licensed for quite some time.
Okay. Yeah, I mean, they've got problems all across the board. Did they seem like it was just that they didn't know what they were doing, not intentionally? I don't know if that's a good question to even ask. Judgment call, I guess, on that one, but
I would say, in my opinion, in reviewing the accounting and the reconciliations with Ashley, I didn't see any evidence that supported, kind of ongoing theft
Fraud.
or
Yeah.
anything that seemed, dishonest or malicious.
Okay.
But it wasn't until recently, I think, that we received the ledgers that showed the negative balances were maybe just as of last month.
Yeah, I mean,
So
those are
there's
significant.
yeah, there certainly has been, it's been difficult in obtaining records. I think the records that have come over haven't necessarily come over very organized. There have been what appear to be very legitimate explanations for requesting extensions or asking for extensions, which we have granted at every step through the way. I don't think it would be a bad thing to necessarily give this individual more opportunity through one additional audit to see if they can finally get things in order. I would agree with you, Commissioner Sanders.
Yeah.
I think things are moving in the right direction. They've just done so very slowly.
yeah.
I would agree with that as well. I mean, the penalty I think is fine, but yet take their license at this point and give them one more chance. I think it'd be fine.
And then, I mean, at that point, it's like, we know what's to follow. We know revocation is really the only other option because
Yeah.
they haven't been able to do what they need to do. But, I'm being sensitive to their situation to an extent. I'm sensitive to the fact that they are moving in the right direction. A
Was
fire,
the-
that's a major thing. And I know that
Was
you guys
but it
commented.
was a fire in a building across the street, right? It was smoke damage, they're saying, I mean, is that legit?
It
That
was
explanation?
a legitimate fire. It was a pretty substantial one. You could actually look up the
I
article.
think I
for
know
it.
the
It was a
fire,
large
but
amount.
it was like across the street, right, to a building that was under construction.
The respondent's office building was located very close to where that
Okay.
apartment building fire took place. Yeah, like
There was
directly, I
damage.
would say, across the street.
Yeah, there was some damage to their files or something like that. Do any of the other commissioners have a position on this case?
Well, I agree we can pull back the revocation. I think if we gave them this last
One more
chance,
chance.
and if everything's not taken care of, then I think revocation is the next step. I would leave the fine where it's at.
Yeah.
And my thought was like because I know that fine was based on revocation, so I was thinking like a $10,000 fine. But I'm open to that. And I do have a question. If we require one more audit, what's a reasonable amount of time for an audit based on your experience and your opinion?
I think in this individual's case, given how long this has already been going on, an additional 3 months from the time that they sign the final agency order.
Okay. Thank you. And then Erica, did you have any thoughts or opinions on this one?
No, I'm consistent with you guys on this. I was curious since they had, I wrote down all of the updates that they did. And so I do appreciate that. And so I was just curious if staff had a new recommendation based on that, but it sounds like this has been kind of fleshed out. I would be okay backing off of revocation, dropping the fine. And I just hope it's conveyed to them that like they got to get on this, like dragging your feet is not going to be helpful. And try and get all this stuff going. I think that last ditch effort is helping them at the moment, but it won't help them in the future,
And also, if this does happen to come back to us, if there could be notes in the report, just as a reminder for us, because, obviously we see a lot of cases, but if there could be note that like this happened, they're
on strike too.
Stipulation, we, have this discussion today, and then the next one, that way we know when we see it, we know kind of how we probably would want to address it based on our discussion today. So can we maybe get on the same page with the fine? I know that Bernadette and Tom said leave the fine. I was just saying reduce it because it's not based on revocation now. So I don't know. But
Yeah, I'm fine with dropping it.
To 10.
Still a significant fine, 10 grand.
It's still a heavy fine.
Yeah.
Absolutely.
Very heavy. Yeah.
But we want the revocation, if that ends up happening in the future, to be impactful. So it's like,
sure,
I would,
Yeah, no, I'd be okay with that.
Okay.
I'd follow with,
What'd you say?
I would follow with that then.
Okay. All right. So I'll just throw a motion out there, and unless anyone else wants to make a motion, but I know
Is there, just out of curiosity, because I mean, this is so common, the same issue, is there coursework that can be required that would help them with the financial side? Because it seems like a lot of these smaller, these guys aren't that small actually, but a lot of companies seem to have issues with the three-way recs and the accounts, the types of accounts they're supposed to be holding and where money's supposed to be held. I don't know.
I would feel pretty confident that there are continuing education courses out there for that. We certainly recommend through our referrals to you all continuing education in property management or trust account. We usually use kind of a general term, but when we say trust accounts, I know through settlement that they're able to find those courses. So there definitely are available.
Because I would throw that in there. I mean, they probably need some help in just understanding what the requirements are and how to do these properly. Because it's not a simple thing. And if you're not good with numbers and you're not on top of your record keeping, it can get out of control really fast.
Yeah. So are you recommending, or I should ask you, which course are you recommending?
Well, that's why I was asking. I don't know of a course that is like that, so I don't have a recommendation, but
you mentioned
there must be out there. There must be something out there.
We would recommend to y'all continuing education in trust accounts.
Okay.
Okay.
Okay. Let's go with that. Okay, so I'm just going to put a motion on the table. Motion to accept staff recommendation with the following changes: final agency order, public censure, a fine of $10,000, trust accounts, one more audit in 3 months, and removing revocation. And do we have a second?
Second.
Any discussion?
Mm-mm.
All those in favor say aye.
Aye.
Aye. Any opposed say nay. All right, motion passes.
All right. Thank you.
Thank you.
Okay, the next one is complaints numbers 2025-1422 and 2025-1907. The division received 2 complaints against the respondent for the same incident. The respondent, who was the listing agent on a successful transaction, allegedly altered an HVAC invoice. The original invoice recommended replacing the furnace. The respondent allegedly replaced the language on the original invoice with language stating that the furnace was serviced and cleaned. The respondent admitted that she was responsible for altering the invoice. Possible violations include 1210-217-1C, 1210-217-1Q, 1210-217-1W, 1210-217-1V, 1210-4043A. Disciplinary recommendations are public censure, a final agency order, revocation, and $12,500 or max fines. And Investigator Peters can answer any questions that you may have.
Do any of the commissioners have any questions or comments?
Well, anytime there's fraud, I don't like that at all. But I feel like in this one, she asked the HVAC company to change it. They told her no. She asked again. They said no. He explained why they wouldn't do it. And in the end, the buyer, it was only a matter of a couple months that what could go wrong. I mean, I guess it could have gotten worse because there could have been carbon monoxide poisoning, I think I would stick with staff recommendations. I think changing it, this could have ended real bad. And
Yeah.
I don't like the fraud piece of it, changing something, after
Yeah,
the
Yeah, I think she made some really bad decisions. The inspection should have caught it, which I think it did, didn't it?
No, because
No, the inspection did. It did say that the initial inspector said that the furnace should be replaced, that it was
Yeah.
old, needed to be replaced. They asked for it to be cleaned, and when a company came out to clean it, then that company
Confirmed.
said that it needed to be replaced, that it was already 20 years old and it needed to be replaced. She responded back, "That's not what I asked you to do. I asked you just to clean it
Yeah.
and change your statement saying that it was cleaned." And they didn't ask for it to be certified, but she didn't ask for it to be certified, but just cleaned and maintained. And it wasn't until title reached out that they found out, that the company that did the cleaning is the one that saw.
That's when they became aware of the fact that she altered the invoice. Yeah.
Mhm.
Yeah.
And then the furnace went out.
Yeah, I think we're probably all on the same page that the staff recommendation is sufficient. She forged paperwork. She put these people
Yeah.
in really
She just
bad
made a lot of
situations.
really bad decisions.
And the HVAC, I mean, they did their job. They did what they're supposed to do. They advised, and she hit that because she knew. So that being said, does anyone want to make a motion?
May I just clarify for the record before you commissioners will go into the motion? Nicole, correct me if I'm wrong. I think you read ESP recommendation V was one of the charges. I think we decided not to charge V, and then we were substituting for 1210-443A. Is that correct?
Okay. Yeah, I will change
We not
that.
charge fraud.
So what would be in replacement? What would replace fraud? Fraud, misrepresentation, deceit. Because
No, I'm not talking about that charge. I'm just
Oh.
highlighting 1210-217-1V, which is civil judgment for fraud. We didn't have a judgment there. That is why I was not recommending to charge V. Nicole, did I hear you right that you read V, or did I mishear you?
I did. I read V, that was fraud, misrepresentation to seek conversion.
But did
So
you say
Commissioner
a different number, Irina? Because this says 1210-217-1V. I thought you said something different.
Right, I am suggesting not to go with V because the facts do not support that, but we can support 12-10-404 3A.
Okay, we have that on here.
Go on there.
Okay.
Okay. So what you're suggesting is that we strike out V, Victor,
Correct.
and then keep, which is already there, keep 403A.
Yes,
And you're saying the
and
reasoning is because you don't have enough evidence, I guess. Okay.
civil judgment. We just don't have civil judgment per se in this case.
Okay.
Sorry
And
about
then
that.
max fines too, like
And
that
then max fines, which
Mhm.
would potentially change, but since we say max fines, we're okay. Okay. Okay, so does anyone want to make a motion with those corrections?
So
Yeah, go ahead.
motion to accept staff recommendations with the removing 12-10-217-1V as in Victor,
Okay.
keeping max fines.
Perfect. And do we have a second?
Second.
Any discussion? Okay, all those in favor say aye.
Aye.
Any opposed say nay. Motion passes.
Okay. The next is investigative matter E. Complaint numbers 2025-1654 and 2025-1863. The division received 2 complaints against the respondent for not performing the minimum duties required of a listing broker. The investigation found that the respondent listed several properties for sale without a signed exclusive right to sell listing contract. Instead, the respondent used their own listing contract, which did not contain the required language. The transaction file was also missing required documents. Possible violations are 1210-217-1M, 1210-217-1C, 1210-217-1Q, 1210-217-1K, 1210-407, 1210-408, Rule 7.1, Rule 6.2, Rule 6.5, Rule 6.6, Rule 6.14C, and Rule 6.20. Disciplinary recommendations are public censure, a final agency order, revocation, and a fine of $27,500 or max fines.
Did you
And
say
invest.
I
7
just
point?
want, oh, yeah, you're saying the same thing I was gonna say. Go ahead, Bernadette.
Did you mention rule 7.1?
Yes.
Okay.
And you did mention, okay, because I didn't hear the last two, the broker's disclosures, 1210-408. Okay, sorry. Any commissioners want to comment on this or ask questions? I have one question. Discipline's heavy, but more than like warranted, right? But we have seen other companies like this where it's not automatic revocation, but I was wondering if the fact that this individual said they were going to continue to operate this way was what kind of moved the, the aggressive like revocation.
Excuse me. The respondent said that she would not continue to operate like this in Colorado and that she was closing out her business.
Okay. I thought I read it that she said she's going to continue to operate as I think it says that she's going to continue to operate as a limited broker, which
She said the opposite. I apologize if
okay.
there was anything in the report, but yeah.
Okay. Well, and if she's made the decision that she's not operating here and there's a lot of violations, then I'm not gonna contest the recommendation? Anyone else have comments?
Well, and I think the thing in here too is that it wasn't just with one person, there was two complaints over pretty much the same thing. And so like I almost feel like it's like almost like lending out your license almost. Well, I don't know how you want to put that, but yeah, I agree with the staff recommendations as well.
Well, and I think there was just a litany of items that were on here, but one of the things that really stuck with me is when one of her sellers texted her for help, she said no and referred him to ask the buyer's agent for assistance. And I mean, that is just a no-go. And I mean, if that's how you're operating, you know, we can't do that. That's not acceptable under any circumstances, along with everything else that was there. But that really stuck in my mind.
Yeah, very good point. Okay, so does anyone want to make a motion to accept the staff recommendation then?
I make a motion to accept the recommendation.
Do we have a second?
I'll second.
Okay. Any discussion? All those in favor say aye.
Aye.
Any opposed say nay. And motion passes.
Investigative matter F is complaint number 2026-118. On March 20th, 2026, the respondent entered a plea of guilty to vehicular assault DUI, a class 4 felony. The respondent was ordered to complete 120 days in jail and in-home detention, complete 4 years of probation, and pay $2,875.50 in court costs. The restitution hearing is scheduled for August 21st of 2026. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with the criminal probation. And Investigator Peters can help answer any questions.
Any questions, commissioners? If no questions, do we have a motion? Anyone? Well, I'll motion to accept staff recommendation.
I'll second.
Any discussion? If none, then we'll call the question. All those in favor say aye.
Aye.
Any opposed say nay. All right, motion passes.
Matter G is complaint number 2025-1701. An anonymous complaint alleged that the respondent, an employing broker, was advertising and conducting business under an entity that was not registered with the division. The investigation found that to be true. The respondent was provided a deadline to bring her advertising and business practices into compliance. The deadline was not met. The investigation also found that the lease and property management agreement were not in compliance with division requirements. Possible violations include 1210-217-1M, 1210-217-1A, 1210-217-1Q, Rule 6.10, Rule 7.1, and Rule 5.21. Disciplinary recommendations are diversion, a $1,000 fine, coursework in contracts, coursework in property management, and an audit within 3 months. And Investigator Peters can answer any of your questions.
Thank you. Does anyone have any questions?
Yeah, I think my only question on this one was and I could have missed this for sure, but it looked like she got everything else in, although it was after the deadline. Did she end up getting everything else in?
She provided an updated property management agreement. She provided an updated lease. However, I did not receive the requested bank trust account statements for her property management business.
Okay, so that's why we're doing another audit in the 3 months. I just wasn't sure what we were still looking for on that. I knew we were beyond the deadlines.
Okay.
And yeah, her documents are not in compliance, so they would look at that too.
Okay, great, thank you.
All right, does anyone want to make a motion?
Motion to accept staff recommendations.
Do we have a second?
Yeah, I'll second.
Okay, any discussion?
Nope.
All those in favor say aye.
Aye.
Any opposed say nay. All right, motion passes.
Matter H is complaint number 2025-1335. The complainant purchased a property in which the respondent was the listing agent. After the property closed, the complainant discovered material defects. The complainant alleged that the respondent knew about the material defects but did not disclose them. The investigation found that the respondent did not provide a complete transaction file of a prior unsuccessful transaction. Possible violations include 1210-217-1N, 1210-217-1Q, 1210-217-1C, 1210-4043A, 1210-217-1K, and Rule 6.20. And disciplinary recommendations are final agency order, public censure, coursework and ethics, and a fine of $5,000. And again, Investigator Peters is here to help answer any questions.
Okay, any questions, comments, commissioners?
I agreed with staff recommendation.
Yep. All right, do you want to make a motion?
Motion to accept staff recommendation.
Do we have a second?
I'll second.
All right, any more discussion? All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion passes.
The next is matter I, complaint number 2026-57. The Colorado Real Estate Commission opened this complaint against the respondent to address potential license law violations discovered during the course of the investigation into complaint matters 2025-951 and 2025-1734. Concerns were identified related to competency, trust accounting, record keeping, brokerage disclosures, advertising, transaction file requirements, and standard forms. Possible violations include 1210-217-1N, 1210-217-1Q, Rule 6.20, Rule 7.1, Rule 5.5, Rule 5.14, Rule 6.2, Rule 6.5, and Rule 6.10. Disciplinary recommendations are public censure, a final agency order, a fine of $8,000, coursework in brokerage relationships, coursework in contracts, coursework in trust accounts, coursework in property management, and a license downgrade with a high level of supervision for 2 years. And Investigator Geske can help answer any of your questions.
Commissioners, do you have any questions or comments?
I agree with staff
I would agree.
And Tom, I'm sorry, what did you say?
Yeah, sorry, I just said I agree with the recommendations.
Okay, both you and Erica said you agree. Does either of you want to make a motion?
Yep, I'll make a motion to accept the recommendations.
Perfect. And do we have a second? You seconded, Erica?
Yeah.
Okay, perfect. Any other discussion? All those in favor say aye.
Aye.
Any opposed say nay. Motion passes.
Okay, the next is matter J, complaint number 20.
Wait, I'm sorry, before we go into that, we do have Bernadette that has to recuse.
Yeah, I will be recusing myself due to actual or potential conflict of interest in this one. If you can notify me when I can get back on, I'd appreciate that. As for now, I will jump off the call.
Okay.
Let me find where to jump off this call on here. Well,
Matter J is complaint number 2025-40. While acting as the buyer's agent during a purchase transaction, the respondent was copied on an email communication in which direct payment of $15,000 was requested by the loan originator prior to any loan being delivered. In total, the buyer paid $37,500 over 4 payments, the last of which was paid directly to the loan originator via wire transfer. In reviewing the loan contracts and agreements provided, it was identified that several required upfront payments contained typographical errors and listed no NMLS ID for the lenders. These lenders were not registered with the NMLS. The respondent admitted that these issues were not identified. The respondent noted that this was her first time dealing with this type of loan product and took the loan originator at her word regarding the loan process. During the interview, the respondent confirmed that she did not seek guidance from her employing broker while this transaction was ongoing. Possible violations include 1210-217-1Q, 1210-217-1M, 1210-4051B, and Rule 6.2. Disciplinary recommendations are diversion and a fine of $1,000, and Investigator Martinez can help answer any questions.
Thank you. Commissioners, do you have any questions, comments? I have a comment. I just want to say, I do agree with the recommendation, but I want to just kind of clarify that there was in the report, there was a lot of mention about the loan and whether or not this broker should have identified the loan issues. And I just want to say, I really want to be careful to not put the task of regulating brokers on or we'll say mortgage originators on, real estate brokers, because that is an area we really, shouldn't be regulating. That being said, because she had a employee, like she's never dealt with a hard money loan, and she may not have understood all that's involved in that. I think that she really should have sought guidance. So I think that that's one area that she has to own up to. But more importantly, I think that where her responsibility lied in and where her kind of failure to execute this properly was in not guiding her buyer to protect their earnest money. And that to me is where I think that she's at fault. But I just want to clarify, because this only mentions loan stuff. Really, I find her issue not in the loan, but in the other areas where she should have protected her client. So I just want to say that, because I don't want to set a standard that agents should be monitoring lenders. The other thing is, most of the time we don't see the stuff that she was able to see.
Yeah, that was
yes, it
that was
should have
gonna be
created a
my
red
question.
flag, but
Yeah.
we don't see that stuff typically. So I don't want to set any kind of standard that brokers should be investigating that deep. If we have a licensed originator, they have a regulatory process. And I just don't want us to be liable for something that originator does. But I think this is all still warranted because there were some mishaps on her part.
Did the respondent know that the lender was asking for money? I mean, that's odd to ask for money before closing.
So she was
Yeah.
copied on one of the emails, and that is exhibited. Let me get you the exact email.
It was the first email, right? That she was-
No, actually, the buyer had made several payments prior to this email where our respondent is copied on it. But the email, hold on one second.
And did they essentially just steal the money, the lenders?
So the money was kept in the investigation of the loan originator. We identified that those lenders weren't actually registered with the NMLS. They didn't appear to be real companies. We didn't get responses to our subpoenas for loan files from them. So yes, the money is still missing. Now, the $15,000 payment, which was the final payment that the respondent had made, that is the email that is cited in Exhibit 5, page 37. And that's where the loan originator is specifically asking that the borrower pay $15,000 to her directly, and it be wired to her personal account. The buyer's agent is CC'd on this, and per the conversation with the complainant, he was never warned about the risks of paying this money directly to the loan originator. Now, the respondent did explain that she had conversations with the buyer and said that she advised him of the risk, but couldn't point to anything in writing that specifically shows her instructing him to be careful or possibly to not make that payment. We also discussed in the interview that any payment that's collected up front should have been kept in an escrow account, and the fact that the loan originator was requesting that it be paid directly to her personal account should have caused some red flags.
Big red flag.
Yeah, and that's where she really should have sought guidance, I think, when she saw that. Like, she should have went to her managing broker and said, hey, this is what's going on. The other question that I had regarding these quote unquote lenders who are not lenders, have they been referred to the Attorney General? Because this now sounds like a criminal case.
Yes, so we did investigate the loan originator. The loan originator was revoked. It did also go criminal, but I don't know where they're at as far as trying to identify any of the people that were at the supposed lender institutions.
Okay.
It looks like the money that that was wired by the buyer to these lenders. It looks like it actually wound up going to personal accounts. When we subpoenaed those bank records, they would not provide the bank records, but it did appear that those were for personal accounts, not for accounts for a company or a lender specifically.
And then one last question, and my understanding, I want to make sure I was right though. The loan originator that facilitated this whole thing was licensed.
That's correct.
Because the person had used her the year prior and they had a smooth transaction.
Yes.
And then this time she's thinking, she knows she's licensed. This is why I was just saying I don't want, brokers to have the responsibility of regulating the lenders because they're especially if they're licensed. But doesn't mean like if you see a red flag, you don't investigate, but nonetheless, so that lender was licensed and has since been her license has since been revoked.
That's correct.
And there's criminal charges.
That's correct.
That are okay. All right. Well, I just wanted to say that piece, but do we have any other comments?
Erica, I agree with you 100% on all of those. That was a concern of mine as well, that we were heading down a road or a path that maybe we need to be a little cognizant of when we're really investigating what her involvement is with the lenders and what the lender side of that was. But I do agree that the disciplinary recommendations are appropriate just based on the other issues that fall under the licensing portion of it for her license. So that's where I stand.
Perfect. Okay. And does anyone want to make a motion?
I think there's some coursework that she needs to take. Something about fiduciary responsibility, because it does seem like with the security deposit in particular, I agree 100% on that. She should have protected her client there and she didn't. So I don't know.
If nothing else, she should have, she had an opportunity to terminate and get that earnest money back. The client didn't even know that was an option. So that's problematic right there.
Yeah, I agree.
So what, is there any, what'd you say?
Would that fall more under contracts class?
That's what I was wondering. What coursework would?
Well, we have the option of contracts or brokerage relationships, ethics.
Well, if we're concerned about her knowing the process for getting that earnest money back and terminating, then certainly contracts would be warranted at minimum.
Yeah. Yeah, that's
I
fine.
like that.
Yeah.
Because that's the part where she definitely didn't disclose. And then, I think from this lesson, hopefully she knows next time to seek guidance when she's unsure of, and
Yeah.
she's experiencing something new and there's some areas of that she's just not sure about. Hopefully she'll seek guidance. Okay, so I guess we need a motion. I don't know if I'm really supposed to make the motions, but motion to approve staff recommendations with the addition of contract coursework.
Second.
Any discussion?
Nope.
All those in favor say aye.
Aye.
Any opposed, say nay. Motion passes.
Matter K is complaint number.
We want to call Bernadette back in.
Oh, sorry.
Yep.
Okay. Can you hear me okay?
Yes.
Yes.
Okay, investigative matter K is complaint number 2025-627. The complainant alleged that the respondent forged her signature on a document following her resignation from the respondent's team. Although the allegation of forgery could not be substantiated, the investigation found that the respondent designated her entire team as the broker of record in Section 3.3 broker of the listing contract. Furthermore, the respondent failed to execute necessary documentation and improperly lent her license for use by her team. Possible violations include 1210-217-1M, 1210-217-1Q, and Rule 6.1. Disciplinary recommendations are diversion, a fine of $1,000, coursework in brokerage administration, and coursework in contracts. And Investigator Gabarty can answer any of your questions.
Thank you. Commissioners, any questions or comments?
Nope.
And if none, does anyone want to make a motion?
I'll make a motion to accept the staff recommendations.
Do we have a second? Okay, Erica, second. And any discussion? All those in favor say aye.
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 Any opposed, say nay. Okay, motion passes.
Okay, matter L is complaint number 2026-936. The Colorado Real Estate Commission initiated a complaint against the respondent alleging that she signed documents in the name of another real estate broker without authorization. Possible violations include 1210-217-1Q. Disciplinary recommendations are public censure, a final agency order, revocation, and a fine of $2,500 or max fines. And again, Investigator Gabarty can help answer any questions.
Okay, does anyone want to discuss or have questions?
Yeah. So this is part of the one that was from the case before.
Yep.
Yes.
So the managing broker, she gets a fine of $1,000 and some coursework. This one, and I'm not happy with anything that's looks like fraud, right? At all. But this one, and even the complainant, you know, they even said that the complainant had even signed others' names in the past. And this one has a full history of doing it for, it sounds like even more than one or two people over there at the brokerage. Um, and it was something that there's like a long history of her helping do this. I wouldn't revoke her license on this.
And
I don't.
Bernadette, I have a similar like comment. Now I think this is a significant violation, right? You definitely shouldn't be forging. I think in this instance, not that it's right, I think that they had this particular team had a practice of doing this, and so I don't think that this was done. I know this, I mean,
Maliciously.
maliciously,
Uh-uh.
not that it makes it right. But I agreed. I actually came up with what I thought would be better discipline. I think there's room for correction here. I think that again, for some reason they had this practice, which the managing broker I'm sure was aware of. And we barely, you know, discipline was pretty minimal. And so I would advocate for just different discipline. And what I kind of jotted down was I think that 1210-2171Q should be there. But I also think that it should be, and I don't have the statutes, I'm sorry, but violation of commission rule should be there. I think deliberate misrepresentation should be there. And I think competency as a rule, 6.2 should be there. But I think it should be a FAO, public censor, coursework and ethics, a fine of $7,500.
I would agree with that. I wouldn't take away her license, but I definitely agree with the coursework and ethics. And I do think that I think revoking her license, it's almost making her the scapegoat for a lot of the other stuff, for whatever was going on there and what they allow. But I don't think she should be the one paying the, you know, losing her license over this. It seems like there, and who knows? I mean, if all of their files were audited, is there more people that are signing for other people, helping others out? I don't know. But it sounds like it was pretty common there. So I think making this one pay the biggest price by losing her license wouldn't be the right thing to do. Um,
I agree with that. I think that I don't know what the relationships were, but if she was working as sort of a junior broker under senior brokers and they're telling her just sign our stuff, I think that stuff happens more often than we all think with transaction brokers. 7,500 seems, I definitely agree she shouldn't lose her license. 7,500 fine seems pretty hefty. But
And hey, that's open for discussion. It's just something I thought, you know.
yeah,
And so if there's a different number that you think, and also different violations that you guys think. I also was under the impression in reading and looking through all of our the file on this. I was just under the impression that this was kind of something that they did, but it
yeah,
came up because now this person left, so then it was more of an issue. But
yeah.
I think she should be disciplined for sure. I just think the recommended discipline was a little harsh, and I think that she can be corrected. Um, she wasn't doing this to cause harm, I don't think. Not that it's, and I'm not saying that this is okay. But I think that this was a bad practice, and I think that there's room again to correct this behavior. And I would imagine that we probably wouldn't have this problem again with this person.
Yeah.
But any thoughts, Erica?
No, I agree. I thought this was kind of reversed a little bit. I do think that she was the one that they came down on this. I wouldn't believe for a minute that the people above her didn't know that this was going on and that she's not been helping others with this. So I think that this is should be kind of a wake-up call for how they do business there. I should watch this very carefully. This should not be happening. And I do think that revocation would be steep and unwarranted a bit for this, although we definitely need some disciplinary recommendations to still be, I'm sorry, my brain is just like
It's been 8 hours.
a
Let me tell
long
you.
day. I have it in there. I just need to get it out. I still think that we need something here to make this impactful, that you really can't be doing that.
And so I kind of laid out what I came up with. You know, just off the whim, I may have missed some statutes and stuff, but I would just repeat those just in case anyone has input or wants to add or take away. But again, it was leaving the unworthy, incompetent practice, adding violation of commission rule, adding deliberate misrepresentation, adding rule 6.2 competency. And if there's any others anyone can think of, let me know. And then it was FAO, remove revocation, public censor, ethics, add ethics, and a fine. And I said 7,500, but I know that you guys might have a different idea there. So does anyone want to add any rules or statutes? Am I missing anything? Maybe
You had a
staff can-
different suggestion for a fine. What would
Yeah,
you
I would go in the middle then, 5,000. That's still a pretty hefty fine. But it is, I don't know. I mean, 7,500 would be acceptable too.
And that was just really going 2,500 on each of those violations, each of the statute violations. That's kind of how I came up with that number. But does anyone else want to change it? So we have 5,000. Bernadette, your thoughts on that?
So I could go either way with it. I think going 5,000 and adding the coursework, I think would be fine, you know, and with the other ones that you added. So I could do that, but I would remove the revocation for sure.
Okay. Erica, any thoughts on the fine?
I'm fine with that, splitting the difference. I think that's reasonable.
Okay. So, and everyone likes the other changes?
Yeah.
Yeah.
Because if so, we'll just keep those and then go with the $5,000 fine.
Okay.
Okay. I will make the motion mainly because it's in front of me. And I wrote a lot of notes on it. So motion, how did I say that earlier? Motion to change disciplinary recommendation to the following. Oh gosh, I need statute numbers if anyone can help me with that. I'm so sorry.
Yes,
Is anyone on
I
staff
can.
available to help me with that? Okay.
Yes, Commissioner Sanders, I can. I think
Okay.
you are trying to find a violation of 12.10.217.1C, 12.10.217.1M, 12.10.217.1Q, and Commission Rule 6.2, correct?
Wait, hang on. Why do we have 3? I just got 4. Okay. 1210. Wait, hold on.
Yeah,
Okay.
217.1C,
Is that the
1M.
violation of commission rule? That's not that one.
No, M is a violation of Commission Rule, and that will go with your Rule 6.2.
Yep. Okay. Okay, so 217(1)(n) would be violation of commission rule. And then what's the deliberate misrepresentation?
I believe you're talking about 12-10-217-1C.
Okay, that one's 1C. Got it. I just had them laid out the other way. Okay.
And I believe you also wanted to keep the Q, 12-10-217-1Q.
Yes. Yes. Okay. Thank you for that. Now I'll make the motion. So motion to change the disciplinary recommendation to possible violations 12-10-217-1Q, 12-10-217-1M, 12-10-217-1C, Rule 6.2, final agency order, public censor, coursework and ethics, remove revocation, and a fine of $5,000.
Second.
All right. And do we have any more discussion on that?
No.
Okay, let's call the vote. All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion passes.
Matter N is complaint number 2026-451. On February 4th of 2026, the respondent entered a guilty plea to 1 count of assault in the 3rd degree at-risk person, a class 6 felony, and 1 count of assault in the 3rd degree, a class 1 misdemeanor. On April 1st of 2026, he received a sentence consisting of 90 days incarceration, a 2-year deferred sentence with probation, and court-ordered financial obligations. These financial requirements included $1,846.50 in court costs and fees, as well as $3,127.63 in restitution, all of which have been paid in full. Possible violations are 12-10-217-1N, and disciplinary recommendations are diversion, a fine of $250, and probation to run concurrent with the criminal sentence. And Investigator Gabarty can answer any questions.
Thank you. Any questions or comments, commissioners? If none, does someone want to make a motion? I'm gonna just be motion to, unless there's a different motion, are we, if there's no questions, are we motioning to accept recommendation? Unless someone wants to make a different motion.
I'm looking back at what I put here, so I didn't write enough notes down, I don't think, but I wanted to.
He claimed he was off his meds or something, right?
Oh, that's right. This is the one that was off his meds. Yeah, I think I do recall that one.
It had nothing to do with any sort of, I mean, he had an assault charge unrelated to any sort of real estate transactions,
Yeah,
right?
but
Not that that matters, but
right, because typically when someone has a criminal charge, they do get a violation, and the 250 usually reflects an amount when they reported it. Is that right, Nicole?
Yeah, that's correct. Yes.
Okay, so this is,
and did he did report it in the
he did
30
report
days?
it.
Okay.
Yeah, that's why the
Yeah,
fine is
I mean, I
250.
think that's fine. I would agree with the recommendations.
Do you want to make a motion?
Yeah, I'll make a motion to accept the recommendations.
And do we have a second?
I'll second it.
Okay, any more discussion? I know you were looking at some things, Bernadette.
No, I'm good.
Okay, well, let's call the vote. All those in favor say aye.
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 Those opposed say nay. Okay, motion passes.
Matter N is complaint number 2026-622. On February 27th of 2026, the respondent pled guilty to a class 1 misdemeanor harassment, strike, shove, kick, a class 5 felony, domestic violence habitual offender. The respondent was sentenced to 2 years in jail and court costs and fees of $736. The estimated mandatory release date is November 6th of 2027, at which time he will serve 2 years of mandatory parole. Possible violations include 1210-217-1M, 1210-217-1N, 1210-217-1P, and Rule 6.23. Disciplinary recommendations are public censure, a final agency order, revocation, and a fine of $7,500 or max fines. And again, Investigator Gabarty can help answer any questions.
And any comments or questions, commissioners? I did have a question. So this person was taken to jail, and I'm like, okay, how do they notify the commission if they're in jail? Like, it's kind of, I would imagine, difficult to make that notification. Revocation makes sense because they're in jail, so they can't practice from jail. But yeah, he didn't notify the commission, but could he when you're arrested? So that's a question I had.
Because it says that he didn't respond to any correspondence.
And he can't get that if he's in jail.
Yeah, that's what I said. And I said, could it be because he was in jail? But I also put that I agreed with staff recommendations. This is not a first time, it's a habitual offender. And I did say, can it be suspended until he gets out of jail, considering? But I mean, if we revoke a license, he's not going to be practicing because he's sitting in jail. And then afterwards he has probation. So how long did it say his probation was after he gets out? Did it say?
2 years.
2 years parole.
Parole, yeah, parole.
Parole. Oh,
I
so
just
it's
wanted-
parole. So he's direct. He's I guess in Department of Corrections, not just jail. If it's on
Correct.
parole,
Right.
So Department of Corrections and not just like a county jail thing. It's two different things, I think.
Yes. And I just wanted to point out too that the date of the guilty plea was February 4th of 2026, and the date of sentencing was April 1st of 2026. So he had time to notify us of the guilty plea.
Yeah.
Okay.
There's
Thank you
that.
for that clarification, because I was really just trying to understand how
Yeah.
he could notify and respond to correspondence if he was away.
Yeah, if he wasn't,
If he was detained.
Yeah, if he was in jail from that April or from that February until that April, that's one thing. But if he was not sitting in,
Okay.
if he was not, then he would have had time to try to get his affairs in order before, he was getting sentenced. This would be one of those affairs that you would get into order before, going into Department of Corrections.
Okay.
So he
Well,
might
that answers
have had a
my
little bit of time
question.
afterwards. He may even have had time afterwards to get his affairs in order if he knew that he was going into Department of Corrections. So I would agree with staff recommendations.
Yeah. I with that new, I mean, the only thing that would have changed was maybe the, failure to notify, but if he had that time, I also agree with staff recommendations. So would you, Bernadette, want to make a motion?
Yep. Motion to accept staff recommendations.
All right. A second, anyone?
Second. Yep.
Okay. Do we have any more discussion? I'll call the question. All those in favor say aye.
Aye.
Anyone opposed, say nay. Okay, motion passes.
All right. Investigative matter O is complaint number X 2025-159. A routine audit was opened on the respondent on September 19th, 2025. A correction letter, a final notice to comply, and multiple extensions were provided in order to accommodate brokers' health situations. So numerous items were corrected during the audit. Outstanding concerns remain. Specifically, money belonging to others is still being held in non-fiduciary accounts, and full reconciliations have not been provided for 3 of the 4 current accounts. Additionally, it appears that the respondent has not disclosed maintenance markups and may be charging tenants maintenance fees in excess of statutory cap. Possible violations are 1210-217-1H, 1210-217-1M, 1210-217-1Q, 1210-217-1T, Rule 5.5, 5.14, 5.17. Disciplinary recommendation is a fine of $1,500, diversion, coursework in trust accounts, and coursework in property management. Financial examiner Meredith is not here today, but I will attempt to answer any questions you may have.
Thank you. Any questions, comments, commissioners?
My only question was why we weren't asking for a follow-up audit on this one.
I have the same question, actually.
Yeah, I mean, that's definitely something we can add because this was their first audit.
Sure. I mean, it looked like they were making good progress, but there was just, some things that were outstanding. And I just felt like maybe one more audit, they could hopefully bring it into compliance.
What would be the recommended time for a second audit, Sarah?
I mean, I think we usually do about 6 months.
Okay.
Yeah.
Did he ever disclose the markups on the maintenance fees?
I don't believe so. Let me check in the report though, because I know that there were some changes made.
Because if I recall correctly, I think he said it's the cost of doing business was what one of his comments was, or something very similar to that. But at the same time, then we want those people have the option to shop for stuff and not just be marked up. So I didn't like that. I just want to know if he ever started following through with that and notifying them.
Yeah, I'm looking in the report quickly. It looks like there was a pricing sheet that he's including. And he's encouraged to contact his attorney. But I don't have anything in the audit that shows that he has.
Yeah, because I think from the beginning, I'm trying to go off the top of my head, that he gave them a pricing sheet earlier on, but with the markups on there, but it doesn't state that there's a markup and that obviously he would probably be making some money off of that.
Yeah. Yeah, in the conclusion
cost of business.
Yeah. Yep. And in the conclusion of the report, it's still listed as, hourly maintenance fees not being disclosed to tenants or property owners. So we've gotten no new information since the report that has been done.
So it looks like the sale of the business has not happened yet, right?
Oh, yeah, that's right.
I mean, chances are if someone else is thinking about taking his portfolio, he's going to have to reconcile his numbers. And if they can't do that, they could back out.
That's the one. I know the next one he's selling his business.
Yeah, I was going to say, I thought there was.
Yeah, that's the next one.
Because that one had a more serious
am I on the wrong
discipline.
one?
Yeah, we're on matter O. Yeah.
This one has the initials KA.
Oh, I'm on P. Whoops.
Yeah, we're not there just yet.
Okay.
So let's go ahead and get a motion on this
Getting ahead of
one.
ourselves here. Yep.
I
Okay.
would move to accept staff recommendations with the change to add an audit in 6 months, a follow-up audit in 6 months.
Thank you. A second?
I'll second that.
Do we have any discussion?
I actually had one more question.
Mhm.
And oh, he states that his daughter helps him. Is she licensed or is she just an employee? Do we know?
Um, I don't know off the top of my head. Um, yeah, I guess I'm not sure.
Okay.
Yeah, I
I just
apologize. I
wondered,
wasn't the auditor, but I don't see anything
I
saying.
just wondered if she was licensed as well and also is like knows rules and is helping and not and stuff is still getting by without being done properly. So I was curious about that, but I just know that I have a note to myself that says that his daughter helps him and a question asking is she licensed or so I was just curious about that.
Okay, thank you. I'll go ahead and call the question. All those in favor, say aye.
I
Any opposed, say nay. Okay, motion passes.
All right, commission matter P is complaint X 2026-3. This audit was initiated as a result of the October 24th, 2025 signed stipulation agreement. The respondent confirmed the audit notice on January 8th, 2026, but did not respond. The respondent received a final notice to comply, but prior to the due date, the respondent was in a life-threatening car accident on February 3rd, 2026. The division provided numerous and lengthy extensions to accommodate his critical situation. The final deadline was set for April 6, 2026. The respondent submitted a narrative explaining that he would be selling his business. Another extension through May 15, 2026 was provided with the understanding that there needed to be evidence of the sale of the business or compliant documents would need to be submitted. On May 15, 2026, the respondent's law firm sent a loan approval letter for the potential buyer, but provided nothing else. It did appear that one of his former associate brokers was the primary interested buyer, and that broker stated that the closing was to be July 15, 2026. On July 16, 2026, the auditor asked the respondent's attorney to confirm the brokerage had been sold and asked for the final set of the financial documents, including evidence of compliant three-way reconciliation. As of July 23rd, 2026, the respondent has not submitted any response regarding the sale, nor has he submitted any documents requested within this audit. The original audit was opened in February of 2025, and the broker has never submitted a compliant reconciliation or any evidence of effort towards compliance between the October 24th, 2025 stipulation and the date of his February 3rd, 2026 car accident. Possible violations are 1210-217-1H, 1210-217-1Q, 1210-217-1M, and then a second violation of 1210-217-1M for the stipulation violation. Rule 5.14, Rule 5.21. Disciplinary recommendation is public censure, a final agency order, revocation, and a fine of $12,500 or max fines. Again, financial examiner Meredith is not here today, but I can answer any questions that you might have.
Thank you. Any comments or questions, commissioners?
So did we find out if he sold the business?
So as of the last time that we had checked, July 23rd, we had not. Yeah.
And any other updates besides that? Okay.
Has he submitted any sort of financial records that show what his accounts are? Like, do we even know, is he missing security deposit funds or anything like that? Do you have any clue, since he hasn't done a throughway rec successfully, it sounds like?
Correct. Yeah, it's hard to tell without that reconciliation.
Chances are.
Yeah.
Hate to say it, but yeah, I don't know. If he doesn't, I mean, I would add on this education, but if he's selling it, that's kind of pointless. But
Did the attorney ever respond on whether it went through with the sale? The attorney never responded on anything else, or any of the documents?
Not regarding the sale, no, or the reconciliations, yeah.
Then I say we stick with staff recommendations on this one.
Okay, you want to make a motion?
Yep, recommend, agree with staff recommendations, in this one, so.
So motion to agree.
Motion to accept staff recommendations.
Okay, do we have a second?
Yeah, I'll second.
Any discussion?
Nope.
All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion passes.
Good evening, Commissioners. Commission Matter Q is complaint number 2025-54. The complainant is a 78-year-old, suffers from multiple medical issues, and had a 50% ownership of a property he wished to sell. The complainant believed the respondent was his friend. In 2023, the respondent presented to the complainant an offer to purchase for $150,500 from her boyfriend of over 20 years, buyer number one, which included buyer number one agreeing to obtain clear title. The complainant alleged that when he told the respondent that the offer was too low, she told him it was a good deal because of the title issues. The complainant alleged that the respondent later failed to tell him that buyer number one had an offer from another buyer, buyer number two, for $235,000. The complainant also alleged that the respondent and buyer number one colluded and manipulated him, which resulted in buyer number one obtaining $84,000 of his equity. The investigation also noted the potential violations that the respondent failed to establish in writing her brokerage relationships with the complainant, wrote the contract without a closing date, failed to extend the contract between the complainant and buyer number one, acted under transaction brokerage for the complainant and buyer number one, failed to disclose to the complainant in writing her personal relationship with buyer number one, failed to ensure that the closing accurately reflected the terms of the contract, acted under transaction brokerage for buyer number one and buyer number two, failed to disclose to buyer number two in writing her brokerage relationship, failed to disclose to buyer number two in writing her personal relationship with buyer number one, failed to provide buyer number one with a change of status, changing from a seller's agent to a transaction broker, and disclosed confidential information to buyer number one regarding buyer number two. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-217-1W, 1210-407-2B, 1210-407-3F, and noted below 1210-402-8, 1210-407-1, 1210-408-2A, and rules 6.2, 6.5, 6.6, 6.9, 6.14A1, and noted below 617A and 619. The disciplinary recommendation is a final agency order, public censure, revocation, a fine of $30,000 or max fines, and Investigator Deanise Wright is here to answer your questions.
Well, thank you. Commissioners, any questions on this one?
There's a lot going on in this. I feel like one, it's the victim is a at-risk adult. I think she knew exactly what was going on. He loses a lot of money in this. There was harm done. I completely agree with the staff recommendation. I would also ask if the Attorney General's office looks at this for the deception and for due to the loss of that 84,000 in equity, that they just turned around and decided that, it was a business deal. He wasn't involved in the business deal. And I think they stole from him. I would refer this also to the Attorney General's office to see if they can do anything about that.
Anyone at staff want to respond to that?
We don't currently have that on there, but I mean, you can certainly instruct us to do that.
Okay. Yeah, I mean, obviously this is not good. Um, I think she did know about this. I mean, this was a wholesale deal that her partner was involved in, and she was aware, and she did not disclose that fact to her seller. Maybe had she disclosed all the details, it would have been different. But the fact that she didn't, I think, warrants the recommendation. Does anyone else have any input as to whether or not they agree with the recommendation?
Well, in his written statement, he states that the date of the closing, she even told him, oh, the other buyer isn't going to make it. And, it was going to be 2 hours late, and still kept talking about the other buyer, not that her boyfriend was going to be the actual buyer. And he didn't even know how much he was getting until he checked his bank. So I think there was a lot of deception with this. And again, like I said, I would recommend the Attorney General's office take a look at this.
Do you want to make the motion?
Yes. So
Commissioner Bugarin, just before we make a motion, I just wanted to clarify that we're referring to correct agency. Attorney General Office, it's us, Gina and I. Then there is Attorney General's Office in terms of consumer protection. That's a different section. That could be an option. Or are you referring, or would you like for it to be referred to law enforcement, which probably not be Attorney General's Office, criminal law enforcement versus Attorney General's office, that is Gina and I, and then there is Attorney General's office like consumer protection. So I want us to be more clear.
So I thought it was your office that did it, but maybe I'm wrong on who looks at that, because I do feel like there was some criminal behavior with this, but I'm not 100% sure they know or understand like this piece of it, right?
So to
I think
refer
it,
to criminal agency, you guys don't have to put that in your recommendation. We are able to do that. But if you want to just say refer it to, an appropriate agency, we
Okay.
can certainly work within our contacts and get it to the right person.
Okay. Okay. So motion to approve staff recommendations in addition to referring to the appropriate agency
Okay.
for, I guess, illegal behavior. I don't know how I would say that.
Law enforcement.
To law enforcement. Okay. There we go.
Okay. Do we have a second to that motion? Okay, I'll second the motion. And any more discussion? Okay, well, let's go ahead and call a question. All those in favor say aye.
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 Any opposed say nay. Okay, motion passes.
Okay, Commission Matter R is complaint 2026-1100. On October 7th of 2025, the respondent entered a plea of guilty to assault 3, no reckless cause injury, a class 1 misdemeanor. The respondent was also sentenced on October 7th, 2025. The respondent did not notify the division of the conviction. The division was notified of the conviction via a CBI report. The respondent accepted a 12-month deferred sentence. Respondent also agreed to pay court costs in the amount of $513.50. The respondent has paid all of the court costs and is currently completing the remaining months of the deferred sentence, which will end October 7th, 2026. Possible violations include 1210-217-1M, 1210-217-1N, 1210-217-1P, Rule 6.23, and the disciplinary recommendation is diversion, a fine of $500, and probation to run concurrent with the criminal probation. And Investigator Denise Wright is here to answer any questions you might have.
Any questions, commissioners?
Mm-mm.
No, I agreed with staff recommendations.
Okay, you want to make the motion?
Motion to approve staff recommendations.
Do we have a second?
Second.
Perfect. Any discussion? All those in favor say aye.
Aye.
And then any opposed say nay. Okay, motion passes.
Commission matter S is complaint number 2026-1105. On August 12th of 2025, the respondent entered a plea of guilty to assault 3, no reckless cause injury, a class 1 misdemeanor. The respondent was also sentenced on August 12th of 2025. The respondent did not notify the division of the conviction. The division was notified of the conviction via a CBI report. The respondent accepted an 18-month deferred sentence, including 18 months of probation, domestic violence evaluation and treatment, 24 hours of useful public service, and anger management counseling. The respondent also agreed to pay court costs in the amount of $591.50. The respondent has paid all of his court costs, has completed 24 hours of useful public service, and has completed the domestic violence treatment. The respondent is currently attending monthly counseling. The respondent's deferred sentence should end in February of 2027. Possible violations include 1210-217-1M, 1210-217-1N, 1210-217-1P, and Commission Rule 6.23. The disciplinary recommendation is diversion, a fine of $500, and probation to run concurrent with the criminal probation. And Investigator Denise Wright is here to answer any of your questions.
Thank you. Any questions, commissioners? Okay. Does anyone want to make a motion?
I'll make a motion to accept the staff recommendations.
Do we have a second? Perfect. Erica, second. And any discussion? All those in favor say aye.
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 Any opposed say nay. And motion passes.
Commission matter T is complaint 2026-620. On March 24th of 2025, the respondent received a deferred judgment and sentence on assault 3, a class 1 misdemeanor. The respondent was sentenced to 24 months probation. On May 11th of 2026, the respondent's deferred judgment was revoked due to a DUI conviction. The original 2-year probation sentence remained, which runs through March 11th of 2027. The respondent did not notify the division of the 2025 conviction. The respondent failed to respond to notification letters sent by email and U.S. mail, including a certified letter mailed on June 10th, 2026. The respondent also failed to respond to phone calls. Possible violations include 1210-217-1P, 1210-217-1M, Rules 6.23 and 6.25. The disciplinary recommendation is diversion, a fine of $750, and probation to run concurrent with criminal probation. And Investigator Coates is here to answer any questions.
Any questions, commissioners? I just have one quick one. Did you ever reach him? Or her? Whomever, this person?
I don't think they were ever able to reach them. But Robin, am I wrong?
I'm sorry. I was unable to reach the respondent.
Okay. Okay. Anyone want to make a motion or have any questions or comments?
So when they don't, go ahead, Erica.
Well, I was going to motion to approve, but it sounds like you have a question, so.
So what happens when they just don't respond to this? We just give them the fine and hope that they see it when they have to renew their license, and if not, it gets suspended. He just goes on without saying anything. Like, how does that work?
Yeah, I'll give you a very short. So what will happen after you make a decision, I'll send out the settlement offer to him. If he does not respond to the settlement offer, then it's referred to the Office of the Attorney General, and they will file with the administrative courts, and we need to get a decision that way. So you just vote on what you think is the appropriate discipline, and then we'll carry it from there.
Okay.
Okay. And then Erica, you were making a motion.
Motion to approve staff recommendation.
Do we have a second?
A second.
Okay. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Motion passes.
Okay, matter U is complaint 2026-1890. Actually, I need to make a correction there. I'm sorry. On your agenda and in the report, the complaint number is correct. Right here on this referral, it's incorrect. It should be complaint 2025-1890. So with that correction, during the years 2023, 2024, and 2025, the respondent entered into cooperative brokerage agreements for 7 different Colorado properties. The co-broker agreements were with out-of-state brokers who were not licensed in Colorado. The respondent did not enter into a listing agreement with the seller on any of these properties. The respondent failed to maintain a transaction file on any of the properties. The respondent stated he had been paid on 2 of the properties and provided the dollar amounts as $678 and $694.68. The respondent admitted that he did not perform any brokerage duties for the sellers of these properties and never had a conversation with the sellers of these properties. Possible violations include 1210-217-1K, 1210-217-1M, 1210-217-1Q, Rules 6.20, 6.1, 6.2, 6.10, 6.14C, and noted below 7.1A. Disciplinary recommendation is a final agency order, public censure, and a fine of $7,000. And Investigator Coates is here to answer any questions you have.
Thank you. Commissioners, do you have any questions or comments?
I'm a little confused on this one. Who are the out-of-state brokers?
They are 3 brokers from Texas, and I'm not sure what additional information you would like about them. They are licensed in Texas, and they all work for the same brokerage in Texas, but they are not licensed in Colorado.
Did they have an agreement with the seller?
Excuse me?
Did these Texas brokers have a relationship with the owners of the property?
That is the information that I got. Yes, that they had the relationship.
Okay. So they were bringing this guy in to be like their Colorado broker who could legally transact the deal. Is that right?
Yes. Yes. And sometimes that's called broker of record or co-brokering, but they wanted
But he never got a
Colorado
listing agreement.
brokers. Excuse me?
But he never got any sort of listing agreement signed, it
Correct.
sounds like. Okay. Got it.
Robin, isn't it true that the Texas folks didn't have a listing agreement either?
We could never determine that exactly for sure because they did not respond to my request for their documents. Is that noted in the report that they did not, or in one of the recorded interviews that you recall?
I thought it was in one of the reports.
That I had stated that even the Texas brokers didn't have a listing agreement?
Yeah, because I feel like when I looked at this, I had a question to myself that said, can we ask because I did see that they didn't respond, and so I wondered if we can ask Texas to look at them and what their dealings are out there. I don't know if that's even possible since they're like, oh well, Colorado, we just did this deal, it falls on this guy. And it was, I think he only did 1 or 2 deals with those guys. I can't remember, but I felt like I wanting to know if Texas can look into them.
There were 7.
There were 7.
But with the same group, wasn't it different people?
It was the same group. He had seven different transactions. And as far as the question related to whether Texas had the listing agreement or not, my focus was on the Colorado respondent, the Colorado licensee, and I was not investigating the Texas brokers, but only to the extent of how it related to potential violations of this respondent and Colorado license law.
And I will say the one area where that would be relevant is because technically they were the ones practicing real estate in Colorado.
Uh-huh.
So that, you know,
That's
but
what I thought too about asking Texas, but because he didn't really, it's almost like he lent his license out for them just to do the deal. He didn't have anything to do with it. He just said, "Here, you can use my name."
yeah.
Well,
And
This is a rise
in
in
the
this. There's a lot of this.
in the interviews, you will hear that wasn't his explanation. His explanation is that he wanted to learn more about commercial real estate and get into that aspect of the industry. There are respondents out there that will admit or say that it was just to lend out the license for a fee. But in this case, the interviews that I had with the respondent, his response was that he was doing this to learn more about commercial real estate. But yet he didn't do any brokerage
he
duties
didn't do anything with
related to commercial real estate.
Yeah.
Yeah, we're seeing this a lot more. And you know, those relationships are legal if you take lead and you do what you handle your file the way you're supposed to. You can broker with another broker, but you can't do it if you don't take care of any of the responsibilities as the lead broker,
They're
you know.
just using his license.
They're literally, that's exactly what's happening.
Yeah.
But we are seeing that happen a lot more. I've seen it since I've been on here. It's a lot. It's coming up a lot. So that being said, do we have anyone that would like to make a motion?
Well, the fine seems pretty hefty to me.
I don't think it's hefty because there were 7.
Yeah.
He's done it 7 times,
Yeah.
So it's kind of like one ding for everything.
Yeah. I mean, I guess he needs to learn a lesson. They weren't paying him a lot. I could tell you
No,
that.
it's not worth it. That's the other thing.
No.
When you see these, they're never worth it. And if
Yeah.
you really want to learn, then get the agreement in your, with the seller
Yeah.
and you do all the things. And unfortunately, in most of these cases, the Colorado broker, they're all set up like this. They don't end up doing their due diligence and having their files in order. So,
And the other ones end up just kind of practicing out here is what it seems like, and without a license.
Yeah.
So,
this might be something to put into just a sidebar to put into an update.
I was
We've
just
seen
thinking
this a lot.
that
You're
it would
thinking
be
that too?
really good. Yeah.
Yeah,
Because
we're
the
starting to see this.
quantity of these that we're seeing, and the examples that are out there, I feel like people are thinking that this is an okay thing to do. So, yeah.
Yep. Okay. Well, can we get a motion, please? Someone?
Motion to approve staff recommendation.
Do we have a second?
I'll second that.
Any further discussion? All those in favor say aye.
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 Any opposed say nay. Motion passes. Woo! We're almost done, y'all. I think this is a record. Oh my gosh, is it almost 6 o'clock?
It is.
Yes.
Insane. This is definitely a record. This is the longest meeting I've been a part of. Okay.
Shall I move on to licensing?
Let's go ahead and move on to licensing matters, please.
Licensing matter A is complaint number 2026-1062. On January 3rd of 2006, the applicant was charged with a criminal offense in Fremont County, Colorado. The applicant subsequently pled guilty to domestic violence and assault. The charges and guilty pleas were not reported to the Colorado Real Estate Commission at the time. As a result, a complaint was opened on May 23rd of 2007. The applicant did not respond to the complaint. On June 13th of 2007, the Colorado Real Estate Commission elected to revoke the applicant's license. There was no response by the applicant after several notifications of the commission's decision. On December 1st, 2009, a final agency order permanently revoked the applicant's Colorado real estate license. The criminal case in Fremont County, Colorado was closed on January 12th of 2007. The respondent applied for an employee level broker license in January of 2026 and was denied in the April of 2026 meeting due to the fact that the rules had changed since his revocation and he would not be eligible for an employee broker level license. In June of 2026, the respondent changed his application to seek an associate level broker's license. We do not have a recommendation, and Investigator Coates is here to answer any questions you have.
Thank you. Any questions, commissioners?
Well, I remember this coming up previously, and the data was incomplete. We were missing quite a bit of history. So I do believe that he's addressed some of what we were needing, like the lack of employment was because he was on disability. He does have a more recent letter from an employing broker who will supervise him. His client letters, again, they were undated, but they were positive in nature, supporting that he did a good job when he was previously in that. And the application that was for an employing level broker was something that we couldn't do. And he addressed that too, that his full intent was to work at the independent, not at an independent level license, so that he wants to learn. So he is aware that he needs a managing broker. It's going to come in for a couple of years. So I would be okay with it in this, with this application.
Okay. And do we have any other comments?
I have no, I would approve.
Okay. So do you want to make a motion to, remember this is an application, so motion to approve the application?
Motion to approve application for licensure.
Second?
No, second.
Okay. And any further discussion? If none, all those in favor say aye.
Aye.
All those opposed say nay. And motion to approve the application passes.
Okay, licensing matter B is complaint 2026-789. In 2013, the applicant was disciplined by the Illinois Department of Financial and Professional Regulation. The discipline was the result of supervising unlicensed personnel, broker supervision, and not registering satellite offices. The consent order stated the applicant was allowing unlicensed employees to sign rental agreements and accept rental payments. The applicant was fined $5,000. The applicant is licensed in both Illinois and Indiana. There have been no further violations reported by any jurisdiction since 2013. The applicant provided an employing broker affidavit and has taken the required education. We do not have a recommendation, and Investigator Levy is unable to be with us right now, and so I will try and answer any questions you have.
Thank you. Commissioners, you have questions? I know I had a couple. First question, his license was not suspended in Illinois. It was just disciplined, right? It wasn't like revoked or suspended or anything.
That's my understanding, yes.
Okay. And then do we know if he's currently an employing broker?
I don't know that, actually. Let's see.
Okay. And while you're looking that up, I'm pretty sure I need to go back in the file, but I'm pretty sure this is the one where the employing broker worksheet wasn't completed all the way. And so I really wouldn't have a problem with this person having a license and maybe even employing broker level license, but it doesn't look like it doesn't look like it was provided, like all the details were provided. So let me go back to I gotta go all the way back. Does anyone else remember that on this file?
No, I don't.
Let's see, let me make sure this is the right one. Employing broker experience affidavit. So on his affidavit, it's incomplete. He put numbers of years that he's practiced as an employing broker in Colorado. It says, okay, it says on here, I just want to verify it, but it says on here, licensed as managing broker since 2012. And then it says number of CE taken in my area of expertise on or after January 1st, 2018, 1 point per hour, may not exceed 20. So he put 20 there. So now we have 23 if we add this, but then on total, he just put 50. So it probably was a misunderstanding. He didn't answer the other questions, such as number of residential transactions closed, number of commercial transactions closed, number of vacant land sales closed, number of property management transactions, number, so there's other questions that are part of this whole calculation that he didn't fill out. And I, again, was just kind of unclear on if he was a managing broker or not. And then I had a question because I really don't know that I know this. If he is a managing broker, does that automatically transfer to a new jurisdiction, particularly Colorado? Or would we require this affidavit to be complete? So whoever can answer that question.
I'm looking on their website. He is a managing broker according to their website in Illinois.
Okay.
And in Indiana, he's a real estate broker. I know in some states they like call the levels of licensure different things than we call them. So to be honest, I don't know. I don't know if Penny can help us with that or.
Yeah, because what we just need to figure out, do we need this employing broker experience affidavit in order to grant him a managing broker license? If we do, then I would take it back to him to complete that, because right now it's incomplete.
Yeah, so you guys wouldn't get that deep into the woods about it. That would be our licensing department who reviews that and makes sure that he meets all of the qualifications. So really, I think it would just be if you approve him to be employing broker, great. And, we'll make sure that he fulfills the qualifications.
Okay. And that was kind of where there was a little pause, because we don't have the information if he's able to be an employing broker. So what you're saying is we approve it as an employing broker, even though we don't know, and then you guys will do your due diligence and determine if he can be an employing broker. And then if he can't, then you'll advise him on what to, like, I guess, because on the last one, he applied for employing broker level license and he didn't have any documentation to support that, which is why we sent it back to him to redo the application. But you're saying we don't need to do that with this one?
I'm not sure I fully understand, but so I understand that he applied previously. And
no, this is a different one.
This is a different one?
This is his first time applying.
Oh.
And he's applying for an employing broker level license. And before we approve that, I'm just stating that he didn't complete the employing broker affidavit. It's not complete. So we don't have information to determine if he is qualified to be an employing broker, and that is what they're asking us to approve, an employing broker level license.
Right. So when we send these to you, we're sending this one to you specifically because he's had, previous discipline in another state. You've approved employing brokers in the past, and it's our licensing department's job to have him provide them all the information. There's a points system, which I'm not sure applies on the transfer, but what you would be approving is the license that he's applied for. And so I wouldn't get into the weeds on does he qualify or anything like that. We're going to make sure of that. But it's just whether you're going to approve him for the license he's applied for with the discipline in another state that we've presented to you.
Okay. Thank you.
Okay. Was he previously licensed in Colorado as just an associate broker, or no? Is he going straight trying to be a managing broker?
Straight to managing broker out here.
Okay. Yeah, because I see here he did complete coursework for it.
Well, I guess we can motion to approve the application. Sorry, I'm just reading through this. I don't know. I mean, because it's referencing this affidavit, but
I understand what you're saying too, Erica. So I guess my question is going to be, can we approve him just for licensure and then he gets all of his ducks in a row and then submits the application for a higher license, or is that not an option for us? Is it this or none?
or even like approve with the restriction that he provides whatever he needs for that level of license.
Sure, you can do that. Yeah, just say he needs to meet the qualifications for that license.
Yeah, because I don't think we have a problem with him having a license, but what came over to us is a license for a managing broker. You know what I mean? So I feel like and it's noted in the summary, and it's noted that he provided this stuff, even though it's not completed. So I just want to make sure that that gets addressed. But so I can make a motion to approve with restriction the application for licensor. The only restriction is if he is going to apply for the employing broker license, that he provides the required documentation.
I second that.
Okay.
Okay. And any discussion?
Nope.
All those in favor say aye.
Aye.
Okay. Any opposed? Say nay. Okay, that motion passed.
Okay, licensing matter C is an application. It's 2026-1088. On May 9th of 2024, the applicant was convicted of an assault 3, no reckless cause injury, a class 1 misdemeanor. The applicant was sentenced to 2 years probation and a fine of $1,793.10. The applicant has completed all terms of the probation and has paid the fine in full. The case is closed. The applicant came before the Colorado Real Estate Commission for a preliminary advisory opinion in February of 2025. At that time, the commission gave a negative opinion. We do not have a recommendation, and Investigator Quintana is not available, and I will do my best to answer any questions you have.
Thank you. Any questions? I think the only reason we gave a negative opinion is, if I recall, this one wasn't through probation or something like that. But I am open to make a motion to approve the application for licensure.
And second.
Any discussion?
Do we know if that's the reason why we gave the negative opinion? Because I had that as my notes as to
figure out why.
I reviewed that the transcript from that meeting, the February 2025 meeting, and it did sound like you all had a discussion about whether or not she could prove like rehabilitation, and had encouraged the applicant to apply again after the probation had passed and she had successfully completed it.
Okay, thank you.
I had a note that I would approve this.
I'm just looking real quick at her probation. I think that was it. I believe it was a probation. She was still, because her term was 2 years.
It says it's completed.
And yeah, it's now completed. And I don't think it was before. So I think that was the big issue then.
Yeah, I believe she completed probation in May of this year.
Okay. I think I made a motion.
You did. So
and we had the second, right? And we had the discussion. So
yep.
I'm going to call the question. All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion passes.
Okay, licensing matter D is an application. The complaint number is 2026-907. On March 30th of 2004, the applicant was convicted of a controlled substance attained by fraud, deceit, a class 5 felony amended to a class 4 felony. The applicant was sentenced to 3 years probation. Probation was revoked and resentenced to 3 years probation, 10 days in jail, with a fine of $2,627.50. This case was concurrent with 2004 CR 756. The case is closed. On June 10th of 2004, the applicant was convicted of a class 5 felony, accessory to a crime. The applicant was sentenced to 3 years probation. Probation was revoked and resentenced to 3 years probation, 56 days in jail with 26 days credit for time served, 10 days jail suspended, and a fine of $422.50. This case was concurrent with 2003 CR 2226, and the case is closed. We do not have a recommendation. And again, Investigator Quintana is unavailable. And so I'm happy to try and answer any questions you have.
Thank you. Any questions, commissioners?
So my only concern, this has been, I mean, it's over 20 years old. Served the jail sentence, balance was paid, letter from future managing broker, letters of reference. My main concern was that there were 2 incidences. First one involving fraud and deceit, and the other theft, a wide array of items. And then both of those are applicable to our industry on a daily basis. You know, you're put in a position where you've got to be very honest, and you have the opportunity. I just, those are my main concerns with this particular one. It's applicability to our industry.
Right. Yeah, I noticed that. I just thought based on the recommendation letters and the personal statement that they, you know, this happened, gosh, what, 19 years ago, I think it was. And so this individual seems to be rehabilitated and they haven't gotten in any trouble. They mentioned like getting married and just really like kind of having a new outlook on life, having kids and just really maturing from that point. And they know the managing broker because they did business with them, because I think they have a sign company or something like that.
Yeah.
They did business with them, and you know, and I think it was a little hard for them to even have that discussion about her past, but she did, and you know, I it doesn't seem like she's the person she was, you know, almost 20 years ago. So I would
I
say
can appreciate that. I just wanted to touch on those items that did raise some concern.
for sure. Yeah, I get it too. But for that reason, I recommend an approval on the application.
My note to myself also says that I'd approve this. 20 years, it's been close to 20 years for, you know, since, and no other incidences, no other history, and, you know, a business owner, you know, life has completely changed. So I would also approve licensure.
Okay. Do you want to make a motion?
Motion to approve for licensure.
The application.
Application for licensure, yes.
Okay. And do we have a second?
Second.
All right. Any more discussion?
Nope.
Let's call the question. All those in favor say aye.
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 Any opposed say nay. Motion passes. And we do not have any expedited settlement matters. We don't have any attorney general matters.
There was one more complaint that was
they removed it.
Oh, is that? Okay.
Yeah, they removed it.
Okay,
Yeah.
Good.
But we don't have any executive session topics. And so motion to adjourn.
Oh my goodness.
All right.
Did
A
it in
record day. Oh my gosh.
at 6:13. Holy cow.
Well, at 6:13, motion to adjourn. I don't know if we need a second. I don't know if we really need a motion, but
I'll
So I'll
second that.
second it just in case. We want to
Second
official.
it too.
yes. All right. Well, I think we're good to go, and we will see you in a couple months.
All
All
right.
right.
Thank
Here, everybody.
you.
Thank you.
Sweet.
Bye.
Thanks, everybody.
All right.
Thank
Yep.
Bye.
Everybody have a good